Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning, everybody. Hi, I'm Linda Kenney Baden. As you know, sorry, we are running a little late today. I apologize, a little technical difficulties after that dynamic show we had with all of you watching yesterday. Our interview with Michael Easter has created a little bit of a kerfluffle on X, Twitter, social media. We even got a shout out last night from Dr. Turtleboy Aiden Carney about it, to say he has to go watch it because it's awesome that we had him on, and it's awesome that Mike Easter came on with us for that exclusive. That exclusive is still up in the Justice Serve TV YouTube site, and you can go watch it. We did post a very short 20-some second clip that kind of summed up what it was all about. An investigation where Karen Reed, according to him, should never have been charged because it was inconsistent at the very least, right? It was incomplete. Remember what he said that, and he went to the I words, and seriously flawed, although he didn't use the F word. That is my word. So thank you all. I don't even see a fan. I see the courtroom, but I do not see a fan of injustice. I think we may be going into the courtroom. Let's listen. Let's listen. Yes, we are. Talk about being right on time, Justice Serve TV members. I don't know what she's looking. Here we go.
All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anybody since we met yesterday? Everyone said yes or nodded affirmatively. Was everyone able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no. So, Mr. Foreman, with that, we're going to send you back out to deliberate.
All right, so court, please.
Jimmy?
Follow me.
As I told you, it is always good if you are counsel, because you want to see that jury in the morning. Some judges do not. And what is happening there in the courtroom? I think the camera is just on Karen Reed right now. And the judge said, "Good morning, counsel." Good morning, Miss Reed. All right, so we're seeing some type of shot. And let's go into court. Let's listen for a second. Let's listen. I don't have any sound from the courtroom. The judge has muted. There we go.
They held me downstairs, Your Honor. I think the jury was being...
Till we make 4. I've been sending a note in at 4 o'clock, so I would like counsel here at 4 o'clock. All right, so if you just plan on being here at 4 o'clock, it would make it easier in case the jurors want to go home. So, all right, Ms. Giannetti, it wasn't until I was here that I noticed you were not in the courtroom.
They held me downstairs, Your Honor. I think the jury was being brought in, so...
Okay. No one told us otherwise either. So.
Understood.
All right, thank you.
All right. What's the recess to exit court?
Oh, well, there was apparently a little bit of a snotty atmosphere there in the courtroom. The judge says, "I'm going to send a note in at 4 o'clock to see if the jury wants to go home." I guess that's why yesterday there was such a quick notice to the jury. Oasis Cat said, "Pursue, I would say, based on the multi-week observation, that they're each dressed a level or 2 up from their usual attire." All right, that's usually a clue that they think they're going to be seen, or maybe they're understanding they're also going to be seen when they're being sent out and sent home. too. And so that all eyes will be on them at that point. They know that all eyes are on them. So we will see. Usually that's an indication that they either have something for the judge, whether it be a question or some type of verdict or a hung or something. When the jurors start dressing up a level or two, very interesting, because apparently she's saying that they all are each dressed up a level or two from the usual attire. That's kind of important. We'll see what it means, if anything. But clearly, the judge this morning, first of all, she said, "Good morning, counsel. Good morning, Miss Reed." And of course, Karen Reed had to respond back. I don't remember her doing that in front of the jury every day. We'll have to go back and check on that, and maybe you can all help me on that. And the other thing, we have a little bit of a snark. She said, "I'm going to be sending a note in at 4 o'clock, and I'd appreciate you were here." And she said, "Mr. Yannetti, no one told me you were here." She said, I was right downstairs waiting to come up, And so apparently this is they're not supposed to do anything without Yannetti in the courtroom, by the way, without Mr. Yannetti in the courtroom. So we should go back and take a look at yesterday when she dismissed the jury. I'll try to find it on X, just take a quick gander at it, whether Yannetti was there, because other counsel who are pro hoc vice under law are required to have local counsel, and that's Mr. Yannetti, in the courtroom. That's why the one day that Mr. Yannetti had to leave, that's when Victoria came in and she substituted in for him as a counsel, lead counsel on that day. And then she had to pro hoc vice everybody else in, because they are pro hoc vice under David Yannetti's name. All right. So it's just a fluke of practice. Once you're pro hoc vice in, the judge should really allow you to stay, even if your pro hoc is not in the courtroom at that moment and is downstairs, for Christ's sake. Excuse me. I mean, really, but she was a little bit perturbed. So I guess she's going to, at every day, if they don't have a verdict, ask them if they want to continue, instead of letting them leave them and then going, because initially, remember, she was going to let them deliberate to 5 or 5:30. I guess she's not, if they're pushed a little bit and saying, "Well, do you want to go home?" Well, who doesn't want to go home? So I guess she's going to let them go home at 4 every single day. That would have been nice to know. And I think counsel was told, "Look, we're 10 minutes away." When we last heard, she told counsel would be 10 minutes away, and or 5 minutes initially at first. And then she said, "Well, Mr. Yannetti said, your judge, my office is 10 minutes away. Could we have that?" And she said, "Yes, 10 minutes away." And so we saw the O'Keefes coming in. They didn't go into the courtroom yesterday. Michael Bryant was there when they came. They apparently went to the DA's office, the Commonwealth's prosecutor's office. And then the defense team came, and everyone was in court when she allowed the jury to go home. Now, as I said, sometimes judges do not bring the jury in, or at the end of the day, or in the beginning of the morning. They just send them to the jury room. They take the roll call downstairs and send them to the jury room. But she's doing it the way actually attorneys like it to be done, so you could get a look, as we did, or as we didn't, but as people in the courtroom do, of the jury. And that's what's so kind of ridiculous. Everybody in the courtroom can get a look at that jury, but you can't if you're watching on a feed like we're watching. It's improper to show the jury. So let me just acknowledge a few things. Sharon Logue, a new member, okay? Thank you very much. Donnie Wahlberg, new member. Thank you very much. And Sky Stars Page, member for 1 month. It's been a glorious month with you all. Well, it's been glorious to have you on to Sky Stars Page. As you know, it's a great community here that we have built at Justice Serve TV. Just a great community, right? Great community. So that is just wonderful. And then we have one other comment from Sky Stars Page. Are judges in general now more rude to the defense? No, judges a lot of times can be rude to the defense, but usually they don't do it in front of the jury. And I think I've told you all, if you haven't been here, when I had the story about when we were trying the Aaron Hernandez case, and the judge was very rude and dismissive to Jose Baez. It was Jose, Ron Sullivan, and I, who were at the table with, and we each had a third of the case, and just extremely rude to Jose. And we went at him, and Jose went at him after the jury left, that Your Honor could be rude to me, but never in front of the jury. Never in front of the jury, especially with my client present. That sends a message to the jury about what you think of the defense and all. So she didn't do it with the jury present. She did it without the jury. But the problem is we are all looking at this, right? We're all watching this. And we have seen from the time she said she had grave concerns that she has been at the defense and very, 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 very rude to the defense. Okay. And the only time we saw her back down a little bit was when Alan Jackson, in the last 2 days of the trial that had testimony, went at her and said, Your Honor, to use a phrase, I have grave concerns about what's been going on here. So he went at her a little bit, I think backed her down for just a moment. It may have been that day, but she's back at it, and we saw it. We saw the rudeness, and I'm sorry, Judge Kenney, but you have been rude, all right? And it's been noticeable to everybody that you have been rude to the defense and dismissive of the defense and nasty to the defense, all right? Absolutely. And when you did the verdict sheet, and Mr. Yannetti had to say, Your Honor, do we have a verdict slip? That's what they call it in Massachusetts. She said, yeah, here. And then everyone had a huddle about afterwards when this should have been given to the defense beforehand. And it's the same garbage verdict slip that caused the problems in the first trial. I guess she figures that if it stays as the way it is, it's easier for the jury to find Karen Reed guilty of something under the second count. That's my feeling about this, because she said, no, with the jury instructions, this verdict slip is very clear. Your Honor, no, with the jury instructions, this verdict slip is not very clear. But then she said something to the Yannetti as they asked her something as simple as, could we have the jury decide guilty or not guilty on each count, right? And there you go. And normally it will say, look, find Karen Reed guilty, not guilty. If you find her not guilty of this count, you move to the next question. If and it keeps the verdict slip itself in most jurisdictions will give the instructions, and it can be as 2 or 3 pages. This, I guess, got crammed on 1 page, and I'm telling you, I can't make heads or tails of it. I would be very confused with it, and it sends a subliminal message to the jury of 1, 2, 3, 4 guilties and 1 chance to check not guilty. So it almost suggests that you have to find Karen Reed guilty on one of these 4 lesser included offenses, right? Under the manslaughter while operating a motor vehicle under the influence of liquor. I mean, that's the message this sends. The defense, as you all know, wanted to do something very simple. Just have a guilty and a not guilty, exhibit LLL, which was then put into more of a chart-like form that they resubmitted, not guilty, guilty. And of course, there's always a question that attorneys have of when you have the not guilty and guilty, what should come first? As defense attorneys, we think the not guilty should come first. Prosecutors want the jury to see guilty first. And some judges will listen to the defense. Others will just say, no, we're going to have guilty first. That's the way, and that itself is wrong. I'm sure if we did a whole psychological analysis of jury slip forms and how they should be not have no indication of bias in them and deal with the Constitution first, not guilty should have been first. Excuse me. Let me grab a sip of a mango, as you know, my Dunkin' mango tea. All right, so I just wanted to go over that with you. We're still at that time. Now, the jury yesterday, just to recap, didn't have any questions. They were, as we say, radio silence. What does that mean? Well, it means they were working very hard, right? But does it mean there's unanimity in that jury verdict already because they don't have any questions and they're very silent, right? Is that what it means? And if it means there's unanimity, is that good for Karen Reed or bad for Karen Reed? I certainly like if we go to the morning without any hint message from the jury, whether it be a knock knock or we have a question or a knock knock before we have a verdict. I'd like to try to bring our jury consultant back in, but we can't keep people on call for all day who gave us blessedly their time the other day. And Richard Gabriel told you all poo-pooed this. He told you on Friday afternoon that the jury would not have a verdict. You'd see something Tuesday or Wednesday. Okay, so Tuesday or Wednesday. I had said that you're going to have a question probably by our time at 11 a.m. this morning, or something from them at 11 a.m. this morning. I can't imagine there being unanimity on a guilty for murder, right? That's for sure. I can't imagine there'd be a unanimity on charge 3. That's for sure. Hold on one second, excuse me. Now, the other ones, they're so confusing. They didn't take Karen Reed's blood alcohol level to like the next day. And there were certain problems with it because she has certain diseases, right, that affect blood serum levels and alcohol and the rate of elimination. And they only had one test, so you don't know whether she was going down or going up. And they did a serum test, and right on the lab test, it says on that lab test from the hospital, it's not to be used in courtroom proceedings. It's not to be used for litigation, right on that lab test. And yet it was. The prosecution came in and did something called retrograde extrapolation to say, well, if her blood alcohol was at this, most people eliminate at this rate. But some people don't, but most were taking an average of the generic population. And therefore, at the time of the accident, which the prosecution says was a collision, at 12, initially, well, it's changed, shall we say. It's changed. Initially, it would talk about 12:32:16. She had a blood alcohol level of X, but that was unreliable. That's why they needed to go back to counting the drinks, that Yuri Buchanan was counting drinks that she was having at the waterfall. And that's why the defense then put in people to say she was driving fine, she talked fine, she didn't slur her words, she was acting fine, and therefore she wasn't under the influence of alcohol. All right, so that's where we were with that, because that charge of being under the influence of alcohol, which is the main count of the manslaughter of count 2, then has 3 lesser included. So basically there's 4 guilty or not guilties that the jury has to go through. And the final one is just operating under the influence of liquor. That wasn't in the original verdict sheet when we had spoken to Jill Zarin the other day, but then the defense asked for it to be put in. And that would be a simple OUI, right? It would be a simple OUI, right? That would be operating the influence, or they have in here operating with a blood alcohol level of 0.08 or greater. Now, Massachusetts, and I'm going to try to get somebody who's an expert in OUI law on, Massachusetts has some of the severest punishments for OUI. I think the judge has discretion from no jail time to up to 2.5 years of jail time, if I read things correctly on the internet. And of course, I never like to just go by the internet, but it does have a severe penalty of possible jail time. But I think the defense then decided that they wanted to give the jury a way that they could possibly, if they were going to decide that Karen Reed was guilty of anything, they had something that they could decide on or compromise on, rather than charges dealing with impact or of a collision. Now, you need that one juror to be in that jury room and say, ladies and gentlemen, my fellow jurors, when things get rough, if they have disagreement, our job is not to decide what happened. Because despite the fact that the prosecutor said in his summation, we don't know what happened, we have a good idea, but we don't know what happened, that should have been not guilty right there. The judge, once the Commonwealth admits that, that really should have been a not guilty, all right? That absolutely should have been a not guilty. But what happened was the judge obviously wasn't going to do that. So let's look at the start question we have from Sandra. Sandra, thank you for that donation. We appreciate it. Good morning. Love your show. I know Karen will be acquitted, but in the off chance it's a mistrial, can the defense reuse all the materials to lessen expense? You mean in terms of the transcripts? Well, first of all, their expense would be great again, because they'd have to get the transcripts from this trial. All right. They can't then just read the transcripts from the last trial that's to the jury. That won't happen. And they would have to call witnesses and pay expert fees again. So the expense would be just as great. And then the question would remain, okay, what happens with the attorneys? They've already spent basically 2 years of their time on this case. And at some point, people have to run law offices. And so that's why a lot of times when you get to a third trial, trial teams tend to change. Usually the second trial, they'll say the same, but then the third trial, they tend to change. So there's a lot on the line for getting a verdict of not guilty for Karen Read, for herself and for her expenses and all. Madeira Beach caregiver. Hello, Madeira Beach. What's the point of notes if not allowed to review and deliberating? They're allowed to review the notes and deliberating. They're definitely allowed to do that. That's the the foreperson was being ragged upon on the internet for not taking notes, but I'm telling you, that should not be a worry, okay? Because I have found that jurors decide among them sometimes after the first day, when they say this is, they're listening, and then they say they can take notes. After the first day, jurors sometimes will assign, not realizing who's going to be an alternate or not. And sometimes in cases where they know the jurors, definitely, they'll assign each people, or the people will volunteer. Okay, I'll take notes on this witness. You take notes on that witness. We all can take notes on something that really just jumps out at us, so that you won't see jurors writing, on every witness. And that's because they decided, that's not talking about the case. That's talking about how they're going to deal with notes, right? And so they've decided that. So I have seeing that. Madeira Beach caregiver, they had to keep the notes on their chairs when they left last night. But when they go into the jury room today, they take their notes with them. All right. And of course, the notes then are collected after they're left on the chairs, and they're kept in a secret place, locked up by the jury person, but now who is supposed to keep them from being contaminated by anyone. But of course, we defense attorneys, we never trust that. We always wonder whether or not somebody looks through the notes. I would certainly love to see, those when you have notebooks at the end of the day, those little things that they put on the crime scene, little stickers, to close that notebook to make sure nobody goes into it. But you never know, okay? And there have been several cases where, like in Kyle Rittenhouse, one of the jurors during the deliberation wanted to take a notebook home. And the judge said yes. And normally that's never done, right? That's never done. Could you take the notebook home? Camera, to keep your notes, and then you hold on to them. Don't tell anybody, just in case there's an issue. Because at the end of the trial, the notebooks are collected, and supposedly they're then destroyed, and no one's supposed to look at them, and the jurors cannot take them home. Just something passing me by, and I see, thank you very much. And by the way, we do have a testimony. I'm waiting for Michael Bryant to get back. He was at the courthouse this morning, as they do their, as they come in and as they leave. He wants to see how everybody looks, and trying to get some interviews with the supporters. Yesterday was a huge day out there. There had to be 500 or 600 people in the First Amendment zone. And as I said, that was created by Jason Grant and Michael Bryant, Tommy CPU, Mr. Delgado, whose case has a different case than Erica Walsh, but mostly initially started by Jason Grant, 3 plaintiffs, and Michael Bryant and Tommy CPU, who said that zone, that buffer zone, was illegally made, and if it wasn't illegally made, it was being illegally enforced as to the First Amendment. And then when they kind of won that, the state police used it as a way to make it worse in some way. So Mark Randazzo, their attorney from the Liberty Center, who funded the litigation, went back to federal court and said, Judge, if you're not going to undo the buffer zone, you have to undo how they're enforcing it. And that's exactly what happened. The buffer zone stayed, but how they were enforcing it was different. That everybody who wanted to come in could come in, as long as they had their First Amendment shirt didn't say Free Karen Read. It didn't comment on Karen Read. It could comment on Norfolk County being criminals, like Erica Walsh's sweatshirt from Michael Thoughts did. It could say, the whole government system in the United States is terrible. It could say anything. It could have a political message on it, as long as it didn't apply to Karen Read. And so you saw yesterday people were in pink shirts. Things were like covered in blue paint, I guess, as a riff on the Commonwealth's case, or covering up anything that said Free Karen Read on it. So, and you saw how huge it was. And then right beyond the buffer zone, people were parked with cars with big signs, because if beyond the buffer zone, you could have anything there. But the interesting thing is that there were so many people that it spilled out all the way through the buffer zone, that 200 feet, and right to where the buffer zone ended, and then beyond the buffer zone. There were just so many people there, and people on the courthouse steps, and even people allowed to harass, in my opinion, Aiden Carney, who was on the courthouse steps actually doing his show, okay? Actually doing his show. All right, so, wow. Let's see. Michael Bryant has just texted me. He is not set up yet. So what I would like to do, I think, is one of the things as we wait for this jury, and let me see if there's any more. Meg, a new member. Yes, yes, yes. Welcome, a new member, Meg. Welcome, welcome, welcome. Hello, Linda. Let's go to a very good question from HJH. And I'm sorry, I have eye drops in my eyes, and I stupidly put them in just before I came on the air. And as you know, it takes a while for them to dissipate. Well, Linda, what is the most that someone has been tried? I believe it was 5 times. And then the Supreme Court then stepped in and, said that's enough, 5 times, because the question is, how many times constitutes cruel and unusual punishment under the United States Constitution? So we see people retried 3 times all the time. Now, I don't know if there is a case specific to Massachusetts. I don't know if there's a case actually specific to Massachusetts that allows a limit on trials. Any of you out there, go to the Massachusetts Supreme Court website, see if you can find a case on that, okay? But generally, there is no limit, but generally, it's usually 5 times has been the most that we've seen somebody tried. And that's a famous case down south, went on for like 20 years with different trials, because there was the verdicts, and then there was things that were was resent back, and then there was a trial, and then there was hung juries, and all. So if they want to get you, being a defendant just bankrupts you and all. Now, losing one's life, we're not saying that it's insignificant that John O'Keefe here is dead, but we're just saying that it's up to the prosecutor to prove it. And if you don't have the evidence to prove it, how many times do you go after somebody if there's a second hung in this jury? We don't know. We don't know what there's going to be on this jury. So we shall see. I can tell you, though, that the defense, if there is a hung jury, will have issues. They're going to try to go back and say she shouldn't be retried. This was misconduct on the part of the prosecutor, that mistrial should be granted. They will try to do that, and that's going to take some time. So we'll see. Let's see what happens. We're getting ahead of ourselves, because we have no word from the jury yet about what they are thinking. They have been, as I said, radio silent, indicating that there is no disagreement in front of them right now. Until they tell us there is, that silence is pretty severe. And then the other thing I would say to you, having tried Hernandez up there, we had a jury that was radio silent for 2 days too. And what happened, we learned that on one day, the jury was actually going through all the charges. I think when they were rereading the charges because they didn't understand them. And that took like a whole day, right? And then the next day, they were like looking at, all of the evidence, and that took a day, and they really didn't start deliberating. And so the radio silence meant nothing, because they were trying to get their feet on the ground as to how they were going to about doing what their job was to do. And then by the 4th day, and we did have a verdict on the Thursday before Easter, because I remember rushing to the train to try to get home for the Easter weekend at 5 o'clock, getting the last train out on that time. So you never know if they don't have, if they are radio silent, Is that because they're discussing and are in agreement, or is it because they're trying to get their feet on the ground as to where they're going? Or have they discussed and they do have their feet on the ground, and they're going through, they do get radio silent when they go through the verdict slip, okay, for a while. That is radio silence, because that takes a long time. All right, so let's see, question, Jacqueline Jace, is there any requirements that the jury must do while deliberating, or do they decide how this process works? So you're the best. Thank you very much. They decide themselves how this process works. Richard Gabriel was very interesting. If you go back and listen to him for our Friday night show, he's the major jury consultant. By the way, he had a major win doing a pro bono case on behalf of workers who are promised money and come here to pick crops and then end up in servitude instead, because the promises are unkept and people aren't being paid. So he had a major win picking that jury on a pro bono case. He announced it on his social media yesterday, and Richard has picked some of the major juries and major cases, and he's my jury consultant when I go to jury consultant with him. Okay, and so you know that he's really good. And he says that jurors, look, there's two types of jurors that are just process-oriented, jurors that are result-oriented. If you have result-oriented, they go in and they want to take a straw vote, but here the judge told them they couldn't, right? They're not. I highly recommend against it, is what she said to them, you know. She basically discouraged them. So some jurors that are result-oriented go in to see where people feel. But even if you can't take a straw vote, it depends on what the foreperson wants. The foreperson may have sat everybody around the table and said, okay, you know, speak your piece. What do you feel? What do you feel? What do you feel? Because remember, everyone has been sitting there not talking for all those, you know, the better part of 2 months, right? The way this case is played out, especially since they were in jury selection, and some of them had to wait for 3 weeks before the trial got started and couldn't really talk about the case. Excuse me. Let me grab a little bit of my tea. So, you know, so that could be one way. That's more of a result-oriented jury. And then there's a process-oriented jury that wants to find for themselves. And Richard Gabriel said many juries do that. They go in and they have their own scenario. What could have happened? What might have happened? You know, sometimes seek the truth, which was my theme in Spectre, which, by the way, the prosecution used in YSL. Even my slide was up there. The same thing. You have a case that you want the jurors to look underneath what's really going on. And so they do look at all the evidence, and they do come up with what could have happened, and they do come up with the process. And of course, they may have disagreements on that. And no matter what jury you have, if they are having problems or disagreements, you need that one juror, if you are a defense attorney, who's going to stand up and say, hey, everybody, our job is not to figure out what happened. Our job is to figure out whether the prosecution proved their case beyond a reasonable doubt to a moral certainty. So there is nothing for them to decide. There is no roadmap for them to decide, okay, on how they go about it. And it all depends on how the foreperson decides how they're going to go about it, maybe with input from fellow jury members, okay? Now, I don't know if any of you watched Clint Eastwood's Juror Number 2, kind of a ridiculous premise, but it had a lot of issues that it touched on about juries and how and what they want to do, and whether some of them are violating the rules and are researching for themselves, and you know, are sitting maybe you know, when they get home in their kitchen and hear family members talking in their dining room with the, you know, let me what are they saying, you know, that type of thing. So we can't assume that is the case. All of us defense attorneys and believe that juries basically do not you know, follow the rules, but I don't know. So I'm told Jason Grant is in the chat here. Jason, find yourself, because if we can find you and bring you on, I'd certainly like to have you give us your comments before I play some testimony about what's happening. So remember, for 3 months, Kimber, and I apologize, Kimberlina 15, member for 3 months. Linda, I watched the David Gate movie. Wow, the end. I have not watched that yet, so don't tell me. Don't tell me. Okay, I'll put it on my list of things to watch. Thank you for that recommendation. And again, I apologize if I'm leaning in a little bit. Anika A., Linda, so if it's a mistrial in the appellate court, Mike ran a mistrial with prejudice based on the prosecutorial misconduct. Yes, that's what the defense would want. The defense would want a mistrial, and then they would want to take they wouldn't want to take an appeal from the mistrial, but they would want us to take an appeal from the fact that the Judge Beverly Kenney would grant a mistrial without prejudice on the basis of the previous motions for mistrial, which were pretty prejudicial in my opinion. And I don't think the judge ever remedied the one regarding the holes in the shirt with Hank Brennan. That was a moment that really should go down in history. The problem is that you would need a hearing as to whether when Mr. Brennan said it was a mistake and he was mistaken, whether that was true or that was not true. Okay, whether that was true or that was not true. Okay, I see Michael Bryant's here. Again, I don't know if Jason, are you also in the chat here? We believe Jason is in the chat. Hello, Michael Bryant. Good morning, Michael Bryant. We've just
Good morning.
Apparently, the jury is dressed up a tad or two today.
Oh, we know what that is.
Every single one of them. Now, of course, they may feel they have the focus. They may feel they have the verdict, or they may just know they're going to be seen. But that's what Sue's reporting. That's not just one. That every single one of them is up a level or two in the way they have dressed for the last 2 months.
Okay. Well, we know that generally means they are, dressed for an appearance of sorts. Right. And Jason Grant was supposedly in our chat. I don't see him right now because I was going to bring him on while I was waiting for you, but we will see. We do have a guest coming on at 10 o'clock, somebody who has not been on here with us before, and who we won't tell you, but, has some insight into the various parties on this case, the various lawyers, maybe on both sides on this case. And so he is scheduled to come on. I actually wanted to kind of surprise you. You won't know his name, right? Okay.
You don't know his name.
I like surprises.
Yeah. All right. So you have to stay on with us to 10 o'clock to know. All right.
I will. I got nowhere else to go. So I'm
what's
uploading
happening
now. I've uploaded the arrivals, and I will tell you, one word just popped into my mind as I was watching it unfold. And it's a little bit at times like Groundhog Day. It's kind of but there was some somberness to the proceeding. And in the processional today just seemed, I don't know if it's fatigue, I don't know if it's concern, but just it definitely felt a little less positive, for what that's worth.
Well, that was the issue yesterday when they were leaving. People were saying that the defense was they didn't have the normal smiles.
No,
and so
I didn't remember this until I reposted it last night, which was kind of a montage of a number of different clips of the end of the day. But as Alan Jackson comes down the stairs, and the photographers are all just like, piranhas all around this hunk of meat. And he said, look, those cameras weigh a shit ton. And you guys got to, make room for us, make room for Karen, make room. And then Alessi says, and we need room on the side as well. Just very abrupt, far less congenial, approachable, stressed. You could just, it was obvious. So I get the sense that at the end of day 2, now we are in day 3 into the 10th plus hour, they're having concerns, because I think as the defense and those following and supporting the Karen Read movement make it clear that they thought this is a slam dunk. I mean, how long could it possibly take for a jury to determine she's not guilty of anything? So as the attorneys, you're in your own mind. Sometimes you're very close, too close to what's happening. And the more time that passes, the more doubts, second thoughts, You know, what did I do differently that I should have done? And, you know, human nature. And so I
Oh,
think we
oh,
saw that
absolutely.
yesterday.
Yeah, absolutely. Been there. When we
course.
did Spectre and the jury was out for the better part of, like, 2 weeks, more in terms of days, it's that you get to the point where at some point that's really good. When you hit day 4 or 5, it's really bad because that's, verdicts usually come in and they're guilty. And to get a hung, you've got to then extend it on well longer a period of time. Things have changed a little bit because of all the social media and the rush and the rush and the rush. But then when we did Hernandez, we absolutely convinced that we had not only actual innocence, but we had a lot of reasonable doubt. That jury took 4 days. Okay, so and you start doubting what you did, right? You start doubting what you did. All right, but
Sure,
you're right.
of
So
course.
Spectre was a 6-month trial. Hernandez was February through April, 2-month trial. So 8 weeks. But you say that there's so much doubt here. How could the jury not see it? How could the
I
jury
know.
not see it?
I get that. Yeah. And I had,
Or,
like I said, I have that 8 seconds from everybody resting and the jury. You have the case. I have that 8 seconds of relief, and then you start to worry. You start to wonder what could have been done differently. So I get it. I understand that. And of course, since the first jury took 27 hours to get to their hung jury position, actually they got hung before that. Then they just didn't get unhung in the time that followed. So we're certainly a distance from where we were for trial number 1, but I think most people who are now savvy as to the importance of the jury verdict slip know that second page is it's a puzzle.
it's a problem. It's a problem. It suggests to me subliminally to say guilty.
Well, yeah, because if you jump past the top, which says not guilty, it's almost as if it's like, well, keep looking, keep working at it, find something. You got all of these options. You got to find something. And that's, of course, why the defense objected to it, suggested one that seemed more logical, which is here's each lesser included: guilty, not guilty, guilty, not guilty. I mean, why is that difficult to understand? Is it arrogance on behalf of the court? Is it stupidity? I don't know what it is.
Yeah. So then, that's exactly where we are. And also we'll see what happens. And obviously, we have, I believe, Missy, we have Neil on standby. Okay, I'm going to just check with him.
Yeah, and I just update our folks. We were going to have Neil. We were going to have Imran Ansari on this afternoon. He, of course, one of the attorneys representing Harvey Weinstein. We just want to kind of get an update on what was going on there. And I just got a note from him. I don't think I'm divulging any.
No, because I think we posted that he was going to be on today.
Well, he said an emergency issue is coming up, and I have to go see Harvey. So I guess I don't know what that means, but I said, no, I'm sorry. You promised. You better be. No, I said, of course, we understand. So we'll re-engage at some point with Imran to find out what's happening there. It could be a medical issue for all we know.
Okay. All right. So Neil is stuck right now. Well, can you come on at 10:30? I'm going to ask him. So
okay.
All right, on that.
So the other thing,
we have Brad. I'll tell him. We have Brad Sohn. Brad Sohn was a co-counsel of mine, handled a lot of litigation dealing with the NFL on Aaron Hernandez, a major civil attorney, has had tried cases down in Florida, huge judgments against the government. And I want to get a different take. I want to get his take as somebody who does a lot of work with jurors about what this means. Neil can come on in a few minutes. Yes.
Is that the surprise? Did you just tell me the surprise?
Yes, I decided I would let it go. Okay, so
all right,
Missy, can we send Neil the link? And if Brad comes on with both of them, that would actually be a great panel, because we may have something. I think that certainly before lunch. I think it's more like around 11. You usually find the jurors in their mid-morning breakish time area. If they have a question or something, that's when they come out. So let's see if the whole idea of jury tea leaves is true.
And sometimes they do the lunch reset. And by that, I mean, we think we know where we are. Let's have another lunch. Let's have another free lunch and, cement our decision before we make it final. While I was hanging out and setting up here, people are always so nice. They'll come over and they think I have people. They have people here. I got minions. Just set that tent up, move that light. No, I'm a one-man band here, so they'll come over and help. And here's how a lot of those conversations go. Oh, I love Justice Serve TV. Is Linda here? No, it's just me. That's it. This is all you got. So I've got a few of those encounters already, and I did an interview. It's
I'm
posting now.
sorry.
I did an interview that's posting now. A young lady. They start talking about how they're moms and they have kids. I'm like, you look 20. One from Nashville and one from Tampa, and they actually sort of met online through X as viewers of this case, and
Wow.
without coordinating, they both independently said after Friday, no verdict, we're going to do something, and so they booked flights, ran into one another here, and in fact, I see them now coming back from across the street, the bagel place, and they just kind of been hanging out and kind of taking this all in.
Oh, well, that's interesting. All
their
because they met online with our show. I'm actually going to post your on X. I'm going to post your Here Comes the Team video that you just uploaded.
Just loaded that, and then the other one
yeah.
is it's called "Why Are You Here?" and that's the two
You're
ladies who have parachuted into town, and
amazing.
it's a cute. It's such a cute little town. And then I was talking to a lot of bike cops here, and one guy came over, and I thought he was, I got this tent set up in this little park. I don't have any permits. I don't have anything, and I thought he was going to be, rousting me. And he started asking about our Starlink.
Oh, really?
So, yeah. So I was giving him the sales pitch on the Starlink because, other than, not having a clear sky, it's amazing. You have to have no obstructions. So thanks again, ladies. Appreciate it.
I'm going to actually post that. That just uploaded right now through JSTV.
So anyway, I'm asking him, and I noticed on the back of his shirt it says Quincy. Now you notice I said Quincy, and it's Quincy.
Right.
It's if you're in this area, it's Quincy.
Really, it's not Quincy.
It is not Quincy, and that's also, of course, the home of Dunkin' Donuts, as you would know.
Well, that I know. That I didn't realize, but I didn't know it was Quincy. I visited when I was up in Hernandez. I visited the original Dunkin' Donuts that started all this, And usually I'll put it in our cup, but this morning we were having some technical difficulties, so I didn't get a chance. But normally
we always do.
There it goes.
There you go. It's a mug cup holder thing. So anyway, so I was asking him after we had our Starlink discussion. I should be getting paid by Starlink. I think I'm selling product. So I said, "Are they? What's the cooperation agreement here? You guys obviously, Quincy is about 10 miles away." And he said, "Yeah, they just needed some manpower." And I said, "So how's it going? I mean, this looks about as sedate and controlled as I can imagine for this many people." He said, "He said this is nothing." He said it's such a difference from Antifa in Boston. So this guy's been called from Quincy to go up to Boston to deal with the Antifa morons, and so this is like nice duty for him.
Oh my goodness gracious! So yeah. I mean, this is as Tom CPU once said. This is like no one's even skinned a knee. Okay.
Yeah.
All right. So be on the lookout for Jason Grant. Know that we have a couple other questions. JSTV, heaven forbid if there would be a third trial, but could the defense request to have the trial moved out of Massachusetts, similar to Koberger's case? Well, it's never going to be moved out of Massachusetts. It could be moved to a different jurisdiction, but I'm not sure the defense wants that because they want people from Canton who know they believe that the system is corrupt. So I think it's
And as exhausting as even the thought of a third trial might be, that they would want the support that they get here. This is, if there is such a thing in this kind of case, it's a home court advantage. So I think they would have no interest in moving elsewhere.
Yeah. Dear asks, is there any way to see verdict forms used for other murder trials in Massachusetts? Not really. There's no compendium with these things are filed.
These days it's getting better. I'll bet you over time, as we move forward, because all of these folks who have just document databases collected up, like this one, this verdict slip, it's now there, it's out there. If you do a little quick research, bam, you can get your hands on it.
Right.
So, but as we go back in time, not so much.
Yeah, and then HJH as are the guidelines for jury forms that judges have to abide for too. No, not really. There's standard jury charges. We know that, but there's no such thing as standard jury forms. And the judge said, "Well, this is how we do it in Massachusetts. This is how she's done it." Remember, she was a defense attorney for like 24 years, which really surprises me, quite frankly. All right, and this is how we do it. But also, Yannetti's there too, and he says, "No, you got to have a not guilty." So this is astounding to me. But in her snarkiness, she said to Yannetti, "Well, the Supreme Judicial Court proved me right," or something like that, right?
Right. And my friends from out of state mentioned that as well, because I brought up the form with anybody anybody within my voice. I'm always talking about that slip, and they acknowledged, that the court had looked at it and rejected any sort of change because she felt she had been, vindicated, when in fact there was no addressing the merits of the slip. It was just the remedies in place. So go away. And that remedy is now in deliberations, verdict or trial number 2.
All right, so hold on a second. I can't, things are moving so fast, so my eye dropped in my eyes, I can't see. Beth, I always pronounce Quincy as Quincy, but Quincy is for John Quincy Adams, the way Linda does. That's why I always pronounce it Quincy, because that's what it was supposedly named after, was John Quincy Adams, right? But that's how we do it in Massachusetts.
Exactly. There is a certain territorial approach to virtually everything here.
So but I do like the way they say wicked smart.
Wicked smart.
That's a saying up there, and you have there's t-shirts and probably you've seen them, sweatshirts and all that kind of stuff. Wicked smart. Okay, because I parked my car in Harvard Yard when we were doing Hernandez. We did have our local counsel George Lantire, and he didn't say any of his R's. So you could always tell where people were from, because we were saying our R's. We were doing our pronunciation, and they weren't. So you can.
I've heard some people suggest that Mr. Brennan, he doesn't have quite the Boston accent that he's put on, and that in closings at some point he started, like adding R's back in and pronouncing things less Bostonian like. I don't know. People like to latch onto things. I'd have to go back and look at that and see. I don't know that Brennan's that good an actor.
No, I don't think so. I think so. Although, you hear people, actors who come from different countries, I always say, and then you listen to them, and when they give interviews afterwards,
I know. So, whoa, I'm amazed. They are so flawless. I mean, I can think of like Yellowstone, the young woman who played the feisty daughter in that. Very Australian, but perfect American accent.
Well, you do voiceovers. You are.
Yeah, I don't do when I did one recently for a film coming out in September. It's a Jordan Peele film called Him.
By the way, you have a somebody who.
I have somebody what?
In the background.
I have somebody. Oh, hey man, how you doing? Good. He likes the photobomb.
Yeah.
Oh, take care, man. Yeah, it's a film called Him. It's about, oh, good, we got some construction going on. Okay. Anyway, they asked me when I was doing some of the work, they said, do you do an Australian accent? And I don't do one, mate. I can't do it. And they said, you're right, you don't do one. So so they had somebody else work on that. But I'll be bugging people about that as it comes out in September. It looks like an amazing film. As Jordan Peele tends to do these kind of real world, but a little supernatural twist. He did Get Out, he did Nope. And so it's this one's in the sports world. A guy, a star football player, finally kind of comes to the end of his career, and they need a new guy who's going to be, him, the guy that's going to replace him. So maybe he has some help getting to that level with some otherworldly influences. So
yeah.
Anyway, yeah, so much of that. Sorry, I got off on that tangent.
That's okay.
Yeah,
that was
I'm amazed
good.
at people who can do accents flawlessly. Not my. I can do Brennan. He's got a little bit of a Boston accent in there when he wants to. So
anyhow,
what do you think's going to happen today? I mean, really,
we're going to hear from them.
We're going to hear something, a question, a clarification, a stumbling block, something.
Well, let's start with this. Can a jury really decide she's guilty of murder without something more? I don't think so. On regard to number two, aren't they going to have a question on this verdict form? I mean, I just can't imagine them coming out with a verdict unless they have a question on this verdict form. Let me go back and find it. I have it right here.
That's a good point, because that's what I would think, that they'd say, Your Honor, can you help us understand this? And then it'd be very interesting to see what Judge C does. My guess is she would say, nope, figure it out. But they did not have a question of that kind the first time around. They had the question, they wanted the cert report.
Right.
And that was it. There were no questions about the jury form, but we learned after the fact that that was what everybody was focusing on, could never get passed.
So here's my question to you. And just remind everybody that in the first jury, on the first day, they wanted a copy of the cert report, which didn't exist. There was no cert report. Okay. And that was, and then we didn't hear from them again, really, until they had the hung, until they noticed they had the hung. That was it. That's the last time we heard, next time we heard from them. I think that was what, 2 days later, Michael?
That sounds about right.
Because it was the fourth day that they were let go, and they were recharged, and then they came back with the hung again. And so I think, so they were a little radio silent for 1 day too. Let me ask you this. We weren't at jury selection. So we don't know what the jurors who were selected did know about the case. Maybe some of them knew that there was a problem with this verdict form, right?
It's possible, you know.
Yeah, but there was also all sorts of rumors as to the verdict form, as to not which, one, whether it be the original, the actual count, or then it was 2 lesser includeds at that time.
Right, because the OUI was not added in there. Right.
Right. The OUI was not, and now we have the OUI added in there as a different element of each of these, right? A different element of each of these, except for the involuntary manslaughter. So the original count 2, and then 1 lesser included that has the collision has OUI, and the other lesser included just has OUI with no death, right? So they're all different in a way. I don't know. I don't know. I mean, I don't know. If I'm looking at this as a juror, I don't know what the heck I'm doing. I guess I'm going result oriented first. Do I think she's guilty of anything? And then trying to fit in what I think she's guilty of by working backwards. I mean, that's what this verdict form kind of demands. I mean, otherwise, I don't see how you can deal with this verdict form.
And beyond that, what is not on the form are the elements of each of those lesser included, which the court instructed them on. And there were, I think is it for the manslaughter? There's like 6 different elements that,
right.
Some of them are very obvious, operating a motor vehicle, and, but still, if they're taking this seriously, they're breaking down each of those elements within each of those lesser included.
Right. And that's why the judge said, well, this is very clear if you read the jury charge, which they have with them with the verdict form. I'm not sure of that, but that's what she claims. So, that could take a long time. So, that's why I think the defense is worried, because they thought a quicker verdict would be like, let's get result oriented. Was there a collision? No collision? That's it. Goodbye, so long, farewell. Oh, we have this OUI to deal with, right? Should we deal with that? And I think that's why the defense is worried that there's no quick verdict right now. To me, that would be the concern if I'm there. And of course, then you say, well, I tried the case differently this time. I tried it, no collision, no collision, no collision. Our guest, by the way, is just about to
and I think if you're the defense and you've added this OUI, it's almost an acknowledgement that we may get to the same point we did last time. We may be hung, and this gives them an opportunity to find something. And let's just be honest about it. The pain is far less for a straight OUI. Incarceration, highly unlikely. And so
unless you're into
let's
retribution.
throw that out there. Oh, yeah. I mean, you're right. It's not impossible, but it's highly unlikely.
Yeah. Thank you, Kim, the Michael Easter interview. That was excellent. I really enjoyed listening to him. Yes, it's created quite a stir online. That's the witness that you did not get to hear in the Baden defense. Well, we have our guest with us right now, and I'm going to introduce him because he's a major trial attorney, does mostly a civil law, but he knows juries, okay? And that's what we want to talk to him about. We want to talk to him about juries. And I'm going to ask him, I'm giving him the heads up. I'm going to ask him, if you're the prosecution, what are you thinking right now? And if you are the defense, what are you thinking right now? And if you're the prosecution, what are you concerned with right now? And if you're the defense, what are you concerned with right now? So with that heads up about the question, I'm going to bring in this fabulous attorney. I'm proud to know he is my friend. That is Brad Stone. We're going to add him to the stage. And there you are, Brad. Nice to see you.
Nice to see you.
Hello,
Yeah.
sir.
You made me.
Nice
How
to
are
meet
ya?
you.
Yeah.
Nice to meet you.
Yes.
Well, I laughed out loud just now when you asked that question, because I think if you are either side right now, you are really starting to get nervous about maybe having to try this thing again.
Okay, tell us why. And I'm going to tell people, and I don't want you to reveal who, that you actually know sort of possibly some of the players in the case. And so I'm not going to mention who that is, or who it may be, or how many it may be, and what the relationship is. So tell us why, if you're either side, you are nervous.
Well, to me, let's start with the defense, because first of all, as I think people say a lot, but it really can't be stated enough. It is a very dangerous proposition to get into handicapping jurors too much, because human behavior is so difficult to pick out. That being said, when the jury's getting the case at 3:00 in the afternoon on Friday, in one of the first summer weekends in the Boston area, if they're going to come back not guilty, most likely, in my opinion, they would have come back, across the board not guilty on Friday. So I don't think you can categorically say anything like that is automatically means that they're going to be hung, or that they're going to come back with convictions on some charges or anything like that. But I do think that if I'm Alan Jackson, if I'm the defense, I'm starting to get a little bit concerned. I would have certainly preferred to, be home celebrating over the weekend instead of, continuing to slog it out. If I am the prosecution, however, at this point in time, particularly having been through this multiple times and knowing how much just pressure is on them in a way that I don't think is necessarily on the defense, this is now getting into the window where you're going, you guys haven't figured this out yet? Okay, maybe you wanted to go back to the jury room and look at some evidence and have some conversations, but boy, this is taking a while. I remember the last time my last jury was out over 3.5 days for about 20 hours. And probably about, I would say, midway through day 2, I guess I started to get a really pained look on my face. And my dear friend who I was trying the case with looked at me and he said, are you getting worried we're going to lose? And I said, no, I'm getting worried we might have to do this again. And luckily we didn't. But, those are the kinds of things that I think start to become, more realities as time continues to tick on.
So this verdict form, this verdict slip, as we call it in Massachusetts. Now, as I said,
Yes.
we both have tried a lot of cases, all three of us, right? The two, Michael and I, have never seen a verdict slip like this, except in the first trial. All right. Talk to me about the fact that there's 1 not guilty and 4 guilties listed on here.
Yeah, I mean, I think it's a really interesting conversation to have, and it's really interesting to see. I think one of the great things about the work that you're doing, on the Karen retrial and all trials is I think the justice system is something that really benefits from people being, keeping close eyes on and paying attention to. And I think the conversations surrounding this topic have been terrific. That being said, there's a big difference in my estimation between something being convoluted and confusing and something automatically becoming, treading into that realm of becoming reversible error. I don't know how to argue. It's funny because I was talking to a dear friend who's a former Boston prosecutor this morning, who was trying to tell me that not including the not guilties on the lesser includes was not confusing. I said, I think you're nuts. I think it is exceedingly confusing. It almost feels like an advertisement for, find her guilty here or find her guilty here, because you're not creating that other option. That being said, it is my understanding that the Massachusetts SJC has approved that form. And so if I were the judge, I would be inclined to permit that slip as well, simply because I know that that's going to be the safest way to not get reversed on appeal. One could argue, and depending on how this thing goes for the defense, I mean, maybe we will see this argument that there's a federal due process violation implicated by that slip. And I certainly think crazier arguments have been made, but to me, that's the only way that that this gets, actually reversed as opposed to, just being something that's messy.
Isn't that interesting? So we do have a couple of questions. Okay. Madeira Beach caregiver, one of our great followers, says, I thought it was interesting the way Judge Kenney instructed jurors to go by, she said, versus what the paper said regarding the instructions. She said to go by the jury charges. You have the jury charges there. So does that also help? What you're saying is that you don't think that this jury slip is reversible error?
Well, one thing that we know is that as frustrating as it can sometimes be, jurors, the way the law simply works is jurors are presumed to have understood and followed all of the instructions. And I can tell both of you in the audience that I was actually about 5 years ago. It was a fantastic experience that lawyers rarely get, but somehow lawyers did not throw me off a jury. I was the foreman in a.
Oh my God, you were a four-person in a jury?
I was. It was fascinating. I mean, it was truly. I talk about it all the time because I was so lucky to have had that experience as a lawyer, because every assumption you have is flipped on its head. I had handicapped the people I thought were guilties and not guilties, and I had it backwards, But the reason I was just bringing it up is because we walked into the room, we ended up acquitting, and we walked into the room, and this one fairly outspoken guy just said, he's guilty. And I said, well, why don't we actually open up these instructions and go through page by page and see if all of the elements have been proven beyond a reasonable doubt. Once we did that, the guy said, well, I guess by the letter of the law, like, he's not guilty. And I said, that's all we have to go by. It's not
So
the letter of the law.
you're my explanation. What I have been saying to people is that you need that one juror who gets up and says, hey, our job is not to see what happened or think what happened or this may have happened or can rate a scenario where she could be guilty. Our job is to see whether the prosecution proved the case beyond a reasonable doubt. So Richard Gabriel, the jury consultant the other day, said the jury foreman here will control how these negotiations, these deliberations work. And you just kind of confirmed that, Brad.
Well, I mean, I do think so. That another thing that is not a wrinkle that I've tried cases, maybe both of you have, where the judge actually selects the foreperson. And realistically, it probably doesn't make too much of a difference, because your leader is going to out themselves pretty fast once they get back into that room and start talking. But to me, it's a critical thing. Because especially, we as lawyers take so many things for granted that people understand that they have no clue about. And, you really have to stop. I mean, a lot of the work, as you said, that I do is civil work. There's all these references in civil cases to damages and money damages. And I had to pull the judge aside when the last case was strictly judge-led voir dire. And I said to him, I think you need to ask them, Your Honor, about whether or not they know what damages are, because I don't think they understand it's money. And sure enough, they didn't. So, I mean, these things are really important to, you can't assume that people just know stuff.
Yeah, that's amazing. Yeah, and a good lesson for folks. You get so deep in the weeds, everything is second nature to you. But these folks are coming in off the street of the real world. So,
Correct.
Brad, let me ask you this. From a observation perspective, because I'm watching the attorneys come and go, I'm watching Karen Reed come and go, the prosecution. What signs would tell you that they're getting nervous, concerned, let's just say less confident?
Well, I think that's a really difficult thing to say, because again, you're talking about human nature. I think that one thing that struck me is, and I don't think this is before the jury was even charged, but I just looked at both guys when they were doing, when they were the last moments up before the jury, and they both looked like they'd been through a war. I mean, they just looked exhausted, and Alan Jackson's face was all puffy. Forgive me if anybody from his terrific firm is watching this. I think he's a fantastic lawyer, but you go through something like this, and as both of you know, I mean, it is the closest thing you can do to like a competitive sport, or it's a full contact activity. And you try a 3, 4, 5, 6 week trial, and by the end of it, you are just beaten down because it takes everything out of you, and you're working these crazy hours. And so, as far as each side is concerned, I think for that reason, it's difficult to really go too far inside their head. But if I were the state right now, again, these are sort of very general propositions, but it would seem to me that that the longer this goes, the more likely it is that they're going to get a conviction on something. And so I'm probably starting to get a little bit of optimism if I'm them. But balanced against the fact that I'm thinking about the fact that this is just continuing to go and go, and could result in another hung jury.
So we have a question from one of our viewers on that. Joan, question. Did you see a Lussie snap yesterday on leaving? There will be no comments today. Very abrupt, seemed aimed at Karen. They made me nervous the way they acted. They seemed scared. Michael, you were there. And Brad,
I'll
you're
tell
there.
you what actually happened. And I mentioned earlier today that as they were coming down the stairs, Alan Jackson did two things. First of all, he kind of said those cameras are shit heavy, keep them out of our way. But he looked at Karen and he said something like, "We're going to stay right here until you're ready to go and you're done." And she looked at him and said, "No comments." So he was deferring to her to whether she was going to say anything, because she has regularly said something or had a quick Q&A with one or more of the media members. But yesterday, he deferred to her. She said, "I'm not going to do anything." And boom, they, forged their way through the crowd. So that was a little interesting.
Yeah. And I think that the entire time through, I mean, Linda mentioned this earlier, and what I think is fair to say generally is, being a Bostonian by birth, and, being in this profession as long as I have a lot of relationships on both sides of this case, actually, not with anybody in the prosecutor's office right now. But, I certainly feel, I feel allegiances to kind of everybody. And so I think it's important to say that, because I'm not in any way, taking anything away from either side when I say this. But I think that one of the I think brilliant strategies that the defense has undertaken really since the beginning of this entire case is the use of social media and the media in general to get their message out, and maybe to arm people that they need with arguments to be able to make once they are back in the room that they're in now. And I think he's Alan and the defense team overall has definitely gotten a fair amount of eye rolls and criticisms from people. But the bottom line is, I think it was very effective. And it's something that in this day and age is something we'll probably see more and more of.
I always tell people that what you're doing both in your social media now and in your closings is you're giving those jurors, because let's face it, jurors have family members talk, or they overhear things. You're giving them the arguments, and certainly the closing is to give those jurors that are on your side the arguments that they can go in and argue against the people on the other side. But to your point about juror confusion, Shannon Giuliano says, "I was a juror on a civil suit, 3-day trial. It was clear cut to me. We literally had 2 jurors, though, who were confused about damages. I was in my late 20s at the time, and I was stunned." That's exactly what you're saying.
It's true.
Brad? Yeah,
it's true. I mean, you just can't. It's a really special skill to take very complicated stuff and make it digestible. To not even forget about intelligence. Just you're not only competing against or kind of shackled with the reality that you have to explain things that are difficult, but you also have to explain things when you're competing against people's attention spans and what they have to do when they get home that night, and the fact that they're thinking about the fact that they might have to do laundry and stuff. And so if there is just too much nuance in anything you're doing, it can very, very easily get lost. And I think especially it's a weird thing, because you spend so much time preparing for every witness and every argument and everything that you kind of can't help but take certain things for granted, and it's a very, very slippery slope when you start doing that.
So I do have a question for both sides. So you are the prosecutor. All right, looking back on this, was the prosecutor really going for murder, or were they trying this case for manslaughter? That's my question on the prosecutorial side. And on the defense side, were they trying this case based on reasonable doubt, or they're trying to convince the jury that Karen Reed was not guilty of everything?
I think it shifted a lot from trial 1 to trial 2. I think that from what I have seen in this trial, it definitely appears to be more reasonable doubt focused, which I think is better. I don't really know what the prosecution's doing, to be candid. I mean, and I will say this, based on what I know, it is difficult because I'm not a juror. Based on what I know, if I were in that jury room, I would be a guilty. And I would be a guilty because, to me, this is an overwhelmingly strong circumstantial case. You have a woman who is the last person to see the deceased alive. She has a murder weapon. He's found in the location where she's last seen him alive. And if she weren't responsible, what else could have happened? I mean, to me, it works on that level, and the sort of simpler you make it, kind of along the lines of what I was saying a minute ago, and the more, if you are the prosecution, you're sort of staying at the 30,000-foot level, the more you're winning. Once you're getting into, I mean, their expert who, was a complete hired gun, and I think that's true of most experts most of the time, not all of them. Certainly not the legendary Dr. Baden, who's incredible and very principled, but in general, there's so much, kind of battle of the experts that will arise in cases that they end up kind of canceling each other out. And, if somebody doesn't really know, which doctor or scientific professional to trust, they're going to revert back to, sort of basic principles anyway. And that's why, to me, if I were trying this case on the prosecution side, I would have been much shorter, and I would have been much more, as they say, kind of high level.
So focused on basically what I've said, the danger to Karen Reed, I've always said, is the Occam razor that people say. But on the other side, the other side, you have no collision, no collision, no collision. Michael Bryant, your thoughts?
Yeah, Brad, tell me your thoughts on the adding of the OUI by the defense. Is that an acknowledgement that they feel this jury will want to find her guilty of something? So let's throw something out there that's the least damaging.
It may well be. And the reality is, most of the time, juries are compromising on something. And so, I mean, would you rather? It's not unlike, people think back to Casey Anthony, and they, remember her as being acquitted, and obviously, she was. And Jose tried a fantastic case, but she was convicted of lying to a police officer in that case, and that's just what happens sometimes. There's the flip side of that coin, which is a jury could just feel like she's been through so much, and if they're going to acquit, they're just going to acquit her up and down. But I think it's a recognition of, sort of basic human nature in that jury room, and the fact that it's probably a very smart hedge if you're the defense, I would say.
Well, that's a lot to think about, because that's exactly I imagine that's the concern for the defense, and the concern for the prosecution is that the defense tried a really good case, to me, on reasonable doubt. Okay,
They did.
So I thought they tried. I don't think you can get any better case than Alan Jack. I said his closing was the best closing I've ever seen, and I've worked with her. I mean, I did all the forensics with her and all, but I thought that. I've never seen a closing as good as I've seen that one, weaving all these different threads in.
I'm very curious, and I know I'm the guest, but I'd love to ask you this question, because I did not think his closing was as impressive as most people did. I thought overall his trial presentation was fantastic, but I didn't like his tone. I didn't like. I mean, he's such a smooth guy and to me, that's such an important part of the package when you're talking about Alan Jackson, that he shouldn't have been looking at his notes more than a handful of times, and he was looking down a lot. Those things were kind of concerning to me, and it almost felt to me like multiple people wrote that closing as opposed to just Alan. I mean, usually when he gets up there, every argument is tight, and it has an internal consistency to it that I didn't see that time. And I don't know if I mean, clearly you disagree about the overall strength of it, but did you see any of that at all yourself, or no?
Michael?
Well, I think we know that there was some assist on it. We think Elizabeth Little probably had something to do with it as well. I didn't notice any sort of note-bound sense to it, maybe because it was so forceful and dramatic as he was making the points he was making. I just didn't feel like I was looking at the top of his head more often than not. I do know that with the time restriction, you've been in that position before, right? Where it's like you want to get certain things in and you have it timed out. They begged for an extra 15 minutes. So they go from an hour to 75, and it actually went almost 90. It was like 85 minutes. But that's maybe more scripted than you might normally be, because you've got to get in what you got to get in that time period. That might have, handcuffed him a little bit, but I didn't find it that noticeable.
Yeah, I didn't either. I really thought he was maybe because I've worked with, when I did Spectre, I had 6-hour closing, which I don't necessarily like, but of course I had to refer to my 2 notebooks over 2 days. I mean, there's no way I could not refer to them with 6 hours. I mean, even actors refer to their notes at that point.
Yes.
So I just thought that he gave the jury almost everything they should have in there, and that's why I was so impressed. At the end of it, I just went, oh, wow, that was, I don't think I could have put all that stuff together and made that coherent a story in that time limit. So yeah, no, I didn't see it, Brad. But that's interesting, because that's not, that's why we have you. That's why we're talking to you, because you do know a lot of the players. And again, I won't say in this case, I won't say who they are. And you do have an insight into what they may be feeling, what they were trying to do. We do have a question though from you. For Angela Amadon, thank you for the donation. What do you think Aperture will do with regard to negative press? Because Aperture, I thought, really got hurt in this case, as experts.
I think that the reality is there are, I don't know, 5 to 10, and maybe less, but let's just say 5 to 10 expert consulting firms around the country that they've been at this a long time. And I think that they're willing to take their lumps, and and I don't think it's going to change sort of like how they do business or who's going to work for them. I just think, and I am a little bit more cynical maybe than most about a lot of experts, maybe just because I've had to battle it out in 12, 15-hour depositions with people who I know are just being paid to sing at the end. But to me, as the lawyer, I just am less moved by those narratives, because I feel like it's par for the course.
Oh, Brad, it's so good to have you on. I appreciate your time, and I know we had to work around you bringing your kids, but a really interesting insight we have. And as I said, in this network, we want to hear all insights, and your insight. Again, I will tell our people, don't discount what Brad is saying. He has some knowledge about the players in this game. I won't tell you who they are. And so when he has these insights about what they may be feeling, what they may be thinking, maybe he's put themselves into their shoes through his knowledge of knowing them. So, if he wants to reveal that after the fact, we can deal with it, but it ain't going to be on this show right now. Brad, thank you so much.
Brad,
let you
pleasure.
go.
Thank you for
nice to meet you.
Likewise.
Thank you.
Thank you very much. Bye-bye.
Bye.
And we have Neil. Neil Rockweiler, I believe, is. Did I hear Neil get on or no? I thought Neil was on. Maybe not.
I do not see him. I do not see him.
Well, we have some other questions, Michael, for you to answer, because that was really an interesting interview.
Yeah, interesting how people react. Let's face it, the Free Karen Read or the Karen Read supporter movement, it's strong and very intense. And when they start to hear something that suggests that, oh my gosh, she might be found guilty of something, or somebody's perspective that doesn't align with theirs, they get a little snippy about it. But the fact is, you don't know what's going on in that jury room, and there may be people making those arguments between one another that is leading towards guilty on something.
Yeah.
I mean, I think it's naive to think that couldn't happen. I don't care
Yeah.
what you think. I don't care what you think the evidence shows. We're talking about a jury here.
Yeah, and as Richard Gable told us, they'll go in, despite what happens, they're going to go in and have their own narrative and try to create a narrative, which is what they should not do, but they do.
Yeah, I mean, that
because,
to me, that scares me the most about the process, where folks think they got to fill in the blanks, instead of holding the prosecution to their burden. They think, well, we know about this and this and this. It's not that hard to, connect these dots and fill in a few others. That's not your job. So to me, that's important. Make sure the jury focuses on what they're there to do and what they're not there to do. And I know it happens all the time. I'm not naive about it. It happens. And I'm sure, and the problem with it is, if you appeal, that's not a jury misconduct issue. Very, very difficult to invade the province of the jury on an appellate decision. They are not going to start, interviewing jurors in the absence of some outright misconduct. They're not going to get in their brains and say, well, how did you get there? Because it doesn't look like the prosecution had that element. That's not going to happen on appeal.
Yeah. Yeah, they're absolutely right. So we have a question here, TC Irish Pride. Question, Michael, I'm going to throw this to you. If she murdered him, why would she call, I'm going to subject killed him, whether it be, because I can't imagine him.
Who was responsible somehow for his death, yes.
Yeah, why would she call Carrie Jen to go to the scene?
And there's a lot of those questions, that people have, they focus on, her outrageous texts, her anger, the phone calls. Hey, it's one of the earlier sirens of the day. Remind me to tell you a story about the rescue vehicles here. I think I have some insight on that.
Wow.
Engine 7, busiest engine in the country.
Yep, still going. I thought you were finishing. Still going.
No, he's making the turn. Oh, and then the ambulance is caught up from behind. I don't even know what I was talking about. What was I talking about? The issues with, why would she do certain things if she was guilty of being involved in his ultimate death? I think those are honest questions. Is a person who has just somehow been responsible for another's serious injury or death, are they screaming mad at them? Are they freaking out about not being able to find that person? And are you going to reach out to people who know him, in this case, Carrie and Jen, versus people that you might want to surround yourself with to protect you?
Yeah.
I mean, those are honest questions. And I think human nature says that doesn't square with somebody who's done something they know is wrong. That doesn't necessarily discount any sort of negligent act, right? But if you intentionally did something to somebody and you're trying to distance yourself from it, do you bring in people that are closer to the victim than to you? That makes no sense.
Yeah. All right. So we have a couple other questions I want to answer from people that are members. How come there weren't any objections in closing? Hank's statement truly needed objective. Michael?
Yeah, I think we were both surprised, but not so much that they weren't that there wasn't objection to Hank's. I thought the defense was going to sit back and let him do his thing, but I was a little surprised that he didn't object to anything in the defense closing. It's bad form generally. Remember, closing arguments. I know some people will they'll switch words, statement and argument all the time. It's time for opening arguments. No, it's not. There's no such thing. It's an opening statement, which is much more likely to be objected to, because why? You can't argue. Great attorneys, they get a little argument in there.
They know how to do it, right?
I've learned that all you have to do is preface what you say with "the evidence will show."
Right. I believe the evidence will show. Right.
And then you can squeeze in. The evidence will show that the prosecution is a bunch of scumbags. Oh, wait a minute. I'm sorry. I mean, those are arguments, but if you do it right, you can get a little of that in. But when closing arguments come along, there's a lot of latitude there. So unless you're misstating the evidence, you're throwing in something that was never in evidence, there's not a lot that you can legitimately object to if you misstate the law or the evidence. But most attorneys are plenty good enough, not to do that. So I'm not sure what.
And she may have had also the Judge Canonia thing where if you have objections, you're going to bring them after, you're going to put them on the record at a second type of a sidebar. And then she denied any objections that were made because there was no curative instructions to anybody anyone was saying.
Hey, let me tell you my rescue vehicle story, which may or may not be true, but it's interesting. I think I'm coming in today one of the main roads, and I see there's clearly a little fender bender. Somebody may have been trying to turn into a gas station, and somebody else clipped them. And so there's some damage to the vehicle, but both the drivers are out, mobile. Clearly, there's no personal injury. They scrambled a fire truck, a paramedic vehicle, and a regular not a fire truck per se, but another fire vehicle. They scrambled because they all came along that road right to that scene. So I don't know if just the practice here is kind of an overkill to be prepared for whatever, but it just seems to me there's an overwhelming number of those parades every day: fire truck, ambulance, rescue vehicle. And I saw it in action with what was clearly just a pull over to the side of the road type fender bender. So
interesting, because here in New York City, if you have an accident or a clipping on the West Side Highway, get off the roadway, next
pull
exit.
over.
Well,
That's
don't
right.
call the police. You don't call the police. You get exchange information. Forget about it. Yeah.
Yeah. Property damage, no injury. Just pull over. Just get out of the way. Yeah.
I'm sorry, Teresa Wingbermule. How much blood did John lose, and why wouldn't that have been hammered home? He didn't have any injuries except to the back of the head on the skull that would cause that type of massive blood loss, Teresa. I mean, the arm, they said the arm actually didn't have any injuries, and that was what the defense was using to say, look, if you're in an automobile crash, you're going to have, crushing injuries and there'll be blood and all sorts of stuff. So there's no way to measure that little tiny bit that came around the skull. It certainly was, the blood itself wasn't life-threatening. It was the expansion of the brain, into the skull plate. That's what.
They collected whatever blood there was in those 6 solo cups. At least we
right.
think
That was
they
it.
got most of it.
Yeah.
And then they only tested
that
one.
That had to be from the back of the head because he didn't have any other injuries. Right.
I thought it was, I think that picture of the arm, which is obviously the central focus of the ultimate injury, was it dog bite? Was it rabid tail light? That picture makes it look like there was active bleeding. Would you agree with that?
That's what it looked like, but there was no blood on the shirt.
And there's been no evidence that it was. So the picture is so misleading. I guess they are, and they're called abrasions, although one of the Commonwealth experts called them lacerations. Right. But Dr. Rentschler, the last to talk about it, said that they weren't lacerations. They were abrasions, meaning these are like scratches that don't necessarily break the surface. But I guess they came out in that picture as very red, very distinct, because maybe blood pooled there under the surface, but nothing ever bled from those wounds. So I think that picture is very misleading.
It is in that regard. And I think back of when Tubi was a puppy and he would do those things to your arm, and there's nothing bleeding, but you see the red marks, and maybe there'd be some, little blood under the abrasion, but it doesn't break the skin, right?
Yeah.
Even a little punctate sometimes that may break the skin, but nothing comes out because it's just a small little tiny punctate.
That's one of my new favorite words from this case, punctate.
Punctate. Yeah. I mean, you take a pin, when a little tiny straight pin, and it hits you over here and it doesn't go through your skin, or if it does, it doesn't cause any blood, doesn't hit anything that is big enough to cause blood. So I do think we do have somebody who just got on. I think I'm stealing the Rockweiler.
I'm going to have nightmares with that sound.
I know.
That little
boop.
Somebody's popping on somewhere.
Yeah. So I hope that answers your question. And Rockweiler is here because we really need his insights, because I have a feeling that the jury is going to have come back with some type of question between now and 11 a.m. or something. So
and they've been at it another hour and a half. So that puts them at roughly 10 and a half hours now. They had 9 hours, 9 minutes at the end of yesterday. So we're now looking at, we're into the 11th hour now.
All right. So tea leaf time. Neil Rockine, I'm going to add you to the stage. You ready? Oops,
yep, I'm sorry. I'm dueling with Missy. Sorry, Missy.
Hi.
Hey, how's it going, bud? Hey, that is amazing lighting. Look at that. That lighting. I need some of that lighting.
I know. I can't get it from outside. I can get it from inside.
Yeah. So, well, can you do our lighting? That is really this is like TV impressive. Holy moly! It's like you're in a movie.
I mean, how do I hold the candle to you guys? Not possible.
I don't know.
Best I can do is
I don't know.
Yeah.
So
Hold on.
how you doing? Let's get your thoughts as we roll into day 3 here.
Well, I'm not gonna. I mean, I am surprised. I'm not going to deny I had anticipated a fairly quick verdict, and that's obviously hasn't happened, right? I mean, so I guess it's all relative. To me, after a 32-day trial, I had anticipated the jury would go back and look at each other and say, I mean, there's obviously reasonable doubt here on, if not the most significant counts in the case, and they haven't. I mean, they had every opportunity to render a verdict, I guess, on Friday before they're being told to leave. They had every opportunity to do that and didn't do that. And the same thing can be said for Monday, and here we are.
Yeah.
So
let me put to you the same questions I put to Brad.
It is
Brad
scary. It is scary to me. It is really frightening that you can't put up a more robust, together, competent, intelligent defense than the defense that was put up here. I mean, you can't, right? I mean, there's these are consummate professional defense lawyers. Alessi, I'm not sure he has much criminal defense experience, but he certainly has experience with the expert subjects, and they put up such a competent defense. I don't think that there was anything that wasn't challenged, and that there wasn't a question mark about. There's the state's theory of the case, and then there's the defense response to everything. So to me, since there's two clearly prevailing possible explanations, and they're not fanciful, seems like reasonable doubt to me. Is it my guess that is it my understanding they have not asked a question? There hasn't been a single published question.
Nothing. And we are now at about the point where in the last trial they had already asked for the cert report, which was the only request for anything up to the point they were tied up in knots. So Neil, what's your take on this verdict slip that we've been talking about? We know it caused a major problem in trial number 1. It's not any different except the added OUI standalone lesser charge. What do you think of that?
Confusing to me. It's very confusing to me.
Yes.
I think that it's confusing. I think that it's confusing when you see it. I understand that technically, and I say technically again, that there are issues, there are reasons why you don't have a not guilty next to each of the lesser included offenses, except I could literally see some jurors sitting there and if they're hung or they can't reach a decision on several of the counts, not knowing where to check the box. What if, for example, that they have reached the conclusion that she is not guilty of murder or manslaughter, but they're hung on a lesser offense? What do they do under that circumstance? My experience. I think AJ tried a great. I think he did a great job in this case. I know he certainly put everything into his closing. You could tell. But we talked. I think it was on Friday. I think that was a Friday. I think it was Friday. I think that was a missed. I think it was. I mean, the days blend together. We've been at this Karen Reed thing for so long, but that was a missed opportunity. And look, we all Monday morning quarterback, right? I mean, you can't squeeze. We all have had closings. Michael, I know you have, and I know Linda, you have, and I certainly have, where we get done with our closing and we sit down and we go, "That was great," and you go, "Oh, damn, I just shit,
absolutely,
God,
I forgot that."
Could I just stand up and say one more thing?
Yep.
You're always going to do that. But knowing that they had such problems and objections and issues to the point that they actually sought a writ of certiorari to the didn't they attempt to go a writ of certiorari to the U.S. Supreme Court?
Yep.
Yes, they did on the verdict slip, right?
Or to the Supreme Court on the issue of whether or not this was double jeopardy to retry her again, giving the juror, the post-trial affidavits of jurors, and that they have a juror / lawyer, now lawyer / former juror, who is on the defense team. It seems like they could have taken the blow up of the jury form and just said, look, this is the form you're going to get. It's going to look something like this. If you think she's not guilty, which we tell you she is, check that first box. Check it.
They didn't have the form though. They didn't have.
Yeah,
they didn't have this form. She didn't give it to them. She only finally gave it to them when they asked at the end. Oh yeah, here it is. She didn't give it to them before closing.
Did they ask for it? Did they ask for
I
it?
I don't know. The answer is I don't know
Yeah.
the answer to that question. Right?
Couldn't you at least? I mean, those are always part of the charge instructions too. The charging issues. In any case I've had, there's always a discussion of the verdict form before we actually close.
Yeah.
Yeah,
And you would
I
think with the issues from last time that they would have been keenly aware that we better see this thing.
Well, and again, to go back to something that I know that we've talked about, expect nothing from Judge Kenney. Right? We discussed this. Our friend Jose Baez once said to me, I like, what do you do with the tough judges? I expect nothing from the judge. I expect no help. So what if you just took out your butcher block, your pad, and you took a pen and say, look, I don't know what the verdict form is going to look like, but there's going to be one box. If memory serves, and the judge will tell me if I'm wrong, and if I'm wrong, do it that way. But we expect there to be a single box that's going to say at the very top, one spot for not guilty. Check that box.
And go home.
Go home. And if the judge has a different verdict form, then she does. But you find the words not guilty on there, and whatever line is next to that, you check. I would think to me that if there's any ambivalence and the jury hasn't asked about it yet. They haven't asked a single question.
No, we think that's odd as well. Yeah, which leads us to think that they are now just going through those lessers, or perhaps the main charge, number 2, manslaughter, and they're just, they're working their way through that as a group.
Let me ask you this. I heard, and I don't know if I think I heard it from you guys, that Kenney told the jurors not to take an initial poll.
Yes.
Yes.
He said strongly advised against taking a straw poll. When you get in there, I strongly advise you against taking a straw poll.
It was almost like part of her final instructions to them. You will now retire to deliberate. That speech, and it wasn't like she was saying it off the cuff. It sounded to me like it was a prepared comment. That I don't recommend, is how she phrased it. I don't recommend that you immediately take a vote.
What if they were all not guilty? Did they then have to deliberate anyway? They then feel like they're compelled to deliberate?
Yep. Yeah.
One of the issues that we have too is, again, I see pundits online talking about, oh, we're past the point where it could be a not guilty. We're past the point where there would be a not guilty. Where all the jury tea leaf reading and the palm reading. I mean, to me, that's all. I mean, the Yiddish word is mishigas. It's all silliness. I don't think any of it has any meaning. The O.J. Simpson jury, I hate to use comparisons, came back in, was it 4 hours?
4 hours, 4.5 hours after 9 months. Yeah.
I think Linda will know better than I, but the Casey Anthony jury came back in, it wasn't
About
long,
9
right?
hours.
9 hours.
9 hours, I think it was. Yeah.
How long was that trial? It was
it was a long
month?
time. It was 2 months. It was longer than this. 2 months. Yeah.
So, you also could have jurors who go back and just think like, we're gonna talk it out. There could also be somebody who is steadfast on a lesser, right? I mean, there could be someone who's just steadfast.
Yeah.
We don't know. We're reading it, so we have you on.
I just don't see. I don't see the accident.
I don't see the accident either. I don't think the prosecution proves the collision. Right? You have to imagine. You have to imagine there was a collision. You have to take a jump from text data to collision. That has to be a jump, and I don't think that's the way it's proved.
There were pundits who complimented both AJ and Brennan in their closing. I didn't think Brennan's closing was particularly strong, but I have my own reasons for thinking that, and I'm not talking about stylistically. I thought it was I thought it was a mile long, and it was a quarter inch deep of trying to stretch the clips. It was all based on the clips. It was really his entire closing was premised on her statements and her clips and her admissions, if you want to call them that, and then trying to stretch those to in between the points of evidence in the case. And so I didn't think it was strong. And I think anytime a prosecutor says we don't know what happened, I mean, I just didn't see any evidence of a collision. I didn't see it. So that's,
and then that leaves us with the OUI, just the add-on defense request for that charge, because that would not necessarily require a collision.
It would not require a collision.
Right.
So
Katie Catnaps, I just want to point out Katie Catnaps is a new member. Thank you very much, Katie Catnaps. Let me ask you this. Do you think though do they start with this charge at the OUI, the lesser included number 5, and then once they decide whether she's guilty of that, being under the influence of the blood alcohol, then move up the form instead of down the form?
Well, I guess you could do that, but doesn't the judge principally tell them you start at the top? And
I don't think that's an instruction she gave them. I don't think she gave them.
But logic would suggest that, But I don't know. There could be somebody in there that just thinks let's start with the bottom and move up. I mean, who knows? Who knows?
I mean, it also is.
Jury has a question. Jury has a question.
Oh,
apparently,
good.
Let's see. There you go.
Let's see. Mara, who's one of our followers, said the jury has a question. I knew that there would be some movement. I said between 10:30 and 11. By 11, we'd have something from them. So let's go. Let me go on Twitter. Let me check with Aiden. I think Aiden's in the courtroom. I don't see the fan yet right now. But Missy, do we have a fan showing now? And that's why I asked you. I was so pushing Neil to get you on during this time period, because I was saying by 11 o'clock, between 10 and 11, we're going to hear something.
Yeah, you needed somebody long-winded to help save yours and Michael's voice during this hour. So
yeah, by the way, all the female, according to Aiden, all the female jurors look really dressed as proper, like in the old time we used
like
the word
in dresses
proper.
and not jeans.
Yeah, well, and the men aren't as dressed up. As are the foreman wears a big gold chain and a t-shirt. Juror 4 always looks like he just rolled out of bed, Aiden says. Today, I don't know. So he's not reporting it, but Mara's reporting it, and I do see the fan. So I think Mara is absolutely right. That's why when we're here, we're not able to monitor social media, which is how there's a question but I see the fan is now up, or as I call it, the fan of injustice, and it'll be called the fan of injustice until it convinces me otherwise. Certainly, it still may be the fan of injustice because the stench of the Sacco and Vanzetti convictions still roll over that courtroom, in my opinion. Let's see. It's so hard in X right now to get any type of information. And when you're dealing with X, you have to go to the people that you know. Let's go to Sue of Boston. Wow, can't find anyone who knows what the heck is going on.
I don't see anything either.
Yeah, but I assume that with the fan going up and we're showing it in there, it could be something. No, I don't see anything either. Mara, where did you see that from? Tell us, because we're not seeing it, and since we're seeing the fan, we know you're probably right, but no one is reporting it out of the courtroom, including Sue of Boston. Let's go to, I wish that all the people who had reported on this, who were local reporters and people like Ted Daniels and everything, had gotten seats. That the fact that the legacy media, as we now call it, Jess Machado says the jury has a question. Okay, so let's go to Jess Machado's page. It would make sense to me, because that's what we talked about, that between 10:30 and 11, they're going to have something. They're going to come out with something, that's going to give us an indication of where they are. Jury has a question 1 minute ago. Jess Machado. Thank you all. Thank you, chat. Christina Rex, new jury has a question and will be coming back to the court soon to ask if this happens by giving a note to the judge and all lawyers are getting ready to read. The lawyers have to come back to the courthouse, I guess. Are they back in the courthouse? If they are not, I am just going to leave Michael and Neil for about 5 minutes, not even 5, and I will be right back. By the way, the fan of injustice apparently is always up. So I'm going to go behind my Tubi app. I know you and Neil can. Oh, wait a second. I'm hearing movement. I guess I'm not leaving right now for the moment. I'm hearing voices, right? So this is dramatic because we will get an idea of what is happening in that courtroom now. So I told you yesterday, 10:30 and 11 today, they'll have something, and here we are with something.
You won the jury question lottery.
Yeah, I don't get anything for it.
Just keep in mind that, this could be a really revealing question. It could also be, you could have one juror that is hung up on something and they need to go to the judge to try to get that juror an answer one way or the other.
Yeah, sometimes the question is just to help somebody understand what everybody else already seems to understand.
Right.
So.
Right, exactly. And then usually, if that's the case, they'll have a verdict. I predict after lunch. We'll see what this question is. Okay, obviously, that's going to tell us a lot.
So if you have to run, do you have to run? Do you have to go?
I'm going to run.
Take a comfort break?
I'm going to. Yeah, I need a comfort break. I'll be right back.
Okay. All righty. So, Neil, what surprises you most at this point? We're now probably coming up on 11 hours. So I think most people would suggest, okay, this is not going to be a clean, quick defense verdict. But what else can you take from that?
A long trial. The jurors don't have the benefit of Justice Serve TV where they're.
We hope. Yeah.
Well,
yeah. On that point, let me
digesting things and having analysis and having conversations with informed people about the propriety or wisdom or competence of some of the witnesses, and so they're just left on their own at the end of the day to go home and try to ruminate about it, and I mean that's.
Let me ask you this, and I thought about this last night because I found it odd, and Linda and I've talked about it, that the attorneys are still gagged at this point. That tells me that the court doesn't trust the jury, that the court thinks that the jury, once they're freed for the day, is going to look at social media, is going to look at the news, is going to talk to people. And if the attorneys are not gagged and they are saying whatever they're saying, and it's promoted on Justice Serve TV or where else people might get their info, then the jurors are going to be affected by that. Why else would they maintain the gag?
That's it. That's it.
It's bad. That's just bad.
It's purely because the judge has the belief that the jurors or relatives of the jurors could get information. I mean, they're not sequestered, right? So there is nothing that, and this is an important part of this discussion about information making its way to jurors outside of the jury room and outside of the courtroom. If someone happens to read a newspaper or sees a TV or listens to the radio or turns on YouTube, there's nobody there's no policeman that detects that. The only way someone would know that is if the relative that the juror or another juror happens to, hey, so-and-so is talking about what she saw on Justice Serve TV. And, I know you're not allowed to, but there's no other. One of the questions that I always ask jurors, which I know you do too, in a trial and prospective jurors, particularly in a challenging or a case that's touchy where there's some news, what do you do at the end of the day? What do you do at the end of the day where your spouse, where you're used to coming home and your spouse, your loved one?
How was your day? Yeah.
What'd you do today? What was the case about? What did you? and you have to say, I can't tell you. You know what I
Yeah.
mean? Or do you look over your shoulder and go, listen, let me tell you about
Yeah,
this.
I can't tell you this, but yeah, no, that's human nature. It's just that
And that's
I've not,
hard.
yeah, and I've just not seen the parties gagged at this point in the process. But I
Very
think
unusual.
the suspicion has to be at the highest level. This judge just thinks this jury is rogue, and they're not going to follow her admonitions to not follow the case.
And we've also seen situations where jurors have revealed after a verdict that there was information that made its way into the jury room.
Of course. Well, look what happened in the Weinstein case. We were going to have Imran on earlier today, but he had an emergency to go see Harvey Weinstein about something. But you know, that jury, talk about a rogue jury. You got two jury members that are saying that, hey, other people on this jury are considering the testimony from the first trial, which was prohibited in the second trial as bad, bad character evidence that should not have come in. And then you got the jury foreperson saying, I'm afraid. I've been threatened. I'm afraid to go back into the deliberations room. Are you kidding me?
Right. So. Totally. It's one of those things where, I mean, it's hard. It was hard to even keep the lawyers in the moment and the witnesses in the moment from not mentioning anything, right? I mean, not mentioning the first trial. Or think about how they tried to dance around as much as they could. Well, they didn't call it the FBI; they called it the IBF or the you know what I mean?
some
government
federal organization. Yes,
but BIFA. You know what I mean? In Pig Latin.
Yes.
I mean,
and for those just joining, there is a question. Sounds like I hear audio from the court. Let's go in.
So, counsel, why don't you come on up?
Sidebahhh.
Of course. Oasis Cat was suggesting that somebody had reported the O'Keefe family was not there yet, and it does look like a lot of empty seats. So what does that tell you? That it's less important, that so we're not waiting for them?
Well, it's not a verdict.
Yeah, I would say that's safe. Yes.
I just want to tell your subscribers. I mean, all four of us have tried. All three of us. I'm looking at myself, Linda, and you, and Eddie, and myself as a fourth. But all three of us.
Your split personality deal.
Yeah, this is. These are moments that, I mean, as lawyers, your stomach is just doing flip-flops.
Of course.
Butterfly. It is turning over.
Look at Sue from the courtroom says Alessi is speaking with a court officer about a concern, and he's talking to Karen as well. A little vague, but okay.
Now, you guys know this. Your stomach is turning. It is.
Of course.
We're all like ducks, and I say ducks because above water we're attempting to look as calm and controlled as we can, and inside we are just, your stomach's just flip-flopping and going crazy.
Yeah, whatever stress you're going through at the time of the trial is quadrupled, quintupled, a couple of decimal points when you get to this point in the process.
So apparently we're not seeing it from the camera operator. Obviously there's a sidebar and somebody's flipping through pages. I don't know if it's a judge flipping through pages.
Maybe it's pages of the verdict slip.
Oh boy, that would be interesting.
Yeah. Well, here we are at 11 hours, something like that. I would really think this is the point where they're starting to wrestle with those lesser includeds on that second page, and maybe they've been unable to figure out exactly what it means, and they need some help. That, to me, would be logical.
Well, except that, the way they're talking about ruffling through pages, it gets me concerned that there is a verdict. I can't imagine that without the family giving time. The judge would know what the question is. She would have had the paper when she got it. So she knew at that point. And then when some judges do it differently. Some judges will call you and say, you have to come over. We have a question. They'll tell you what the question is. Other judges will not, right, Neil? Especially
correct.
The defense. They want to give you, they want the defense to suffer as much as you can.
Some will tell you what the question is right away. Some will
Yeah, let's see if they have anything to
sign the
say.
question.
Bob, I can't do this. I can't.
Brennan said, I can't do this. You hear that, hot mic? God, I can't do this. I can't do this.
I
That
heard
was
that.
a hot mic moment.
Well, you're seeing that same note that I am, and Alessi seems to be leading the charge here, which is apparently a happy Karen Reed family.
Neil's right. You know, until you saw that question, you're like, I can't breathe. Because, you know, you have your client, people understand. Yes, we're talking about a very tragic incident. Somebody died. We're also talking about someone who says they're not guilty and is on trial for murder and could go away for life. When you have that person in your hand, right, Neil, you are just beyond. I mean, beyond, because you will get to go home at night no matter what. But the client who has trusted you does not.
And look, I know we're dealing with sensitive subjects and we're dealing with, you know, personal tragedies and a life lost. But as lawyers, you give up so much of yourself for a case. You give up time with your family, you give up sleep, you give up proper eating, you give up at times just the sort of daily regimen that that brings us part of our routine. You could be doing something important with your family and you have a brainstorm.
Right. So let me just say, there was just something handed
there's
from
some
the
cards.
defense team over to the prosecution. There was a note handed from the defense team over to the prosecution.
There were 3 earlier that AJ had that he handed back to look like Brennan or Lally.
Okay. And we did have the hot mic moment where Brennan said, God, I can't do this. I can't do this.
Yeah, I think he said, I can't do this again.
Okay, I missed the again. I just wrote, God, I can't do this. I can't do this.
Clearly, you know, look at the activity in the defense circle.
That's the slip that they have in their hand right there, right? That's the verdict.
Right, that's the verdict. That's the verdict slip that they clearly have in their hand, I think. A printed copy of it.
Yeah, and you can see Alan Jackson is making note of whatever it is they're concerned about, asked about.
Whatever it is. No, that was not AJ. That was Brennan. Whatever this is, it's something that they have to take time to answer and are thinking about the answer, right? I mean, there's no doubt about that. Let me go.
Well, if we saw a wider angle, we'd see if the prosecution is likewise putting
Yeah,
heads together.
that's what I'd love to see.
You see the O'Keefe's here now. Do you see that?
O'Keefe's family are coming in. Okay, yes. Thank you, Neil.
So Karen Reed is very involved in her, right?
Counsel, what I'd like to do is I'm just going to read the questions to you now. So please take your seats.
They're all on
So
individual
I'm going to
cards.
read the questions. I'm going to have them marked. Then I will take a short recess, let you all talk about it, and then come back.
Thank you.
So, all right. So I received 3 questions from the jury. The first one is, They appeared on note cards, so that I don't know what order they came in, but this is the order I got them. This is the order I'm going to read them. What is the time frame for the OUI charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The second, are video clips of Karen's interviews evidence? How can we consider them? And the third, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge?
I missed that.
So I will give you some time to consult. I think the first
Does the
one,
conviction
I'll hear from
on
you as to what the time
subcharge
frame is, and
example
I don't
number
need to hear from you
5,
now.
does that
That's
result in
pretty
conviction
clear
of the
cut what they're looking for.
higher
The
charge?
second one are video clips of Karen's interviews evidence. How can we
What's it?
consider them?
And the
Well, we
third?
know they are evidence and they can give them whatever weight they want. I would also be inclined to give a humane practice instruction, and tell me if you want the digital evidence instruction. It's a little awkward because it would be something like, before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who appeared in the communication was in fact Karen Reed. So think about that when you when I come back out. But I think it's appropriate to give a humane practice instruction, and also tell me what you think about what to say about the weight. The third question is a little bit more, I think, unclear as to exactly what they're looking for. Does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What I'm proposing, I gave you both a verdict slip where I included the language. I know yesterday I said they have to be read hand in hand, the jury instructions with the verdict slip. I've incorporated the language from the jury instruction into the verdict slip. I've given each side a copy. When I come out, I'd like your input on whether you think this is appropriate. I would instruct them, as I did before, that they start at the top and work their way down. That's the only thing I did not specifically put in here, but I think it takes it step by step, an analysis to do it. So how much time does the defense want to be able to respond to me?
Perhaps 15 minutes.
Okay. And the Commonwealth?
That will suffice.
Okay. So it's 7 past. Why don't I come out at 25 after, give you 20 minutes?
Thank you, Your Honor.
There you go.
All right, we have
what
a
a
lot
surprise.
to talk about. What a
What a
surprise.
surprise. It's that freaking page 2. If I'm the defense, I'm happy because they're obviously kicking around the OUI charge, and their concern is, well, how does that work? Because the verdict slip is so screwed up. It has one not guilty at the top, but nothing else. So what does that mean in the big mix? But clearly it's that fifth option that they're looking at, the fifth.
And Michael, we talked about this, and Neil, we just talked about this. They're wondering if they convict her of that. Does that mean that they've convicted her of all the other ones? Or right?
Yes.
They're
So
confused. If they convict her of just an OUI, and then they're also saying, and this is perfect. When does the OUI apply? Does it apply at 12:45? Does it apply at 5:45?
Yeah, perfect example of how the whole retrograde analysis makes no sense to them.
Right.
Because there wasn't a traditional OUI, stop in the road, do the field sobriety test, do the breathalyzer, all the things that most people would be used to in determining whether OUI is here you have blood test at 7:30 in the morning, extrapolated back to 12:30 the night before.
And not even a
telling you-
regular blood test. Not
I'm
even a
telling you
regular-
what she's going to do. So just for your subscribers, judges a lot of judges don't like to ad lib when it comes to jury instructions. When they start to ad lib, they get into, when they start to deviate, right, from the standard instructions, they feel like they get into to think for themselves, and thinking for themselves all of a sudden becomes a problem, right? And you invite potential error. So the judges commonly tell the jurors, you start at the top with the highest charge, and if you reach agreement, you're done. And if you haven't reached agreement, then you move on to the lessers, and you work down those. That's
Here,
not an
Neil.
answer to this question, though.
No,
No.
but listen, this here when she said that, because number one says not guilty of the offense charge or any lesser included offense. So if they start at the top, they're the quitter.
So it's
They
not
have
an
not
answer. It's not an answer. That's it doesn't answer the question for the jurors. So let me tell you how I read this, and maybe I'm just, again, I've overread jury instructions, and okay, I'm gonna offer you my take. I think that all three instructions are probably related to one or two jurors. This is my take. One or two jurors. They've been sitting around the table. They've been hashing it out, and someone keeps saying it's okay, but I think she did. What about the OWI? And someone else is saying, yeah, but if you convict her of that, there's a question, when was it? And the state's got to prove the time, and they got to prove when this occurred. And if you convict her of this time, what if that was before or after? You know, then are you saying there was an accident? What's the implication of that? And didn't you hear her clips? And someone saying it's not what she said. And the clips are just tiny little pieces. And that could be and someone saying, well, can I hear them again? And the jurors are probably, this is just my take. I could be totally wrong here, but.
And you could be totally right.
This is not 12 jurors that are all sitting around saying, you know, we're really all really close. We all have this one question, and we all are focused on the OWI, and we're all want to know what to make of the clips. This is likely one or two jurors that are just, for whatever reason, they got to convince. I had a juror in a case, one of the biggest cases I ever tried. She, by the end of the trial, I was convinced that she was out, that the best we could get was an 11-1 verdict. I was convinced of it. And then they came back and they wanted instructions read on the underlying moving violations, what's this offense and what's this offense. And the judge read them to him. And I was just like, oh my God, terrible. I didn't want these things read again. You know what I mean? It turns out that this juror was our strongest juror. She was just our strongest juror. There was somebody in the room that they couldn't convince. And she's just like, fine, we'll go out there. We'll have the judge read the instructions again. Fine. You know what I mean? So you don't know.
Yeah, no, I would agree. It's probably one or two. A couple of folks need some further help. I get it. But the video clips, I think, is interesting because it seemed pretty clear that they were in evidence.
Yeah, but I think Neil's right, Michael. I think someone's saying that's an answer. Someone's saying, "Oh, I'm not going to convict her of that." Well, let's listen to video clips. Didn't she say she was doing this? You know, I think.
Oh yeah, no, I'm not minimizing the impact. I just think the simple question about are they in evidence seems odd to me.
Can we hear them? Can we see? Because I don't think they get them in back.
Well, we had a conversation about that too, and we thought that they did, that they had the ability to replay anything in evidence. Remember, because we talked about some of the PowerPoint presentations from Burgess and Welcher. Those are in evidence. The one from Rentschler is not. The one from Wolf is. So we think they have the ability technically to play any of those visual assets that are in evidence. So again, that's why I'm confused that they would be confused. That if it's in there on a pile, whether a thumb drive or however they got it, they should know that's in evidence. But again, it may be one person who needs to be, further convinced that it's not just demonstrative, that it's something they need to consider.
Yeah. It could also be over what did she say? Like, did she specifically admit to drunk driving? Wasn't there a question about whether she drank when she was at home and then she came back and
that was never answered
afterwards?
Right.
And I know there's a question up there. I know that's going to be, so who knows? I mean,
so a broad brush.
We knew they'd come back before their morning break.
Broad brush,
So.
Linda. What? How do you interpret this from either side, defense team, prosecution?
Well, I like the last question, which if that came last, is convicting on a subcharge, for example, convict her of the above, because somebody is worried that they're negotiating, right? They don't want to convict her of the above charges, and they're worried if they convict her just of the OUI, they then convicted her of the manslaughters, because you can't tell heads or tails from this form, right? So I think I think they've dismissed the murder. If I had to take a,
I think that's
safe bet. Right. And now they're worried because somebody wants to compromise and they want to compromise at the OUI, and somebody's worried. If I'm the defense, I'm happy. And somebody's worried, well, if they do the OUI, then they're going to convict her of the manslaughter because they don't know the effect of what they do with this jury sheet. So that's why
if I'm in the defense, I'm ecstatic because number one, their focus is on the OUI and it's on the confusion in the jury verdict slip. Right. That confusion ultimately helps the defense. No matter what the ultimate outcome is, that confusion helps the defense because they're going to have a major argument that if they unfortunately have a conviction they can't take, they're going to appeal. And once again, that ugly verdict slip is going to raise its head, and it's clear jury members don't understand it.
Right.
This is substantially, listen, I respect the jurors asking that last question. I really do. I hope the judge answers it. But to speak in a circle with a point, that is why judges will sometimes go back to, well, use your collective reason, your collective memory, which is a terrible answer. And the other is, well, we think you ought to. Well, let me tell you. Let me read this again. How to handle the main charge and the lessers. They have a very specific question. They just want to know. It's very straightforward. If we find her guilty of a lesser, of this specific lesser, what's the implication of that? They're not asking for sentencing. They're not asking what she's going to be sentenced to. They're trying to figure out if we convict her of drunk driving, does this mean something more than just if we convict her of drunk driving?
Right. Right.
Yeah,
I wish you just answer that. I wish you just say yes or no, like no or yes.
She should effectively say, well, here's what the form should say. Guilty or not guilty as to each of those underlying charges.
You could say it very easily, right? We could do it right now. If you think she's not guilty of everything, then you just check not guilty right at the top, and then you're done. But if you're considering less serious offenses, then you go through each one. If you think that she's not guilty of the primary lesser offense, then you move on to the next one.
Yeah. Basically, a blank is not guilty. That's one way to explain it as well. If you leave it blank, that's not guilty.
If you leave there you go. If you check something, but if you don't check anything else, it's a not guilty.
Yeah.
So. All right, guys, I got to go. You guys are the best.
All right. Thank you very much for your input at a time that we needed it, just as the
perfect timing, Neil.
Perfect filler. I filled the air right up until you got some notes.
Okay. Thanks, Neil.
Thanks, bud.
Okay. Bye, guys.
Rock on and let us know if you want to come on when there's a verdict.
You bet, guys. Talk to you later. Thank you.
Bye. All right. So the drama continues, but I think it's become focused. And again, if I'm the defense, I'm liking everything I hear, and I'm also pissed off because they didn't clarify the verdict slip early on.
Yeah, I know. And then, of course, the defense is probably wondering, wait, maybe we shouldn't have asked for that OUI charge because then they would be not guilty on everything.
It's such a calculated risk, and I'm sure obviously they talked to Ms. Reed about it to find out, here's the, potential penalty if they do bite on that. But to give the jury such, I'll use this word because by comparison, it is innocuous, right? A straight OUI under the circumstances in this case, that's like jaywalking. And so, so they throw that out there, give the compromisers something to bite on that doesn't bite our client. And it's, it's really a win. So everything with that, if that was the thinking, it's playing out.
Yeah. This if that's the thinking, it's absolutely playing out. Wow is all I can say is just wow. And
what about this? If in fact it was Hank Brennan saying, I can't do this again, I can't do this. That means he's interpreting what is happening as leading toward a hung jury, which I think would be an interesting interpretation.
Yeah.
Because I don't interpret it as heading toward a hung jury.
No, I don't interpret that either. But we did hear him say, I can't do this. I can't do this.
Yeah.
I can't do this. I can't do this. So you heard again, I can't do this.
I did. I'd have to listen to it one more time. But I could have sworn, because that would be the operative word to me.
Again, right.
Yeah.
It was an interesting mic moment. Okay. So I just think that Neil is right, though. Kind of interesting that you have somebody who wants to answer one of the questions, because she said that she got them on like a notebook paper, and she doesn't know how they came in
on
first.
the cards. Yeah.
Yeah, and so, but the way she got him is, and if it is 12:45, it's a great question, actually. What are we supposed to be talking about OUI for, right? Are we talking 12:45 or when she hit the car in the back? What are we talking about?
So that makes it even more confusing as to that blood alcohol level information, which we've talked about the whole retrograde analysis, how accurate it is. There's a lot of missing information.
Right.
What happened after 12:30 and before 5 in the morning? Was she pounding shots? None of that information is available. All that is available, this jury would have to believe that the science of that retrograde test, a clinical blood test, right? Not for legal purposes, a clinical blood test using the retrograde analysis gives her a BAC above the legal limit. That's it.
But that's using a test that they say is not for legal use, and that's the
but
problem
somebody,
here.
maybe 1, maybe 11, somebody is giving it that weight. So who knows? Maybe it's 11 people that think it's not, and one person needs to be convinced that it is not conclusive, even on an OUI.
Yeah, well, but then the fact that somebody added 5 a.m. I'm saying, well, I'm not going to find her guilty at 12:45. Well, what about 5 a.m. when she went back out? Maybe that's
well, I don't even know. I think about that. That's irrelevant. I mean, who cares?
But that's what they're saying. But I know, but that's what they're trying to. Maybe that's the alternative. Well, what do you say? You say that she was drunk at 12:45, or you say she's drunk at 5? What are we here for?
Well, okay. I think that suggests to me this person or persons who have that question are wondering if she had alcohol in the time period after she left 34 Fairview and before she returned to look for John O'Keefe's body. So they want to know, has she been drinking in between? And if so, we're not going to blame her for what happened at 12:32 if that was the OUI moment for what she drank afterwards. So that's the only relevance I can find to that 5 o'clock hour, because you might as well have said 7:30 when they took the blood test.
Oh my goodness gracious! And then the second one was, how can we consider the video depth? So we consider the video depth. As a matter of fact, I posted the actual questions on our Twitter account, our ex Twitter account. So with the 3 questions. So let me just go to that so I can get them exactly, and you can go to it too. And I said what Neil said, that the ugly slip raises its ugly head, the verdict slip. The last question we believe is helpful to the defense. Number 1, they want to know if they convict her of drunken driving, OUI, I put drunken driving, what effect on above? Judge should answer directly, no, not guilty to above. That's what I put in our note. What is the time frame of the OUI charge, 12:45 or OUI at 5 a.m.? Are the video clips of Karen's interviews evidence? How can we consider them? Does convicting a jury on subcharge, for example, offense number 2, 5, convict on the overall charge? Yeah, right?
Yeah. And some of the chat flying by, I've seen people suggest, well, this is good because, again, these are Karen Reed supporters, that means that they don't believe there was a collision. And I can't disagree with that, right?
Right.
So it seems the focus is totally on alcohol. Right.
That's what it seems to be right now. At least this is, right? That's pretty good. I mean, if that's the focus.
Again,
because why would they care?
I'm happy about that.
Yeah, why would they care about an OUI if they found her guilty of murder? Why would they even care?
And that really, the collision aspect wipes out everything but the OUI.
Yeah, right. Which the defense asked for, but we'll see. I mean, it may be, that may be the compromise at this point. Who knows? We don't know. We don't know.
No, we're just spitballing here, based on experience and the questions we're seeing in this case compared to the evidence that is and isn't in this case.
Now, somebody was saying there's Alan Jackson who said, "I can't do this again. I can't do." I heard it was from Hank Brennan. I heard
it sounded more to me like Hank Brennan,
right? From his microphone. It was not Alan Jackson. That was Hank Brennan. And all, no doubt to me. And I'm sticking to that. If I'm in the jury room, I'm sticking to that.
Yeah. Yeah.
Yeah.
I
But now we
agree.
have to worry about what Judge Beverly Cannoni is going to say, because you know that most judges will just answer things very easily, right? Or go back to a charge. They won't like start making stuff up, okay? Because the answer should be on 12:45. That it's only at 12:45. They weren't charging her with 5 a.m. driving. The
No,
prosecution.
that's why, again, that's only relevant if they were trying to excuse whatever the blood alcohol content retrograde result was. And they're saying, well, what does that mean to us? Doesn't mean anything, because we don't know what happened between 12:30 and 5:07 or 12:30 and 7:30. So I think it's a smart question. I'm not sure they're going to get an answer. What would the answer be to that? They're going to say, you'll have to look at the evidence. You know,
Right.
that's the answer to the first one.
That's the answer in the first place, except for the fact that the prosecution never was charging a 5 a.m. drive. But let me ask you about this. They used 12:45. Now, that prosecution said that's when she pulled into the car. She actually, according to the evidence, pulled in to hit the Wi-Fi at
12:36.
At 12:36.
Yeah. So I don't
She wouldn't
know.
be driving then. So then,
No.
what are we talking about here?
12:45 was the first trial. Remember?
That was the first trial. Right. That was the first trial. That was not this trial. So that can't possibly be, because she wasn't driving at 12:45 a.m. unless you buy the prosecution theory that she was driving back into the house at 12:45.
Yeah. And again, that's not a charge. The charge relates to the time that any incident took place, not 10 minutes afterwards.
Right. And right. So therefore, I mean, that's another problem. So they can't answer that. The judge can't say it's 12:45 versus 5. You have to rely on the evidence. That's what the judge has to say, right?
I would hope, but I think it's going to be a bail. It's going to be, you have to, I'll leave it to your recollection as to the state of the evidence on that issue, blah, blah, blah.
Well, I think the defense is going to say, the defense has to come back and say, Your Honor, there's been we were never charged with 12:45 or 5 a.m. The whole time was at 12:32. So we want this jury to be told they cannot consider those times for a charge.
Yeah, good luck with that.
I know, but you got to make the record, right?
Yeah. Oh, I agree. And I think the simplest, I'll repeat what I was talking to Neil about, the simplest fix for that final and most important question relating to the jury verdict slip is just to let them know, if you don't mark a box, that's not guilty. That's it. That's all you need to know.
Yeah.
That's it. So it shouldn't be this difficult. It just shouldn't be.
It shouldn't be this difficult. But that's when you have this. This is the creation, okay? This has created these problems again, all right? And the video evidence, how can they consider it? Somebody may be saying, oh, well, somebody may be saying, well, she said it. We'll go back and look to see when she said she was driving, when she said she had a buzz. So I guess they're considering it. Maybe they're saying, do we consider it as primary proof? They're looking for more than, it's an evidence. And the judge wants to give a technical charge on a human. What was it? What was it?
Yeah, I made a note of it, and I can't read my own note. But she said she's definitely going to give that a human factor. Is that what she said?
That's what I thought she said.
Factor. I'm unfamiliar with. I'm sorry, I'm unfamiliar with that. So I might want to look it up real quick here.
And she was going to give the digital evidence charge. So you have to be.
Yeah, which she felt was convoluted. And then she kind of read it to the parties, just almost to say, well, what do you think? This is what it sounds like.
And then I don't know. She was going to give some other charge. I don't know what she was going to give. She should just reread humane instruction charge. Sam Poop said it's a humane instruction charge. Here goes the fan. By the way, one of you earlier asked my glasses. I actually had to take them off and take a photograph because I couldn't read the inside. Robert Mark from New York City, and Mark with a C. Robert Mark from New York City. Okay.
Just doing some research here. Okay, looks like they're back. Let's see what's going on.
Okay, let's see.
Proceeding, court is in session.
All right, so I will hear you on the first question, the time of the OUI. Any suggestions?
Your Honor, do you want to hear from the defense first?
I'll hear from you're standing up, so I'll hear from you first.
Okay. On question number 1, what is the time frame for the OUI charge, offense 002, section 5, OUI at 12:45 or OUI at 5 a.m.? Our suggestion would be something along the lines of, ladies and gentlemen of the jury, you have the evidence. It's your decision.
You are the fact finder.
You're the fact finder.
Mr. Brennan, or whomever from the Commonwealth,
My suggestion would be 12:45.
and why is that?
The case has always been focused at that time. I don't think there's anything specific in the indictment regarding the time.
Do we have the indictments?
No.
If it's not in the indictment, I'm uncomfortable telling them a time.
I'm sorry?
If it's not in the indictment, I'm uncomfortable telling them a time.
Understood.
All right.
I agree with the court on principle. I just don't have the indictment memorized, so I don't remember. If we can pull that up.
There's no time? I don't expect that there's any time. To be
All right. So I'll say you have the evidence, and remember, you are the fact finders, or something to that effect. All right. Are the video clips, Karen's interviews evidence? How can we consider them? So I'll tell you what I was planning on saying, then you can add to it.
Sure.
Yes, the videos are evidence. Give them whatever weight you think is appropriate to give them. And then I would give the digital evidence instruction and the humane practice instruction.
The only thing I would respectfully ask the court to include in that sentence is give them whatever weight, if any, you deem appropriate.
All right.
If any.
Okay.
Thank you. Otherwise, it's fine.
Okay. What's the Commonwealth's position?
We have a different perspective on that.
Okay.
The first part of the question, are the video clips of Karen's interviews evidence? The answer should be yes.
Okay.
How can we consider them? I think it's fair to say you should weigh the defendant's statements as you would evidence. Since they've been introduced substantively, they are like any other piece of evidence. There's no difference, and there shouldn't be any reflection of a difference in the answer. We didn't introduce any evidence in this case and say you should give it any weight, if any at all. We didn't provide a limiting instruction in any way, and these shouldn't be so limited. This is just like a photograph. It's no different than a physical piece of evidence. And so I think the answer should simply be yes. You should weigh the defendant's statements as you would any other piece of evidence. I do not think the court should give humane practice or digital evidence. It suggests that there's some deterioration or further analysis that is different. Those instructions were already given during the charge. In addition, those instructions are in their hand in the written jury instructions. And so, to put it most simply, as I think that we should, is this is a piece of evidence, and you weigh it like you would any other piece of evidence, whatever they decide, rather than give them guidance to curtail it or to limit it in any fashion.
My only suggestion, Your Honor, is that every single piece of evidence that's provided to them, it's in keeping with Massachusetts laws, in keeping with the responsibility that they have. Every single evidence is given the weight, if any, they deem appropriate. That is not a misapplication of the law. I think the Commonwealth suggestion suggests in the answer that they should or they have to give those statements weight, and the law is they don't have to give them any weight. So I think the appropriate comment by the court is exactly as the court suggested initially, which is you give it whatever weight, if any, you deem appropriate.
She's trying to figure out how she can give the Commonwealth more, in my opinion.
that human factors instruction basically says if there's an admission, you have to find that it is voluntary and intelligently made. In other words, she's making these statements on these interviews voluntarily. So she's going to give that instruction. That I don't think is an issue.
I'm telling you though, Michael, she's trying to find how she can give Brennan more, right? Because he wants more. He wants basically,
Yeah, he wants to put a time on it. I'm surprised she immediately poo-pooed that. In terms of the video evidence, I don't know what she can do other than say it's in evidence and give that human factors.
Yeah, it's in evidence and give it the weight, if any, right?
Yeah, if any,
if any, right?
If any, that's yeah, because you don't want to say give it the weight it deserves. That leads them.
But she's like, that's what she's looking. She's looking to see what else she can do.
You sure she's not working on the third one?
No, because he objected to the he objected to the weight, and so she's now.
I don't know where she can go that helps them.
Well, she's trying, in my opinion. But I think the telling question is, if we convict her of that, does that mean she gets convicted of everything above it? That's telling. They don't want that to happen.
No, and that would also be, I think, a contradictory verdict form slip. I don't think it would be upheld on appeal. It doesn't make sense.
All right, so what I'm going to say is, yes, the videos are evidence. You should weigh the defendant's statements as you would any other piece of evidence and give them whatever weight you deem appropriate. But first,
she left out if any.
Read the electronic communications and the humane practice. That covers it.
If the I don't have a principled objection to it if the court adds the word if any.
I understand.
Because every single
She's not going to do it.
To think, for instance, the way that it's worded as the Commonwealth suggested it, they have to weigh it the same way they weigh other pieces of evidence. Every single piece of evidence is weighed in and of itself. It's individual to the piece of evidence that's presented. For instance, they could weigh the statements by Ms. Reed. They could give it no weight. Each individual juror could decide, I'm going to dispatch it altogether and give it no weight, while giving another piece of evidence, like whatever that might be, the testimony of one of the ARCA witnesses, complete weight. I think that we need to stress that the clips bear no additional weight, no additional gravity than anything else that they've considered. And the only way to do that is very simply, you give this the weight, if any, that you decide is appropriate. It doesn't, I think, comparing it and contrasting to other pieces of evidence in the case, it's unnecessary, and it tends to suggest they have to give it weight.
Okay. So your objection's noted. Now let's get to the.
Thanks,
After she said she was going to
one.
give it, she changed her mind. Okay, because there's nothing else she can do for the Commonwealth, so she took that
Does
out.
convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? What do you want to say, Mr. Jackson?
No.
Your Honor, I appreciate the effort that the court went to amend the verdict slip as it relates to count 2. And I think there are some excellent suggestions by the court in the verdict slip. By and large, I think question number 3 is answered by the amendments in the verdict slip. So we certainly could say something like, does convicting guilty, the question was, quote, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? The answer is no, obviously. And perhaps
That's
we
it.
could formulate an answer that says something along the lines of, no, new verdict slips have been provided that will make it more clear, or something of that nature. As well as a decision of guilty on the OUI charge 002 number 5 is an explicit acquittal on the higher charges in offense 002, which is a proper statement of the law. And then there are suggestions that we have regarding the edits that the court has made to the verdict slip. And
Wow,
I'm happy
there's
to go over
edits.
those with you and put those
Okay,
on the
go
record.
ahead.
We need the edited slip. There's been edits.
With regard to going from the top to the bottom, just under number 1, number 1 reads, not guilty of the offense charged or any lesser included offense. We would propose that the court add the language, the consistent language that it's added throughout the verdict slip. If you quote, if you find the defendant not guilty of the offense charged or any lesser included offense, comma, stop and sign the verdict slip, period. That's the only place that that language doesn't appear, and I think it should appear.
Okay.
The second is a relatively minor issue. However, under number 2, sub 2, the parenthetical check one or both of the following, I think it should say, just to clarify it further, if guilty, comma, check one or both of the following.
All right. I think I'm going to leave it because it appears only under the guilty.
It appears only on,
Under the guilty. So go ahead. I'll hear you further.
going further, going under number 3, toward the bottom of the page, in the parenthetical that the court suggested, which we find is excellent. If you find the defendant guilty of the lesser offense
Okay.
of involuntary manslaughter, we would simply add that clause.
So we'd have to add it in all of them,
Correct.
which makes sense. I think
Correct.
we had it in the first one.
Right.
Okay.
And then moving to page 2, at the top of the page under sub 4, again.
Hold on one second.
Of course.
Okay.
We had the same suggestion. It appears that the court is not inclined to give it. If guilty, check one or both of the following. And there's a typo. It says the parenthetical
We
says
fixed it.
check one of. Okay.
Yes. So we changed of to or.
So my only suggestion to that would be to, again, add the if guilty, comma, check one or both of the following.
Okay.
On that page, going down to the bolded parenthetical, same thing. If you find the defendant guilty of the lesser offense of motor vehicle homicide.
Okay.
Moving down under sub 5, the
We still
OUI.
need to say stop and sign the verdict slip.
Right. After the word stop and sign the verdict slip.
Yeah.
And then under sub 5, again, the same thing. We just suggested for consistency that it say, if guilty, check one of the following of the both. And the final edit would be in the final parenthetical, the last sentence. If you find, I think her should be
Yeah.
changed to the defendant. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1.
Okay.
And those are the edits that we have suggested for the verdict
All
slip.
right. Mr. Brennan.
I don't have any disagreement with the edits.
Okay.
The idea of instructing them on the nuance of selecting one guilty or not guilty, I don't think needs to be explained. I think that the edits, this proposed instruction explained it.
All right. Would
I
I,
don't have any issue with if you state, if you decide on a lesser included offense, it does not include the earlier offense. And I'm not sure of the exact language that can be. I don't think that's necessary, but that is something I wouldn't have an objection to. But I think the form that you filled it out with the edits is going to be sufficient for them to follow.
what do you think about the defendant's position that if you were to find her guilty of operating under the influence, Mr. Jackson said explicit acquittal. I don't like that language. I think if you find it, it means you have found her not guilty of each of the others.
That would be fine with us.
I think it's better if you find her guilty of any lesser included offense. It would not include the higher offense.
All right.
I think that's just confusing.
So what I planned on doing was bringing them out and giving them each a copy of the amended verdict slip, explaining that it really is consistent with the jury instructions I gave them, but walking them through it. So we start from the top and then explain, if you find the defendant guilty, you're done. Stop, sign the verdict slip, and let the court officer know you have a verdict or something.
I prefer that.
Yeah, I think I'll walk them through it like we do in civil cases.
I don't have any objection to that. The only other thing is the digital instruction.
Yes.
We don't believe that it's necessary. I don't think that we should reemphasize that, and we're not asking for it. That
All
would
right,
be-
so you're waiving it?
We're waiving it.
Okay.
Yes,
All
thank
right,
you.
I will do humane instruction, humane practice instruction. So I need 5 minutes, and Tori, your computer, to amend this if we can, and we'll make copies. So we'll bring the jurors in. Let them know that we'll be bringing them in shortly, Tony. All right, thank you.
All right.
Oh my. Okay, hey, welcome to the conference that should have taken place last week.
Right. And should
I
have
mean,
been
that is
how the attorneys were able to sum up.
I mean, to be doing this now, although I guess we should be glad that she's acknowledging some issues and that she is sort of kind of trying to clarify them. This should have been done last week. And she was hesitant to do it because she had been upheld by the judicial supreme poobah. It's just inexcusable. It's just not the way it should be done. And who's the ultimate, penalty for? Not just the jury, but obviously the defendant in the case. The whole system gets screwed over because she was too proud to look at this the first time through, see the inherent errors in it, and fix them then.
Yeah.
So what do you think about the fixes? Are we close to getting it better?
We're getting it better, but you know what? Clearly, she now knows that there's a problem. The jury's, she tried to help along getting a verdict here, in my opinion, with this stuff. And now there's a problem, and the same problems we talked about. We specifically mentioned yesterday, Michael, and I think we were the only stream that mentioned that if they get down to number 5 and want to convict her, they're going to want to know if they convict her of that, will a convict her of the above things, and that's exactly the question they're asking. Exactly.
Because somebody is either wanting to convict her of something else and make it apply beyond OUI, or somebody doesn't want to, or more than one person. But there's clearly some division or some misunderstanding as to what that ultimate check would mean on just that box.
Yeah. Texas Sister said, thank you for the donation. He said, that was definitely AJ. He said, Bob, I can't do this, as Alessi was leaning in. Then he backed off when AJ said that. Okay. All right. Yeah, this goes to show you how we
want to look at it again.
Right, we will look at it again, how we hear evidence. But thank you. We're going to take a real close look at that, Texas Sister, because of your input. Tanya Carr, can the judge tell a jury how much Karen can serve time in jail convicted on the OUI? No one is to tell the jury what the OUI
none of the penalties are their concern.
Yeah, and then so they never do that. Meg, she admitted to being drunk at midnight in the clips. If the clips are evidence, she is guilty of OUI at midnight. See, that's why it's been very interesting, because even the indictment didn't have the time now, and so everyone's been thinking the OUI is at the time of the alleged collision, but now we've got an OUI, which could she anytime. Why don't you go back and convict everybody else of OUI for that?
Yeah, well, we've had those comments, and obviously somebody else's guilt doesn't mean you're less guilty if in fact you're guilty as well. It's it's relative deprivation. It pisses people off, but that's a fact. There's a lot of people driving around that shouldn't be driving around that that aren't getting caught, ticketed,
this is a good one. Mr. Bryant, I'm interrupting you. Mr. Bryant, I'm interrupting you. That's a clue. Mr. Bryant, I'm interrupting you. That's a clue. Okay. All right. Oasis Cat. I'm sorry. I wanted to make a point by interrupting Michael and making a point, Mr. Bryant tells you that I'm not considering him like human, right? All right.
Right.
And here's the question.
and the if any disappeared, which I thought was, yeah, ultimately maybe it doesn't mean anything, but the subtle inference is that, well, you've got to give it some weight, right? Here's this evidence, give it the same weight you might any other evidence, if any. So now you got to give it some weight, apparently.
Here you go. Parading. This is why, Mr. Bryant, I was interrupting you and talking to you, okay? And I know you can't see this because of the
I can
weather.
see it now. I can see it.
Per Aiden, in their note, the jury refers to Karen Reed as Karen.
Nice.
Not the defendant, not Miss Reed. They're calling her Karen. That is why the defense is smiling, ladies and gentlemen. That is exactly why the defense is smiling. Julia Nielsen, could the judge know any verdict at this time? No, she doesn't know anything but what she sees here at this point. But we all kind of figure out what we think the jury is saying, right? We all kind of figure out what we think the jury was saying.
And it sounds like the verdict slip had some modification to it even before this.
Yeah,
there was something that had changed.
Yeah, it's something
maybe not enough to make it clear, but something had been changed.
Maybe when we take a break and they go back in, you could go across the street and get the verdict form. If indeed they have filed it, the newer one when they file
I'm not counting on that. And then the one, the new and new approved one, that one will never, it's not going to see the light of day.
We didn't have the old approved. What was filed yesterday was the one we all had, the 3 pages. Then apparently there must have been some concern, and she must have rethought something and all. And so she apparently had an improved one. Maybe that's what was discussed and it was going to go into the jury, okay, when they came out with this form, okay. 007 Texas, we are family. I got all my JSTV stuff. Thank you very much, 007 in Texas. All right, so what's happening out there on social media? Can you tell? Michael? Oh, he's on to mute. I'm sorry. He is on mute right now. Okay, so we have a lot going on here. A lot going on there. Okay, so there's questions about this verdict sheet, which of course we've all been raising. Maybe the judge heard it finally. And why would the judge want the jury confused? Because it's easier to come to some kind of verdict that, well, there's 5 guilties, 1, 2, 3, 4 guilties. That must mean we have to charge guilty on one of these. It's ridiculous.
I'm sorry, I'm back. I was answering questions from passersby.
That's okay. No, that's great. That's great. What I want to do is I want to look at seeing what's out there on X right now. We are all tweeting on X, and everyone keeps following all of us, and we follow everybody else. I think Neil's breakdown was right, though, right? Okay.
The question that I was just asked again by passersby was that, hey, maybe we're all just getting duped into thinking it's going to be this OUI conviction. Yay, that's the best case scenario, absent a total acquittal. Maybe that's not what's happening. Maybe that the jury is actually looking elsewhere. Of course, anything's possible. This could be just to convince one person that if we take the OUI, that it takes everything else off the table, and we don't want to do that, right? We don't know. We don't know what the interpretation is. I do think the reference to Karen is huge, but it's not dispositive, but it's pretty interesting.
It's interesting that she didn't read that. The judge Kenney didn't read that. She just read really the questions, But see, that's why you have to be in the courtroom, because Aiden is there in the courtroom and reporting. I also, quite frankly, I mean, first she said she's going to give the if any. That absolutely right. That's the charge. That's Massachusetts. No problem. Then as soon as Hank Brennan opposes the charge, I told you when she started looking through those papers, she's looking for something to try to help him. So she can't find anything to try to help him. So she removes the if any. They're supposed to. I mean, that's what they're told. If any is in a particular, it's clear.
Of course,
that's in all his instructions. How can he remove it? How can he remove it?
I do think some of the things Alan Jackson asked for, which I'm assuming are being now incorporated in the new and improved verdict slip. I was surprised she was okay with. He talked about if you find she's not guilty of anything, then mark that box here and stop. And sign the form. You're done. that's very definitive and very helpful. May not matter in this case if they're truly looking at the OUI as a lesser included,
Right.
but it's something. You know, it's helping give the jury direction that they don't have now.
And what you may have too is that this is the classic compromise that they have decided no collision, no collision, no collision, but somebody wants something and says, well, something. Somebody wants something,
Yep.
but then another juror says, well, if we give you the OUI something, does that mean then that they want to know the implications of finding her guilty of an OUI on a compromise verdict, in my opinion. Okay.
No, I agree, and I think that was the reason the OUI was tossed in there by the defense, to give them a compromise that doesn't really hurt. You know, you put that word in quotes. It would be a best case scenario conviction. So let's talk about that for a second. You know, let's assume somebody comes in to court, they've been pulled over, they've got they blew the field sobriety test, they blew a .14, and now they're facing the court. First offense, no priors. What do you think happens in that scenario?
Well, normally,
in that scenario, yes.
Normally, you'd get probation. You know, you
pay a fine. There's a fine.
Yeah, and you know, I could check with my friend, and maybe he can come on if we do have this as to what the implications are. But I don't even know that she would sentence right on the spot if there's an OUI, right?
I wouldn't think so. And you'd certainly, again, normal scenario, you'd be released OR and you'd have a court date to come back, and that'd be it.
Right.
So I guess my real question is, you know, and are we so suspicious of what the court might do in this case that she would do something extraordinary that you would not normally see in a very typical OUI conviction?
Well, to me, this sounds like, right now, if I'm the defense, I'm happy, because to me, this sounds like an acquittal on all of the important charges relating to the death of John O'Keefe. That's what this sounds like to me, and that's why they, you know, because I can't imagine them being in agreement on the collision. You know, I can't imagine them being in agreement on the collision, that a collision happens. What I'm saying,
right.
You know, because the prosecution, in my opinion, didn't prove it. So this is what this feels like, and that's why the defense is happy. But you and I said that we get an idea from the jury about between 10:30 and 11. I can't believe we called it 10:30 and 11 today, and here we are. You know.
Yep, right on the schedule.
Right on.
So now I think the other thing we can, again, you know, we're all spitballing here, but I think the other thing we can be confident of to some degree is that we're going to have a verdict of some sort.
Right.
Today.
Right.
How quickly? Who knows? They're going to come back. They're going to get this explanation, questions answered, and then they're going to go back to deliberate. I think, of course, one of the critical questions for Judge Kenney during the course of this trial is lunch, right? She'll stop arguments dead in their tracks to make sure that lunch is handled, you know. Mr. Jackson, lunch is here. So, you know, so they should address that. Whether the jury can continue their deliberations and have their lovely lunch, and then they'll come back with their decision.
Yeah, that's so. By the way, okay, Rhonda, Iowa girl, thank you for that donation. Really appreciate it. I went back and looked at the tape 5 times. It was AJ saying no to Alexi. It wasn't, but okay, we stand corrected then. It's just that's why sometimes eyewitness testimony is not so good, because we were watching it, we heard it.
That's right. And the worst direct evidence is witness testimony.
But having said that, this is what juries do too. Okay, I maybe I was wrong, and even if you're right, sometimes maybe I was wrong, you know. But we're going to defer to the person who's we've given.
I will definitely be listening to it myself later, but I have no reason to dispute that.
Yeah. Thank you very much for that. Thank you for taking the time for that. You know, and also we really appreciate it. Okay. So we are monitoring the live court feed. Obviously, as you know, the judge said she wouldn't be back until what time did she give here?
I think would she say 20 minutes? I don't know.
She said 20 minutes. And all she needed 20 minutes was the first time to give them time to come up with their responses. Now she has to go back and do the new improved,
and then make copies of it. And and she said to tell the jury that we'll be calling for them soon.
Right. And the jury's in there now wondering, okay, what did we do here? Is this going to, you know what they want to do? What was this going to happen every time we ask a question? Are we going to be stuck here for another hour? You know?
And I have to assume during this down period, they're still talking. They're still, they're still trying to figure out, okay, what if the answer is this? Then what does that mean? What if the answer is that? Then what does that mean? I don't think they're just sitting twiddling their thumbs.
I can't remember which case it was, but I had a civil case where the jury asked a question, and before we could go back with the answer to the question, they knocked and had a verdict. And I think we've seen that in some criminal cases too. That all of a sudden they're like, "Hey, let's just answer this ourselves and get out of here," right? You know.
Yep. I mean, those are some of the human issues. They've done a lot of work, 11 plus hours. They've boiled it down now to some very specific issues and questions that tell us they're getting very near a decision of some sort. So at this point, it's like, okay, what can we do to speed this up? We're done. We've done our job. Can we just fine tune this and hand it in and get the hell out of here?
Yeah, well, I think that third question is the most important. If we
Of
find her
course.
guilty of, for instance, the OUI, let's say count 2, number 5, will that find her guilty of all of the above? Okay, and I think that to me is the most important question they had.
Sure, of course, and it just relates back to the craziness of that jury instruction, that slip, because it's a slip and fall. It's a mess. It should never have been that way, and the fact that she's now tweaking it, I don't think it's 100%. I think the one that was offered by the defense prior to deliberation was fine. If anybody saw that, it was very simple. Each lesser charge and then a guilty, not guilty box beside each one. That's it. That's it. And now she's kind of coming up with some bastardized version of that. So it has some better clarification, but it's still not as simple as it could have been.
Oh, Michael, what a mess. And now she's trying to correct it because I think she sees now the handwriting kind of on the wall, and she doesn't want to now be in a position that what she does is created an issue that would get her reversed. Right now, she's put in everything that she could put in, except that she still tries with the taking out the if any with, no problem with that. That's what the law says, and then takes it out. Right. When Hank Brennan says, well, they're in evidence and she said them and therefore they have to have some weight. What do you mean? No, they don't.
That is not true. No,
not true.
No, that is definitely not true.
That's simply not true at all. By the way, how were the crowds this morning? What was happening? We never got to talk because we came right into interviews with 2 guests and
what was the question?
You've been there.
What was your question? What was your question?
The crowds. How are
the crowd? Yeah, it was
or anything.
Yeah, well, and I did post a little video to give people a sense. Right across from the courthouse, the Trevi Fountain, I'm now calling it, the Hall of Records there, the Registry of Deeds, not nearly as packed as yesterday. And so, and I've talked to enough people who, they got lives, they got jobs, so Friday might have been an investment of time. And then those who decided over the weekend, I'm going for it. Like the friends I spoke to from Nashville and from Tampa. One of them was heading out 6 o'clock tonight. She had a flight out later tonight.
Right.
So people got, they got to work. They can't just, do what we're doing, kill time here every day. They've got to.
We're working too.
Got to go.
We're sleepless. Sleepless in Dedham.
Sleepless in Dedham. Dead in Dedham.
Dead in Dedham, right? The people understand that we still have our work, and Thursday is a federal holiday, and if we have a verdict before this, I expect that we will all be taking that federal holiday to celebrate Juneteenth.
Yeah, I have so many things that are pressing on me. I can't wait to relieve that pressure and get those things done. Yes.
Think about all of this. Now, we're talking about that with regard to a possible compromise, but they may get in there and say, look at all this. This is ridiculous. We went down, we have this charges. It could be 1 or 2 people. It could be 1 or 2 people, right?
It sure could be.
So whatever it is, look, every side, whether you're for the defense or in the sense that you don't think the prosecution has proven their case beyond a reasonable doubt, or you're for the prosecution because you think that they have and you think that they've proven something. Look, it's giving their all in this case. I can tell you that the attorneys are probably exhausted. I don't care who you are.
No doubt about it.
Yeah, the attorneys
and that's when they get frustrated and a little snippy. As I mentioned yesterday, when they were leaving, clearly the tone had changed.
Right.
I think it's better now.
Right. They're coming back into the courtroom, pursue right now. So
Okay.
let's go. Let's listen
Can't
to
wait
this.
to hear this performance.
Yeah. Yeah. By the way, Brian B. sounds like Commonwealth didn't prove when the OUI was. Yes, they certainly didn't prove when any OUI
That
was.
reinforces, if that's what it ultimately becomes, it's total compromise. It's because there is no clear evidence of that violation. I'm not even going to call it a charge.
Well, there was no charge. There was no charge in the
know.
indictment for the single driving while OUI. So, if anything, it was at the time of the alleged collision, because that's related to the other four, the 2, 3, and 4.
Because if you think about it, in theory, if somebody through this retrograde process is proven to be above the legal limit, then they were driving. She left the scene and went to One Meadows. So all during that journey, which was up through 1236, she would have been OUI if you believe the retrograde application of So, pick a time. pick any time she might have been on the road. It's a compromise.
But as I said, Massachusetts has a severe penalty. One of the most severe of 2 years, I think 2 years plus in prison for an OUI. So this judge, if she's responsible, Karen Reed is not out of the woods yet, even with the compromise. And then, of course, if that is, if it is a compromise verdict and it does lead to the conviction on that, then, of course, the defense who asked for this to be included will be wondering whether or not they should have asked in the first place, since it wasn't in the indictment. It wasn't in the indictment as to the time of an OUI.
Yeah, that would be a different level of outrage. The penalty technically is up to 2.5 years in prison. There's some fine, also a fine involved, and it is the total discretion of the court. And so she would have to, at the time of sentencing, give her basis for a first offender with no other history of criminal activity, her basis for increasing or giving what would be far greater sentence than a first timer normally would receive.
Right.
I'm not saying she can't do it, but she'd have to do it.
Yeah, no, she's well, we've seen her conduct, so she also didn't read the whole notes. The fact that the jury is calling her by a first name, no one is convicting of her murder calling her by her first name. Okay? It's just not happening. It's just not happening. Okay. So I don't see, well, I don't know what she's going to do. I don't know. It's like, it's well, you kind of know if it's going to be helpful for the defense, it's not going to do it. That's kind of the rule in this trial.
What I think is interesting is, and this is telling in terms of sentencing, and again, we're getting way beyond ourselves.
Yeah, because we don't know. Right.
We don't know. But second offense OUI, third offense OUI. Any idea what the max jail time is for second and third offense?
No.
2.5 years.
Oh,
it's
my
the same
goodness.
max penalty.
Oh my goodness.
So
doesn't make any sense. Okay. It's if that happens, we'll try to get somebody who's an expert on. Okay. Joey Kane wants to know, will she not be remanded today on an OUI? That depends on what the judge wants to do. Bail, right? Totally.
Totally.
The judge wants to make a big scene and all,
It would be that would be, to use one of your used words, outrageous. I mean, unbelievably outrageous to take somebody into custody on an OUI, with no priors and no injuries resulting from the OUI.
Right, because they would have found none. They would have found that this didn't occur. It would just be a straight, complete OUI as opposed to any impact. But it's not without the realm of possibility. So Brian B, knowing Bev Canone, OUI will have a trial tax. Trial tax is when you go to trial, and which you would normally get if you didn't go to trial. You end up with a big sentence, and we see it all the time. Okay, pursue very quiet as we wait for court.
I can imagine.
Oh, I can imagine how it's quiet. And we're spitballing here because maybe this is just one person. Maybe they have found her guilty on something.
You're right.
else. Who the hell knows?
You're right.
But it sounds like if they had found her guilty of a murder they wouldn't be asking that third question because that included the OUI. So
Logic, but who knows?
yeah, let's
right.
go into court. Let's listen.
Court is in session.
All right, so we can bring the jurors over. Tori, do you have those? So Tony will take those. All right, so I'll take, thank you. Tori, how many did you make?
By the way, as you know, Michael and Brian and I believe there has not been enough evidence to convict Karen Read, that we believe in the no collision, no collision, no collision. We believe that if people can get convicted on this type of evidence, we're all in trouble. We understand the idea of compromising, especially with the OUI. That's why the defense put it in there. But we don't trust anything that's going on in this courtroom because we think that the decision making has been unfair for Karen Read. It's not been equal. If it were equal, it's worth it, but it's not been equal. All right, so we stand very strongly on that opinion, you have to prove your case beyond a reasonable doubt. So we'll see what the jury thinks. Obviously, now their defenses and the prosecution are reading the amended, updated jury slip. Joey Kane, thank you again, giving 5 Justice Served TV memberships. We really appreciate that. You are fabulous, and you're doing that every day. All right, so yes, we absolutely appreciate everything. Okay. So, okay, let's listen, because the listening is kind of the quiet is kind of part of the drama. I think Brendan's leaning back in his chair with his hands kind of crossed, his one fist kind of clenched, the hand crossed over it. No, this is not a verdict. This is the judge is going to answer the jury's 3 questions.
Please, jurors, enter. Let's back to session. You may be seated.
All right, jurors, we're in receipt of your question. We've been working on making sure that the answers we give you are the right ones, so it's taken us a while. So the first question, what is the time frame for the charge? Offense 002, Section 5, OUI at 12:45 or OUI at 5 a.m.? The answer to that question is that you folks have all the evidence. And remember, it's only you who decide the facts in this case. All right, that's the answer to that question. You are the fact finders. The second question, are video clips of Karen's interviews evidence? How can we consider them? Yes, the videos are evidence. You should weigh the defendant's statements in the videos as you would any other piece of evidence and give them whatever weight you deem appropriate. But first, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2, number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set,
Sure, why don't you come on over?
Well, while they go to sidebar on this, wow, gee, it sounds awfully like the one Nettie asked for yesterday.
Almost.
Except that she has to keep talking guilty, right? Guilty.
Yes, it does give them a roadmap, which they did not have before. The if-then, right?
Right.
Which is one thing that it should have had. The proposed suggestion was clearer. It just had a column: guilty, not guilty, guilty, not guilty. You know, each successive lesser included. This is not that clear, but it's far clearer than it was. And it's just a joke that we had to get to this point to make that happen.
Right, right. And she
Myself
had it.
say this, and I'm glad counsel told me I did. So if you go back and look at the form after 4, if you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony, OUI, liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below. I think I said, then find, I don't know what I said. I heard myself read the guilty,
Said
of the lesser included offense.
Right,
So
that's what she
if you
read.
find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay. Thank you very much. We're going to release you.
All right, the court, please. You're closing.
But what about lunch?
But of course, they can't just have a not guilty on the last one, period, which would make it easier. I would go back to number 1, you know?
Yeah, then then go all the way back to the other page. See, that's
which
just it. We've been calling it, the page 2 of the verdict slip. Well, now it's really page 2 and 3
Right,
of the verdict slip because it's now slopped over with all the new verbiage.
With all the new verbiage. So, but she did say, she did start by saying, that's what I said. She got guilty. What do you mean guilty?
Yeah.
Okay, hold on.
Are you satisfied, Ms. Giannetti?
Yes, Your Honor.
Okay. I'm going to ask everybody to stay a few minutes. I'll be back out in about 5 minutes.
Go questions and thoughts and why
All right.
was this objective?
We
Interesting.
don't need that. So that, yeah.
I thought we had
so
some special guests you hadn't told me about.
All right, so let me see. Aiden Carney is reporting that he's in the courtroom. Luckily, he has a spot in the courtroom this week. That the foreman looked at the direction of Karen Reed's parents and smiled. Now, these are little things that you can pick up when you're in the jury, when you're in the room. I'm sure the attorneys are picking it up. Let me tell you that there's a lot more. Yesterday how we talked about the defense seemed a little downtrodden because they hadn't had a verdict yet, right?
Right.
And you and I thought, well, no, that's going to go. They're going to talk all day. They haven't talked. They're going to talk all day, and Tuesday is when you're going to hear something. We said that between 10:30 and 11 o'clock.
Right.
That we'd have a hit. So you get these little picks. You pick up these little things. Now sometimes they're wrong, but I don't think that that would happen. And Aiden also reported that in the hallway he saw AJ Alan Jackson and said, "Those are good questions." And Jackson responded, yeah, you think? So Michael, so I ask you, are those good questions, and for whom?
Of course, yeah. And we've talked about it. If I were the defense, just hearing those questions without even getting the adjustment to the verdict slip that we've now seen, I'd be very happy. I want to make sure that I'm not misreading these questions because you want to temper your enthusiasm, but I don't know how I would interpret it as anything but a win. And it also makes me think I'm pretty damn smart that I put that OUI charge in there as a throwaway. Talk to my client, told her what the possible ramifications might be, but also told her what the benefit of having that alternative compromise for the jury might ultimately mean. And it sure looks like we're walking right down that path. So yeah, I'm thinking, I'm smart. I'm smart enough to do this for you. And it seems to be working.
Yeah. Brian B pointed out that, of course, we had to go to a Sidebahhh. Okay. And sometimes the night.
Why do you think she wants him to hang out? Why do you think she wants him to hang out for a few minutes?
I think she's thinking there's going to be a verdict. And by the time everyone goes back to their office and she brings them back, there's lunch and we're at 2:30. I think that she knows that this is close to a verdict, and that's my feeling. Whether she's reading the tea leaves. Donnie Not Wahlberg gifted 1 Justice Served TV membership. Thank you very much, all. If you're joining us from X, where a lot of you have joined us, please go to our YouTube page, hit the subscribe, like, share button, and when this case ends, because I'm not going to have you do it right now, go back and listen to the. Did I somehow delete me? No, I'm still on, right? Okay.
Yes,
I thought maybe I deleted me because I was trying to close down all the gosh darn open windows I have to look up stuff. Go back and listen to our interview we did exclusively with Mike Easter last night. Now Michael Bryant is not on. Okay. So,
I just had to sneeze. And
I know. I've done that too. I did that too
hit
yesterday.
the sneeze button. Yeah.
You know, the funniest thing is when we're on network TV, we can't do that. So you go to sneeze and you're like,
Well, think about it. Yeah, I mean, and I don't think I've ever sneezed on. I think I probably have hiccuped on live TV, but this is slightly different in that we're never gone.
yeah,
We're
never
always
gone.
on.
Here we
There's
go.
no commercials.
No commercials. We're never gone. We're with you, good, bad, or indifferent. So we're going back up to the Sidebahhh. Okay.
This may be her insight as to where they are in the process, and telling the parties, look, you might consider hanging around. Obviously, we will wait if you do leave, but think about it. Maybe we'll get you some lunch.
Yeah. No, it's very interesting. Now, that doesn't mean that we're right. That our teams are
we
right.
could be dead wrong.
We could be absolutely wrong. It could be absolutely wrong. Okay. I don't think so, because I don't see how you could get 12 people to think that there was a collision. I think if there were, I thought there could be a hung jury, possibly the way the verdict form was. But my personal feeling was that there wasn't enough evidence to prove this case. At this point, especially with all the problems that the prosecution had, with all the problems that they had. I mean, there were severe problems that were not answered. Okay.
Oh yeah. So my plan, once it is announced that there is a verdict, as I expect there will be sooner rather than later, I'm going to bolt down the street. You can see the courthouse right behind me. I'm just going to pull up stakes and wander down there and get the react from the street.
Okay.
So.
All right. If you're going to be on for like 5 minutes, I'm going to take, while they're still at Sidebahhh, I'll just be back. I'll be right back, because I expect that when we come back on, we're going to be on for a long time.
You think so?
Yeah.
Okay.
Okay. Hold on. I'll be right back with you.
Okay. All right. So, and I just noticed this is like a clock. I have a light here. Obviously, lights out because my battery has died. I'm telling you, the battery usage on the road like this is pretty incredible. But so far, everything except that light has survived. So, what are you thinking? Are you concerned? Are you nervous? Do you think along the lines that we have, which is they've narrowed it down, hopefully with the court's further instruction and a new and improved verdict slip, that they can get where it appears they are going, or we're all washed up. We have no idea what they're really doing and where they're really going. What do you think? Oh, this is too bad Linda's not here. She could see this. Watched your movie, Phil Spector. So great. Yes, Helen Mirren played Linda Kenney Baden. Jennifer Robertson just found your channel. Thank you for subscribing. We appreciate that. Question: is it normal for the defendant to go up to the Sidebahhh? Yeah, that's a good question. They have the right to do so, and I always encourage it. But in this particular case, there was an attempt to get a little headset early on. Alan Jackson asked the court, "Hey, can we get just a wireless headset so that Ms. Reed can stay here at the table, but still basically be part of these Sidebahhh conversations?" Denied. Judge Kenney said no. She has every right to be up here, and she can be, and she has been. I don't know that I've seen her sit out even one of the sidebars. So, this is their case. There are attorneys I'm aware of that will discourage that kind of participation. I think that's a mistake for a lot of reasons. Last thing you want is, after the fact, if you've lost your case, your client's convicted, and then they're making Sixth Amendment ineffective assistance of counsel arguments on appeal because they didn't involve you in the sidebars, right? I don't see any downside, unless you have a totally out of control client. I don't see any downside to having the client with you at Sidebahhh. And you have seen through the course of both trials now how active a participant Karen Reed is in her own defense. In fact, if you just dropped from Mars onto the planet and you started watching this case, you might think she's one of the attorneys. She dresses the part. She is very much involved, and it does not surprise me that she is at virtually every single sidebar. And I'm assuming she's chiming in as well. That would not surprise me. North Carolina, I think that's for North Carolina. North Carolina Highway Patrol retired. Think about it. If you're on this jury and the state didn't show you your crash report, wouldn't you wonder where it is? Well, yeah, you would. I would. There wasn't one done as required by law, that in a fatality. Yeah. Well, we know there were a lot of things that weren't done in this case. And this gives me an opportunity to promote our exclusive interview with Michael Easter. This is the law enforcement procedure expert. We learned he's actually more of a cell data expert who also does now law enforcement procedure expertise. Check that out. It's in our library. It's the first time he's spoken to anybody since he was denied the ability to testify in front of the jury. Let's see if they've worked out something here.
All right, so we'll see everybody at 1:30.
Okay, so that's interesting. We'll see everybody at 1:30. Obviously, there's the lunch break, but it's almost as if she's saying, "Stay close," because at 1:30, and maybe in her opinion, we're going to have more than just a post-lunch confab. We don't know. We have no idea. We don't know if the jury is getting to deliberate over their ham sandwiches. Do you think they would give ham sandwiches to the jury? I guess it's possible. So we don't know if that's what's happening. If I'm on this jury and I'm truly as close as it kind of feels like they might be, I'm grinding through the lunch hour. I want it done. They may not come back till 1:30 to take the verdict. Oh, what was that? But I want it done. I want to just be sitting here enjoying my lunch, knowing it's done, knowing we're ready to wrap this thing up. On the other hand, if we are 100% wrong and they are just stumbling through one of the many options that they have and they haven't gotten anything figured out, well, we'll be here quite a bit longer. I get the sense from the judge keeping everybody in the courtroom for a minute to have that additional sidebar and now asking them to come back at 1:30 that she has a sense, which she gets not just from her, but court officers, the bailiffs, those around the court that are, monitoring deliberations to the degree they can without being in the room. You get signs. You get the feeling that you think they might be getting kind of close. So thanks to everybody for the support. We appreciate it. The subscriptions, very nice. I think we're getting close to 16,000, I think, at this point, which we do appreciate. I'm not sure what we're going to do after this trial is over. I'm already now thinking beyond this into, post Karen Reed, what happens next? We know there are a number of trials coming up, big trials. Whether we cover them similarly, I'd be hesitant to think we can. I'm not sure we can devote the time to it, but we will definitely have an end of the day kind of wrap up for some of the more important trials. We'll have still the amazing interviews from those connected to these various trials and from experts on the outside that can weigh in on the trials. So that's kind of our loose plan going forward. We did this in part as kind of an experiment. Let's just see how this works. It's close enough. We can be on the ground here, which I think is a critical distinction from some of the other offerings in the true crime space. We've always thought that this where in the world is justice concept. We always thought it was important to every time I covered trials for Court TV, Law and Crime, what you learn from being on the ground in the location is you just can't make that up. You can't recreate it any other way. No matter what you read, no matter how many reports you watch, no matter how many interviews you see, it ain't the same. It's not the same as being here where you get to hear construction all around you, where you get to count the number of sirens and rescue vehicles that go by every day. It just ain't the same. So I was just ruminating on where we go after Karen Reed, but talking about the importance of being here, wherever here may be.
We do want our members, we're probably going to give exclusive access initially to our members to find Where in the World is Stephanie or Who Killed Stephanie, a case out of 1968 out of Oregon that we'll give the full name for. And we're going to devote some time to getting that set up to start. You can have all the information. We've been promising that. Also, I understand the Diddy trial, the government's going to rest Wednesday, and then the defense is going to do it. Now, there's reporters in the courtroom that we should talk to about that. And
I'm going to get down there after the dust settles here. I'll definitely go down there and dip my toe in that.
Yeah, but we want to we don't want to do like, and I'm not going to say run of the mill because no case is run of the mill, but we want to bring you some exclusive content and some high powered attorneys that actually show up. By the way, thank you. You watched my movie, Phil Spector. So great. Thank you.
Oh yeah, you were gone when I went through that one.
Oh, thank you. I'm sorry about that. Just seeing that now in the comments. Okay, did you do all the comments here?
I did. I did all
Okay.
of them, every single
Oh
one.
wow, you're an
was zooming.
amazing co-host. You were zooming right through. No, so we know we want to bring you as we did some
It's a
really
good
exclusive
question.
high tent comment. Are there any civil lawsuits attached to this case? Will you come? Yeah, there is a civil lawsuit. The both the John O'Keefe's niece and I guess the mother are, I think we heard, are suing Karen Reed in a civil suit for wrongful death and all. So
And as to where we cover them, yes, to the degree that we can, they will never see the inside of a courtroom. They'll be resolved far short of trial. They'll be settled. There will be payments made no matter what. And I don't care what the outcome is. Remember, you can look at OJ as an example, the wrongful death civil case versus the criminal matter, very different outcomes. But no matter what happens here, that doesn't mean it negates a civil case. A conviction gives you a slam dunk in a civil case, but an acquittal just means you got to go forward with the much lower burden of proof, the preponderance of the evidence, 51%. So you can still prevail in a civil case, but it'll never get that far. It'll be resolved with insurance money, whatever other funds they can scrape together.
Right. Now, apparently, Missy has queued up Karen leaving the courthouse. So because they have to be back at 1:30, I guess we should play that, right?
Great. I'm going to go find another battery because I feel like I'm in the dark here.
Okay.
So,
okay.
Okay.
I'll hang out with all of our amazing thousands of chatters. Okay. Yeah, Michael Bryant is never in the dark. Let's listen. Let's watch.
You see this as a positive sign.
How are you feeling? How are you feeling?
Any reaction? Let's find out if Mr. and Mrs. Reed have any comment. Hi, Mrs. Reed. Mr. Reed, any comment?
How are you feeling?
How are you spending the deliberation time?
Ms. Reed, your family visibly believed there was like an exasperation moment when you found out the questions. Do you feel the jury's leaning a certain way?
Are you
Talk to me about the
prepared for a
emotion
verdict?
inside the courtroom.
I'm prepared to hopefully find out the verdict.
Talk to me about the why be a win for your family.
Oh, there you have it. So that was Mr. Reed. Obviously loves his daughter, a big supporter of his daughter. I hope we all be a big supporter of our children, but truly believes that Karen has been, and there is the fan of injustice. And until there's justice, I will keep calling it that, fan of injustice. We have seen a lot of it, haven't we? Okay. Yes, and we are monitoring that court feed, although we do not expect them to come back until 1:30. I guess what's happening, and I have a feeling that she's actually has lunch being brought in now, and that's why she's giving her court officers lunch now, because she expects a verdict in the afternoon. And rather than wait till 1:30 and then the jury has to wait, that may be what some of this, that last sidebar was about, with regard to what she was doing. There's a lot of mundane things like that happen at sidebar. And I have a feeling that's what it was. And that was not saying it that this is their actual lunch hour. She's required to give their court officers that lunch hour, and she's just moving it up because she knows the jury has to go back in there and they have to look at the new form and take those new instructions. Now, the jury will get, if indeed they are having lunch and they knock, they may have been told that they can't announce any other question or a verdict until 1:30. They may have been told that. That's a possibility that jurors have been told. So so we just watched the feed. I think they look a lot different today. That they got a sign from the jurors. Okay. But But I think those were actually very good questions from the jury. Somebody was raising the idea, well, are these evidence, but how do we view them? That's what the question. How do we view them? It's not so much that how do you view them as evidence. How do we look at them in light of, are they admissions? Are they confessions? Do we look at them in light with every other evidence? That's actually a juror who's really thinking. I mean, they're thinking very smart. The fact that they're thinking that, well, if they compromise, because maybe one jury wants to compromise, if they compromise and find her guilty of OUI, okay, if they compromise and find her guilty of OUI, does it mean that then everything above in that old verdict sheet, which obviously by changing it to a new verdict sheet to sort of what Yannetti had proposed, had to be changed because it was a problem. Of course it was a problem. We all told you Judge Kenney was a problem. You did not listen. And apparently the deliberation clock is stopping at 12:41:20. Who's ever running that? But the judge has allowed this jury to continue deliberating during lunch. So unless they have notice and there's been a knock at the door and there's a verdict that we haven't heard about, and quite frankly, we'd have to go to a reporter in the courtroom. Okay. So there we are with regard to things. So if somebody has stopped a verdict clock, do they have notice that there's a verdict? I'm not going to report on that because we don't know unless we hear it from really someone in the courtroom that the jury has that. Because remember, the judge told everyone to come back at 1:30, at 1:30. So let's see. And it looks like, obviously, I think Yannetti said they were staying at his office because he asked to be 10 minutes away. Okay. So let me just, Aiden Carney gives you a really on-site of what he sees in the courtroom. We told you he reported, by the way, let me just see. I know. Still no slip. There's still no, by the way, we don't have a hard copy of the slip we could pick up, but she did read it out in the courtroom. And she finally read the questions in the courtroom fully, not just the substance of what the question is, but the question. And when Aiden Carney told you the question 2 referred to the defendant as Karen. When you refer to a defendant as their first name, that is usually pretty good. Okay. You don't really, like when we have defendants, we refer to them as Aaron or Phil or Casey. You don't refer to them as the defendant. Some people, when I hear lawyers, defense lawyers do that, I just wonder if they got their degree out of a Cracker Jack box. Okay. So, and all. So, I'll tell you what Aiden is reporting, okay? Aiden Carney doesn't believe Karen should be singled out and convicted of drinking while driving because Brian Higgins, Brian Albert, Matt McCabe all testified they were all drinking that night. As a matter of fact, Higgins was like 5 more whiskeys and 5 whiskeys and this and that. But if you put this in to try to get a juror who could convict as a compromise, you take the chance that you get a compromise, okay? And that's something that your client had to agree to. Remember, the prosecution didn't want any compromise verdict. They were going for all or nothing on the top charge. They didn't want any lesser includeds even. Okay. But then he also reported, so that Aiden Carney reported juror number 4 picked up a piece of his paper and used it to shield his mouth, and he whispered something to juror 3. Okay, now the juror 1, 2, and 3 are in the back, by the way. 1 is in the back, far right corner, and then the juror 2 is next and all. And juror number 1, so it's not in the front like you would expect. And so that juror would have picked up a piece of paper, juror number 4, leaned to his right, his or her right, as he was looking at the media. Many jurors are looking at the media, which they don't usually do. It's as if they know they are about to do something. So you could hear me because I was talking to you, but you may not hear me, especially if I leaned into another juror. Okay. So they know they can talk about the case now to each other. And, so very interesting, obviously. Juror number 4 be somebody you'd want to talk to, pretty juror friendly. I mean, pretty, I would say pretty media savvy too. All the jurors are these days. They're media savvy. All right. Think about it. We did not lose one juror of the 18, and the other 6 are probably following this right along as they're supposed to. We did not lose one juror. that whole period of time. Usually in a long case, in a high profile case, you lose some jurors. We did not lose a juror at all. And all. So that's where we stood. All these jurors wanted to deliberate on this case. And they may have had differing opinions when they went in there. But again, if you are the defense, if you pick the one juror that says, look, our job is to decide whether or not the prosecution proved its case beyond a reasonable doubt, we don't know what happened. The prosecution said they don't know what happened. We simply don't know what happened. We know that there was no expert that said there was a collision. We know that those wounds on the right arm don't appear to be coming from a car accident. We know that. We don't know what happened, and no one wants to tell us what happened. I'd like, some of them may say, I'd like to hear from the people in the house. I'd like to hear from Higgins. I'd like to hear from Albert. I'd like to hear from McCabe. Some of them may have said that in the jury room. They're free to say that. They're free to say that, okay? And yes, while one should never drive while you are drunk or under the influence. Boy, it sounds like the whole police department was driving that way, right? We saw the Canton report. Everyone in that bar. It seems to me that Dedham and Canton may have an issue with people drinking while they're driving. But Karen Reed apparently was the one. John called her, remember, to say that he was still hungover. This was 3 o'clock in the afternoon from the night before. And then when Karen Reed had some resistance for coming because she had the plumber and all. If you recall, going way back, he said, well, I was expecting you to be here by now to be driving me. I need a ride, okay? Why was that? Because he felt that he was drunk, before he felt that he was going to be drinking. So he entrusted her to be driving, to be the safest one driving. And apparently she drove pretty safely. And while I don't condone driving while drinking, I am not sure that I could convict anybody, single this person out, given the fact that everybody else there that night was absolutely plastered, it appeared. That seems to be the norm, okay? And I hope the jury remembers that when they said, somebody goes back in there and says, okay, well, maybe we shouldn't convict her of anything because we're not convicting anybody else, We're not, look at all these other people. We're not convicting of anyone else, right? Okay, so Meg says, by the way, we should check out the plastic surgeon trial in Florida. It's a death penalty trial without a body. Okay, let's make a note of that. I'm going to take a screenshot of that, and I am going to send it to us, to our producers, and also to at Michael J. Bryant. We'll check that out, Sure, absolutely. Okay. Yeah, this is a word Cindy Salsa said. Everybody was snockered. Okay, I never knew that word, but everybody was. What was the word that? Tell me the word that puddled. Okay, everyone was puddled. Thank you, this follower. Thank you very much. That was the word he used because remember in the text, one of the texts on the trooper we never heard from, the case agent, the lead investigator, Michael Proctor, when he was asked, one of the people, his friend said, oh, the homeowner must have been, is he responsible? He said, no, he was puddled, or he was puddled too, or something like that. Snockered, puddled. I have to tell you, these are words that I had not heard before. Tell me more of them. And quite frankly, I'm for like a little bit of fairness in with regard to it. I would not, I'd fight when voting for a verdict that's a compromise here that has to do with drinking while driving, only because everybody else was doing it. They were so all, in my opinion, the same, if not worse, than Karen Reed was. Probably the worst than Karen Reed was, because at least we have the records that even that guy, what was his name? Let's see, the expert, Shannon with one N, Burgess. All of the data showed that she was driving within the speed limit, driving safely. When she came to the end of the street, the other car that had the people in it, they waved her on to make the turn. She did a very safe 3-point turn to get to the house, and she was going the wrong way and all. And yeah, that's a word that divining rod, that I've heard in the past. That one I'm familiar with. I'm not going to say it out loud, but and then she drove home appropriately. It took about 7 minutes to drive home. She was not driving at 40 or 45 miles an hour. She was driving within the speed limit. And then the only time she did have a problem was when she's rushing out because she's upset that John is not home. And in the snow, in that little tiny driveway, which Michael Bryant has seen, has said, to get these cars out. She was driving a big SUV Lexus, and then I didn't realize the Traverse was such a big car. I have on my Instagram, right? Michael Bryant, let me just tell you, it is you. He cannot get back onto StreamYard, Dizzy or Missy. All right, so let's see if we can help him. Let me just answer him. It is you. Okay, because he's trying to get back on to be with us. There he goes. I hear the pop of my ear. So I mean, I saw a Traverse, and in my Instagram, Kenney Baden at Kenney Baden, about 2 weeks ago, I was walking to be the poodle, and there was this Traverse, and it was ginormous. I had no idea it was so big in that tiny driveway. No wonder she couldn't get out without hitting that tail light.
Yeah, the way that driveway is configured is a nightmare anyway. It's a very sharp 90. They should never put that kind of garage adjacent to that small lot. Terrible, but anyway, terrible. And that car, the Acadia is the GM version of the Traverse, and that's what I have. That's been our mobile studio. So
okay, I didn't realize that. It's big.
Yeah, so it's plenty big.
It's plenty big. Blessed Mom in Texas. Love you, Linda. Absolutely correct. Karen Reed will be acquitted. Manifest, y'all. Thank you, Blessed Mom in Texas, for that. I just tell you that because of, I was saying, Michael Bryant, that I know this is a compromise if they find her guilty of the OUI, and I know the defense felt the need to put in the OUI as a compromise. But if I'm in that jury room, I'm going to say, heck, I'm not compromising with you. I mean, unless you bring all those other people that were driving, I'm not going to convict the girl of that. I'm just not doing it. I mean, I stand my ground.
Yeah, we're back to that, that analysis of personalities in the deliberation room. Are you a wolf? Are you a sheep? Are you a follower? Are you a leader? And, there are going to be a little of both in there. And if the person with the hesitancy is a sheep, then they're going to bend at some point.
Brian Stockport wants to know, did I meet Helen Mirren? Of course, I met Helen Mirren. Yes, absolutely. Maybe I'll post a couple of pictures. I keep them private, or a picture or so at the wrap party with David Mamet, or maybe I'll do that. Go back and post some of those on my Instagram. It won't be on the Twitter. I don't use like my personal pictures for Twitter, Twitter, but my Instagram is Kenney Baden, and it has a lot of it's mostly personal stuff. But I will, you can check it out and follow me, and maybe I'll go back and do that. Let me make a note to myself on that because I don't want to forget that. So I'm going to actually make a note to myself. I'm actually going to print out, that terrible thing you shouldn't do right now, which is print out. But I am going to print your note out, Brian, so that reminds me to maybe put a picture or two on my personal Instagram back then. Yeah, she's delightful. And unlike me, who can't hold down a drink, which is, I'm like, I'm like my mother. Give me 1 sip of alcohol, I'm like, I have to go to sleep, of course, unless it's high-powered champagne. But Helen, she's pretty damn good, all right. But not driving while you're drinking, okay? And again, I'm not condoning that. What I'm saying, what I'm saying is that I couldn't go for unequal justice here to compromise. All right, that's what I'm saying on a personal matter.
I get it. And if everybody had your Constitution, maybe we'd have another hung jury. But I know
but that's
people
the hung.
Get put in a headlock and they bend. They break.
Well, but this is pretty good. Obviously there's people really smart on that jury to be able to ask that question. If we convict her of some kind of lesser included, e.g., number 5, which is OUI, does that mean
that was
convicted of all the above?
That was telling to me, not just the initial question, but to give an example, right? If they had not given that example, it was a crapshoot. It could have been any of the lesser includeds on that second charge, right? But they said, for example, maybe not this one, but for example, if we were we're just talking here.
Yeah, we're just spitballing.
Maybe it's just maybe that one.
Yeah.
That was telling as well.
Yeah.
Folks are heading back and forth here from lunch. Can you see There's usually a pink wave as
apparently,
they
there's a
continue by.
wave, right? I mean,
Yeah.
you're in just tell us when apparently it's like a festival out there. That's what we understand, right?
I have a feeling, compared to this morning, I've not been back, and I'm going to go as soon as it sounds like they got a verdict, but I haven't been back since this morning when it was a little more sedate, a little more solemn. And I think the mood has definitely changed.
Yeah. You know what gets me though? If they convict her of even the OUI, you know what the headlines are going to be. Headlines will be Karen Reed convicted or something like that.
Convicted?
Yeah, that Karen Reed guilty, because that'll be the headlines, because the media that is, if it wanted her convicted, will have to point to that. Just like we heard yesterday with poor Aiden on the courthouse would say, Aiden on the Aiden on the courthouse was being mauled by somebody who's like, she was drunk driving. She's driving.
Now we're having StreamYard issues. That's very interesting.
Yeah. Oh, okay. You are hanging up on StreamYard. You're pixelating and hanging up. That's not our Skylink, I assume. No, Michael Bryant's having a problem.
227.
I think the jury wants to send a message. Okay. I don't know. I don't know. But look, there's no doubt the judge took an early lunch. They're going to take an early lunch. There's no doubt that we think that Michael Bryant just left off. By the way, what states do I practice in? A lot. My main practice started in New Jersey. I'm also admitted in New York. I'm admitted in Washington, D.C. I've been pro hoc vice in like 6 different states, if I recall. It's on my CV. I can't quite remember. Tennessee, California, Florida, Connecticut, Massachusetts. I've been pro hoc in those states for different cases. I'm admitted to the New Jersey District Court, the Southern District, the Eastern District, the Western District, and the United States Supreme Court. So a lot of different cases. My of counsel office is in New Jersey, but I kind of go everywhere. I mean, we finished a case last year. I finished a case in California that I was of counsel to a firm dealing with national counsel for a client. The local counsel actually completed the case in California, but I was national counsel for my client, who had residences both in New York and in England. So my practice is one that I get called in to do the specialization on cases or handle major cases. Our office in New Jersey handles major cases dealing with sex harassment, discrimination, and civil rights actions. So that's where we are. Everyone loves my colors. It's not Fashion Friday, but this is a deep purple. Normally it'd be like a funereal color, but it's actually adult.
You see this color behind me?
Yeah, I see pink, and then I have a lavender jacket. This is actually lavender. I guess somebody would call it pink. It's heather, I guess you call it.
This is our favorite photo bomber.
Oh, wait a second. Wait,
Scott. Don't hide behind your. Don't hide behind your sign.
Scott is hi, Scotty. We were just saying we missed you. I think you're out. You're outside the zone. Now let me ask you this, Scotty.
There you go.
Can you come on, Scotty? There you are. Scotty?
Hi, Linda.
Hey, nice to see you. Good. You're wearing pink, and you've got what's the green thing around your arm?
That's for Turtle Boy. Free Turtle Boy.
Free Turtle Boy. Did you see him getting mauled or molested yesterday, and the statey going by and doing nothing about it?
Well, that was Aiden trolling DePietro. There was really nothing going on there. Aiden does that to him all the time.
It was just Aiden's just doing his thing, and I guess I was on, as you know, I was on Fox Nation on the show with DePietro, and he and I didn't get along too well.
Well, when Aiden goes up and trolls DePietro on the stairs like that, it draws a crowd. So it drew attention of the state police. But it's all in good fun. I mean, the news media tries to make it into something that it's not, more fake news.
Yeah, I like the
We troll him all the time. I was sign bombing him just like I sign bomb Michael here.
Yeah.
Try to disrupt his lives.
Yeah, that doesn't work.
It doesn't work because
it
doesn't work because his co-host
I knew Michael
wants
would
you
be
on.
over here, so I had to take a walk over.
Yeah, Michael's responsible
But
along with.
I was saying to Michael, you know, we were talking about the added OUI, and that sounds like that's the only thing the jury is hung on.
Yep, it sounds like that's the compromise, that somebody wants something, and they're worried if they compromise on that or find her guilty on that, that somehow the judge, they don't trust the judge, right, or the prosecution,
Definitely having
not
some
to
issues
convict
here
her.
today. Some StreamYard / Starlink, although Starlink is solid. It's in a place it's always been when it is solid. So, I cannot blame Elon Musk for this. I'm blaming StreamYard.
Okay, well, I can't blame Scotty. Scotty, can I just tell Scotty something? Remember with the first walk you did with Michael Bryant on April 1st, you walked through the buffer zone, and because of that walk, we got that, you know, with Michael's and Jason and all, and you covering that, we got that First Amendment zone instead of the buffer zone, and you were part of that first day, Scotty. Okay, I don't know if he can hear me. I hope he heard what I said, because Scotty was walking with Vine. Dizzy wants to know, how many devices do you have signed into in StreamYard, Michael Bryan? If you have too many signed in, you may be causing some problems. All right. But I wanted to remind you all that Scotty has covered a sign, walking from one end to another, where, you know, way far away, where the Judge Kenney had put the buffer zone. And Michael Bryan was doing news gathering that day and walking with Tom CPU. And Scotty was there. Scotty had covered, actually walking with Scotty, picked up Tom CPU, and then Mr. Delgado. And then when they went to the point where Hardman said to Michael Bryan, I've seen you walking past here 5 times. I don't want to see you again. Okay. And he's news covering. And Michael thought it was important enough to bring a First Amendment suit with the help of Mark Randazzo in the Liberty Center. He was joined with that on that with Tom CPU, and that was Tom DeRozier. And then Jason Grant also, with his 2 co-defendants. Jason Grant is actually the named plaintiff in the first suit. Michael Bryan has the second filed suit. And then the third suit with Mr. Delgado. Erica Walsh's suit came later. But they're the ones who got that undone as a result, because of the enforcement. Even when they won, they tried to enforce it terribly. And that you're seeing what you're seeing, and all the support and everybody expressing their First Amendment rights, partially because of the step that our own Michael Bryan took. That you know, this is where I lag on mainstream media. You didn't see that. You didn't see anyone else coming to our aid, right? We did that. He did that. All right. With the Randazzo and the Liberty Center. None of the big networks came to our aid. None of them said, yeah, you know, we should, the First Amendment's being infringed upon, right? They did drop in when the verdict came to try to be in the randomizer and get some seats, but no one, the reason why they have all these people there to interview is because of Jason Grant and his 2 co-defendants. It's because of Michael Bryan. It's because of Mr. Delgado, okay? That's why they have that. That's why you're able to see all these people. And that's now why they want to come in and interview people. So if I sound a little testy on that point, it's because I believe that everybody should have come in and helped to try to get that buffer zone, whether it's undone or get it so that you know, the jury is not going to be affected by the buffer zone, right? All right. And even when they got even a little loud, Alan Jackson came back out and told everyone this. That's why they went to, as we learned yesterday, the love sign. I'm not, my fingers aren't doing this as good as they should be. For everybody, that is the love sign. We have a bunch of students who are hard of hearing, have deaf issues in our chat. Okay. And that Karen Reed went to the love sign, that we love you. Okay. And that's what you put up. And everyone went pretty crazy over that. And I don't mean crazy in a bad way, and decided that, yes, that's what we're going to do. We will keep it down. Because in the buffer zone, you're not supposed to be shouting or wearing clothing that says Free Karen Reed. That's why you saw, I think, a lot of people with the shirts that have the tape over them or the blue paint over them and all. I think they did this to themselves also when they arrested Erica Walsh, and Mark Randazzo said to the federal court judge, hey, we won first, and then this is what they did. You've got to stop this enforcement, right? You have to stop this enforcement. Blessed Mom in Texas, let's share this video everywhere. This channel should have 20,000 subs. It's free. Hit the like, share, and subscribe. Thank you, Blessed Mom in Texas. If you're joining us from X, yes, please come to our YouTube channel. Hit that subscribe, share, like, and all. We're honing in on 16,000. Boy, would we love to be up to 20,000. Just get that that started. I'll tell you what, for everyone that has now followed us, I think that I see the importance of learning sign language. Okay, I see how important it is and how important that we have, and I think our closed captioning is working on our YouTube. I hope it is. We try to make it work all the time, and sometimes I do have the YouTube here, but my YouTube, when I am not on it on my computer for some reason, doesn't give me the option to do anything. All right. I would definitely need help from some tech expert here, and that's to deal with this. But sometimes just good old common sense and good old let's see what we can see and do what we can do is important. But yes, look at this feed. Look at this feed. Okay. Listen to it for a second. Let me be quiet. Let's listen. That's the feed of the First Amendment. That's the sound of the First Amendment you're hearing. Okay, he's back.
Well, that's fun. I don't know if StreamYard is being overtaxed, but I've been kicked off a couple of times now. It's kind of spooky.
Well, last week, all the cloud services, the Google Cloud services were under some type of attack, and that's why StreamYard was down the whole day. So
hopefully not the case. Of course, when they get that the verdict is announced or seems to be imminent. In fact, even just before 1:30, I may book.
Yeah, I think you've got. I think you've got to get down.
And
there.
then then we have to make a decision. This is up to you. I mean, you're an Iron Man, Iron Woman, Iron person. You can keep doing your thing, or we can run some pre-recorded something, either reports we've done. Something.
I'd like to see if we can. I'd like to see if you can deal with this. I'd like to see if we could get some. Matter of fact, Missy, if you're around, maybe check Chris Plord. Maybe, by the way, thank you, Moto85. Text Chris Plord, see if he's available to come on for the verdict. Maybe, Michael, can you text Bob Bianchi from where you are?
Sure.
Yep, her 1:30 is
And, I can try to see if Michael Del Segior can come on while we're talking here right now. I think I have his email. Let me just go silent for a second.
So you can kind of sense the buzz. There's definitely there's a buzz. People feel that something is imminent. Obviously, they're optimistic that it is the best of all possible worlds for their position, which is an acquittal on all charges. I'm not so sure that's borne out by the questions and answers and discussion over the jury verdict slip. But who knows? Who knows? I just think that something is imminent, and we're going to find out after the 1:30 break.
Everyone's loving my story. But look, I posted this. My mom's going to be having a Facebook post up with me and your turtle. She's going to make a Facebook post.
You might really have to.
Okay, sent a note to Mr. Bianchi. Which one? We're getting that. This is a long crime feed. Okay. Could be Michael down there, one of the guys I met early on in this process.
I just sent
he's kind of the stringer. Yes.
I just sent a text too for the person who practices in Massachusetts doing OUI law and see whether or not he can come on. I haven't talked to him in a while, so be like, "Hey, remember me?"
Yeah.
No.
Just
we're friends on
need some OUI information for a friend.
Yeah. So we'll see on that. So okay, you want to get down there, and I will take it from here. We'll see. We have a list, Missy, I think, of people and Dizzy that we wanted to talk to. I know Chris Plord was Steve Plord. I keep saying Chris. Michael, you're going to go down there, right? And get ready.
Yeah, I'm going to hang for a couple of minutes and see if I get kicked off one more time.
Okay.
But yeah, I mean, they're not even reconvening for 25 minutes, so I got plenty
Yeah.
of time.
Oh, you got plenty of time. Yeah. Let me see if we've had so many people on this. Neil, I think would want to come on for a verdict and all, and I will ask them. I know we've been, it's hard when people have law practices to deal with this, and I'd certainly love Michael Easter if we have a verdict in her favor, but I don't want to ask these people just to come on.
To be hanging out.
Just to be hanging out, especially if it's not necessarily great. So Neil has notification silence. That sounds like he's in court. Oh boy. Okay. All right. So do you think we could send a Missy? Would you send, or Diz? Could you send a note to Joe Jockalone? See if he's free. I mean, we have to see if any of these people are free. That's the issue. To come on, I appreciate it, and I will text. I'll text our other crime scene consultant. Okay, so
thanks to Moto 88.
Thank you very much, Moto 88. Thank you. Meg had doctor's appointment. Did I miss anything? I'm hoping this is over tomorrow, because I have an 8:45 appointment with somebody scheduled, and I'd like to be able to make it.
Yes.
Okay,
I mean, not
that
this hasn't been a quest, just staying on this, covering it to the degree that we have. Obviously, we're serious about it and are glad we're able to do it. But all honesty, it gets tiring. It's a lot.
It's a lot, especially you're standing there. Are you sitting? Or are you just?
I'm sitting. I actually, I always forget something. I can always count on that. Every time I will forget something. Last time up, I forgot my suitcase. So, I wore the same clothes twice. It was bad. This time I forgot my chair. And so I'm in this little park, which I've been so lucky now to find this great parking space 2 days in a row now. Yesterday it took me 3 tries. I had to go all over the place before I landed here. But this is right across from Dedham Pizza, right by the La Luz pastry joint. I'm gaining weight just sitting here. But it's a cute little park. It's just a great place to be. You can see the courthouse behind me. And it's Starlink generally is very good here. So, so that has all worked out.
Yeah. Oh, that's great. That's great. So I know you want to hear. You're all dying to hear, in case anything happens. Okay, we're not. Nothing is going to happen until 1:30. Okay, and then it was interesting though. She asked people that. Did she ask? No, she told them to come back at 1:30. Did she tell them to all come back here at 1:30?
Yes.
So
she wants the parties back at 1:30.
All right. So if she gets a note from the jury, she doesn't want to wait for them all to convene. So she wants them back at 1:30. What is happening now, Buster, in Texas? We are waiting for 1:30. Nothing. We don't have, the jury has probably been told that they can't have a verdict or a question during lunch, and we think that the judge gave them the early lunch. That's why she told everyone to get back at 12:30. She said to come back at 1:30, so that because she has to be she has to give her court people a break. And think about the court reporter who's sitting there all the time with talking about everything. They need a break.
I can't even imagine. I always wonder about those folks, if when they leave court, they can turn that skill off, or if every conversation they have is like it's repeated in her head, because that's what she does. She's basically listening to her conversation and then repeating it. Yeah. What a crazy skill.
Now, Michael Bryant, it seems to me, and you tell me if I'm wrong, they would not be asking the question about count 2 unless they have eliminated count 1, because if he's guilty of murder, they're not considering count 2.
I think just like the first trial, this jury has eliminated count 1 and count 3. Now, I may be wrong. They may be working their way through 1, 2, 3, and they have been hung up on 2 and haven't gotten to 3 yet. That's possible.
That's possible.
That's right. And that would be kind of a false sense of security for the defense if they think they're defaulting already to the OUI. Maybe they did do 1, 2, 3. Maybe they went 1, 3, 2. So we don't know.
We don't know. But just to remind everyone, offense 3 is leaving the scene of an accident resulting in death. Not guilty or guilty of an offense charge, leaving the scene of an accident resulting in death. It doesn't have just guilty.
And that's the one charge that has a more specific intent.
Right. Right.
And so technically
explain that.
Well, she has to know, right? She has to know that somebody has been injured and perhaps could die and leave the scene despite knowing that. So that's a pretty high level of knowledge. Remember, for the first charge, second-degree murder, the intent is more general, and that is you doing something that you intend to cause serious bodily injury or death. The intent is the action, right, which is driving the vehicle, again, believing the Commonwealth's argument, driving the vehicle backwards, depressing the accelerator to 74%, driving backwards into Mr. O'Keefe. Those are the intentional elements. I think most people get past that pretty quickly. But there is an intent element to leaving the scene, and you got to know what you're doing, which is why we think the first jury immediately got rid of that as well.
Yeah, just that's I think that's what they did, but you never know. But it doesn't make any sense to me that they're talking about this if they had convicted her of murder. And it seems to me they had to convict her of murder if they're going to talk about number 3. That would have been the way you went around it. But you're not talking about number 2 and whether or not. Why would you care? Why would you care if you, for instance, picked number 5, guilty of a lesser included offense operating under the influence? Why would you care if it convicted her of the other 4 unless you believe she's not guilty of the other 4?
Yeah, there's no doubt. If you are leaning toward that final lesser and you just want to make sure, hey, we don't want to, also bring in these others because the form is so unclear. We want to make sure. I don't think it would be somebody saying, hey, we want to make sure that we're bringing in some of these other lessers by marking OUI. That's a weird scenario. Why don't you just mark the others then, right?
Right.
So,
right.
Yeah, I think that's probably logical if we can use logic.
If
So
we
remember,
can
I'm
use
thinking
logic.
in the scheme of the thought process about 1, the second-degree murder, and 3, leaving the scene. Those could be squared in your mind by saying, well, she didn't intend to run into him. She didn't intend to press the accelerator down, drive reverse into him. But once it happened and she knew it and left the scene, then you could be guilty of 3 and not number 1. So that would be the defining difference, I think, between those two. Again, first trial, the jury found pretty quickly, we hear, that she was not guilty of either of those.
Right. Let's go back to the fact that the verdict, the questions, when the judge first read them, she didn't mention, she mentioned the substance of the questions, but not the fact that they used the word Karen. And we had to go to Aidan Carney's Twitter feed, X feed, to find that out. Then when she did read them to answer them before the jury, she read the word Karen in there. I don't think a jury calls somebody by their first name if they're going to convict them of murder.
You sure don't.
Right?
Nope. I just substitute one of your friends' names, in that conversation.
Michael.
It's just the familiarity is contrary to convicting somebody.
Yeah. And you may even have you may have 2 issues here. You may be, as I'm watching people talk about this, because you can't assume anything. You may have one issue of compromise. Well, we think something happened, and they're worried about, other people are worried, well, if you convict her of this because we compromise with you, will that convict her of the above? But you also may have an issue of some juror thinking that her words are enough under those clips to convict her of operating under the influence, or as we call the DD, drunk driving of some sort, right? We don't know the level, but and for our viewers, explain to them why there's operating under the influence of liquor and or operating with a blood alcohol level of 0.08 or greater, because those are 2 things the jurors have to check and find.
Yeah, well, one is effectively, I'll use the word presumption, although in Massachusetts I'm not so sure it's that loose, but one is a scientific proof of being, in this case, under the influence, operating under the influence, and the other can be determined by a number of other factors, including an admission. Right? She could say, you know yourself pretty well. If you tell somebody, man, I was blitzed, I never should have been driving, that's evidence that you were, in fact, operating under the influence, even though you may have never taken a blood test or blown a 0.09 or higher. It's just an alternative way to get to the same result, operating under the influence.
Yeah. Okay. So that's and that choice was on both the original account 2, and it was on the lesser included of the sub 4 and then sub 5. I thought the jury was very smart, suggesting sub 5 as the example.
Well, that's what I'm saying. That's so telling. You know, they could have picked any of them as an example. Why would they pick that? Because it ain't the example. It's the one that they're having some issue over. Let me throw this out there because I just saw Cheech go by. Those of us who
tell Cheech I said tell I said hello, because I never when she says hello to me, I'm not on.
I know. I always give your greeting back to her. Yesterday when I interviewed her outside, she said it's gonna be 2:27 tomorrow. 2:27. You know, some symbolic sort of. So she just reinforced that it's right on track for her prediction of 2:27. Of course, syncing up with the How's Long to Die in the Cold search that never happened.
Yeah, I know. By the way, I can't read this. Let me just. I don't know what was in my eye drops this morning. Moto 88 became a YouTube member. I have to put it.
What do you got going on there?
I don't know. So we have that time. We're on Justice Watch. Justice really has no time. Justice to take all the time in the world to do justice here, but we're still watching it.
Is the clock still ticking? Is that what we've heard? The clock is still ticking somewhere?
I think someone said it was stopped, which suggested that everyone that it was stopped for lunch. But she allowed them to deliberate during lunch.
Yeah, the whole clock thing is let's just say it's an inexact science at the very least. It's nobody's in there with here you go and stopping and starting. It's all word of mouth. Are they not? What's so it's a rough calculation.
Yeah.
So they're past 11 hours. That we know.
That we know, and that's not. Hold on a second. I have an answer from my OUI expert. Yes, he's willing to come on. Okay.
Oh, good.
Let me have your email, and we will send you a link right now to StreamYard. You have to use Chrome.
Oh yes.
Okay. I'm Missy. I'm getting. This is Michael Del Signora. He is the person, OUI expert in Massachusetts. I met him after the Aaron Hernandez trial, and I did a lecture that he actually pays for people to come to learn about forensic. Okay. So forensics, and he's just absolutely wonderful. I have not seen him in a while. But he's been following our coverage of the trial. Okay. So Missy, I have to actually, let's see, I have to message this. I'm going to copy it. Okay, let me copy that. If I can do the copy email. And then Missy, I am going to send it to you right now in Stephen. This is like I'm having a conversation with like 6 people at once. Okay. Okay. Missy, if you're listening to me, could you send that to Michael Del Signor? He knows he has to use Chrome to get on StreamYard. Send him the link. I told him it's coming right now. Okay. Thank you. Appreciate it. All right. And while we're doing that, Michael Bryan, and I'm letting all of you know, you're seeing the production going on right now because we show you that Stephen Plord wants to know an interesting question. That charge was not refuted by the defense. Well, they had to let the prosecution prove it. I think the defense asked for the instruction, but still said the prosecution must prove it beyond a reasonable doubt.
Of course, yeah. She's not admitting to the charge. Hey, add this to the verdict, and by the way, she pleads guilty. No,
right. No, she's not admitting to it. Right. Yeah. So, but that's Stephen's not a lawyer, even though his wife is a lawyer. His brother is a lawyer. Yeah. He's surrounded. I mean, I think he's got lawyer DNA and all. Okay, in that regard. So somebody suggests that Karen Reed, by the way, civil trial would end up being a trial because if this is an acquittal, people want to get their pound of flesh, so to speak. Okay. Okay. So so we're going to wait for Michael to come on. Michael Del Signor. Okay. Yes, please. We just sent you a link.
So a reminder for folks who when they have some downtime, they can check out our library, which has all kinds of all kinds of different interviews and experience stuff from both on the ground here and some of the interviews we've done from here and from back at the mothership. So when you get some free time, check out some of that content.
Okay. He's going to log on, Missy, in 3 minutes. Okay. We're going to log on in 3 minutes. So I'd like to go right to him and get our questions ready about OUI, the penalty. If she's found guilty, do they take her away then? Blah, 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 blah. Okay. And the judge. But this is the man that can tell you. All right. His name is Michael Del Signor. If I know Missy can't get on our Twitter page, but he is active on X and Twitter with him. And he is considered one of the major experts in the state of Massachusetts on OUI, which is what we have here. Okay.
Yep. And for those maybe just going, OUI, what the hell is that? I mean, virtually everywhere else, it's DUI or DWI.
Right.
But they've expanded it here because you don't have to be driving. You can be operating. I'm just operating something.
A bicycle,
skateboard. There were some kids behind me the other day that were questionable. They're, I'm parked here at their park, and it was clearly after school, if they aren't out of school yet, or after summer school. And they were skateboarding all over the place. I thought I was going to take a hit.
You thought you were going to take a hit? Oh, you should be in New York. People skateboard all over the place right now. Okay, I'm going to actually put this in 1 minute. We will have, since I'm apparently the only one that can get into our X page. Have expert Michael.
Yes, I see. Kimbo talked about riding a horse, DUI or DWI.
Oh, really?
Yeah, operating under the influence. That's very possible. Yeah. Yep.
Okay. I can't type that fast. Okay.
Well, not without typos.
Everyone knows me, it started out as a lark, let me just tell you, kind of like a lark because, you know what? I can't type this. This is no way I'm going to type it. And with my nails so I'll just leave it. Michael couldn't type it. It started as like a lark. Like I'd put errors in like emails that I was sending, because then I knew if there was or a space between a period and things like that. And then I kind of became like careless about
Here
doing
we
it.
see the defense team returning.
Oh, let's look at that first. More important than my story.
A little more bounce in the step, I think.
Yep, there they
Here's
are.
Mr. Reed, Nathan.
Oh, the fan of injustice.
Yep.
Okay.
Only fan.
Only fan.
So yes, you were. Are you talking about your?
Yeah, and so I put it in there
skills?
because then if people then released it to the media or something like that, I know exactly who did it, because every single email or text had a different typo in it purposely that you wouldn't necessarily notice. Okay. Or if it was cleaned up, or if it was cleaned up. Yeah. So
you're going with that story. You're going with.
Oh,
that
it's
story?
absolutely the truth. Absolutely the truth.
All right.
And it's amazing. And then I just stopped.
Yeah, this is yet another thing where we are opposite ends of the spectrum. Where I take way too much time texting, emailing. And if I have a misspelling or a grammatical issue, I'm mad at myself because I didn't take the time to do it properly, respecting the language. But I'm way off the map with people these days. It's all about fast and immediate and shorthand and little abbreviations. And I'm like, get off my lawn. I'm gonna type these things out like a human.
Get off my lawn. I'm gonna type these things out like a human. You're funny. You're actually funny. Sometimes some of the abbreviations, I have to admit, every once in a while I have to look one up. Most of the time I know what they mean, but every once in a while I have to look one up. I saw somebody though getting, my goodness gracious. Apparently there was a
Another jury question.
No, apparently is there another jury question? Really?
Oh, I don't know. I'm just reading.
No. I'm just looking at in the Diddy case. Apparently there was something happened in the courtroom. Okay, so I don't know about that. We haven't had time. We haven't had time to even look at that case.
The prosecution has rested, or they were about to rest, right?
On Wednesday. It said on Wednesday. Okay, so So yeah, no, I don't see another jury question being, and the jury couldn't ask a question, right? So that's where we are. So we should have Mr. Del Signore on soon to be asked for all your OUI questions. And again, we don't know what's happening. We are taking our best guess, just like everybody is, based on what the questions are. But those could have been from one or two people, okay? It would have been one or two people, right? Yeah, no one wants to miss the verdict. By the way, Missy, I'm texting with Steve Plord. Okay. Okay, he said, Michael the Signor said he's logging on now to StreamYard. He has you have the link. We sent the link.
Yeah, then I will say hello because it would be rude otherwise, and then I'll say goodbye.
Yeah, copy email. Oh, there he goes. I hear the pop in my ear, and I haven't seen Michael in a while. And it's good. I mean, I follow him, and the fact that he's been married since I last saw him, and he's happy, and knock on wood, and all sorts of things. And I told you he is the maven in Massachusetts. If you have any issue when it comes to testing and alcohol, we can add him to the stage. There you go.
There he is.
Hi, nice to see you, Linda.
Oh,
nice to meet you, Michael.
Hi, nice to meet you as well.
And
I'm gonna leave. Okay, guys, what's going on there, Linda?
I have a double. I don't know what it is.
Are you getting an echo?
Yeah, I had an echo in my ear. We good now? You okay, Michael? No echo in your ear now, right?
No, I'm fine. I'm fine.
Okay, guys, take care. I will talk to you later.
Michael, Bryant, we'll see you in a bit. So tell us, this is your field. It looks possible that Karen Reed may get convicted with a simple operating under the influence of liquor, either operating under the influence of liquor and or, I don't know why there's an and, or operating a motor vehicle with a blood alcohol level of 0.08 or greater. What does that mean? What are the penalties in Massachusetts? People want to know, if she gets convicted, will she be taken away in handcuffs, put in the hoosegow, et cetera, et cetera? You're the man. I know you're the guy.
Yes, I'd be shocked if she didn't get the minimum punishment. If they find her just guilty of the OUI, that means they believe there was no accident. So the crime was her driving drunk back from Fairview to her house. So I would think the judge would obviously she wouldn't like this, but she'd have to give her the 24D. She'll probably give her a 90-day license loss, but it's 45 to 90-day license loss, 1 year probation. I don't see how the judge could give her more than the minimum punishment that anybody else gets for the OUI if everything else comes back not guilty. The difference in the charges in driving while impaired or 0.08, it's the same. It's guilty of either one. Is it guilty of OUI? So it's just alternative theories.
That's what I didn't understand. So these are alternative theories, but with the same penalty?
Essentially, yes. If she was found guilty of both, it would still be she was guilty of OUI, one crime. We don't have any enhanced penalty for OUI in Massachusetts based on the blood alcohol level. So the judge used to be a district court judge. I don't see, and she never.
What does that mean? Tell people what that means for people watching.
So Judge Kenney used to be in district court all the time, where she's sentenced probably hundreds of people for first OUI. That's the most common penalty there. She was never known to be, an egregious sentencer or somebody overly harsh. So it's really unheard of for anyone to get jail on an OUI in Massachusetts on a first offense. And if they don't believe there's an accident, then her driving really wasn't any different than anybody else's.
Yeah, and what people are upset about, even I said it, I mean, I wouldn't compromise on this because there were so many people, it appeared, that were driving OUI that night. But I understand it, and I don't condone it, obviously. So that answers the question of why, because no one understood why there was a OUI, operating under the influence, for the motor vehicle under the influence of liquor and or with the blood alcohol level. No one understood that. So it's the same charge, alternative theories, and no different penalty depending on what the jury finds, if they find one or more of those.
That's correct. Yeah, and okay. I agree. The optics of it would look bad if she got, somebody can theoretically get up to 2.5 years on a first OUI, but with evidence that the police officers were driving around impaired, I think the judge would be bound to treat her like everybody else is treated and give her the minimum penalties.
Could she decide to have a trial tax here, as one of our viewers who watched commented, and say, well, I think there's more here. I think the jury got it wrong, and so I'm gonna send you to jail. And if she does that, would she take her away right from the courtroom, or would she have to give her bail?
She would have her taken into custody if she was going to give her jail time. She could. We generally don't see trial taxes in Massachusetts, so that would be unusual. I wouldn't expect Judge Kenney to do that. I think she would move, if it's just the OUI, I think she's going to move to the sentencing very quick and say, hey, we have a first OUI. Commonwealth, what are you recommending? And I think she would expect it to be the minimum punishment. Miss Reed's attorney is also, Massachusetts attorneys handled OUIs. So I think it would be hard pressed to say that this case, if it's just the OUI, deserves anything more than the minimum punishment.
Okay. Now, Michael, I know you have an X account too, right? Is it the same as your Twitter account? Because we have your Instagram account. I mean, is your X and Twitter the same as your Instagram designation?
I don't think I think just I pretty much just use Twitter. I have an Instagram account, but I don't think it's tied to my law office. And then I have the Missy, could we see if we could go on and find his X account, Michael's X account, and put that up in our headline rather than this? Thank you very much. There's your office. Okay, we have that. And if we could have his X designation too, that would be just wonderful. Okay, it should be the same name. All right, so let me then ask you this. All right, would she would do that today then if she's found guilty of the simple OUI? And we're just spitballing because we don't know. The jury can go back and find. Oops, wait a second. Stay with us, Michael. Let's go into court. Let's go into court. Let's listen what's happening. All right. See if we can get Steve Plort on to join Michael here, if we could. He's expecting something from us, so that would be great because it looks like we got some issues going on. Steve was a highway patrolman in California, so it'd be great. All right. Possibly another question, maybe.
Okay. Let's see. Maybe a question. Maybe they had a verdict. I know you've been following this case. So she's got something in her hand, right?
Looks like a question.
It looks like a question, you think?
Oh, God.
Oh, it looks like it could be a verdict, right?
Well,
or is it
one charge is hung, it said.
Got some input from defense on the side. Well, now it could be a question if she's putting something in the envelope. I think it's a verdict. There's Kim said it's a verdict. I think it's a verdict. That looked like it was a verdict form for me. Missy, let's also get Steve Plort on with Michael. We don't have any sound. Anyway, we can get sound, guys. There we go.
The defense position is certainly not for it. I agree. We can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions.
Maybe a question.
Does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than one count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later, the way the question's worded. If I find this, if we do this, I'll hear from the Commonwealth.
We don't know what the question is, but it's a
We
question.
agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah, I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
We don't know what it
I would
is.
strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say, this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever
you say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, John?
The sound is awful because they're not at their microphone.
It's 10 minutes late.
We just need 1 minute.
Thank you.
Okay, so what's happening is, Michael, you pulled it right when you said it's a question, because you could tell about the note cards. So apparently it's a theoretical question, and she won't answer it. And I guess Alan Jackson wants her to inquire as to, in Massachusetts, as to, what more it is that you're looking for. And she says no, because it's a theoretical question. And then Alan Jackson made some comment that if you don't deal with this, it's going to end up the same position as we did in the first trial. What are your thoughts? You've been following this case. You're a Massachusetts lawyer, and then we came from the OUI right to here.
Yeah, it sounds like the jury was asking what happens if we get a verdict on some of the counts and are hung on the other. So I would agree with the judge. It did sound like they weren't asking, they were asking hypothetically. So she's basically going to send them back and saying, continue deliberating. She probably should give them instruction. If you are hung, then report it. But until then, keep deliberating. I think that's how she'll answer the question.
Okay, so into court listen.
As you suggested just now in open court, it's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict. And that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah, I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course, you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying I can't answer this is sending a false message to the jury. If the court would simply indicate this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns, and it protects Ms. Reed's rights. I think that.
Well, I think that is, this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
Add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
Apparently, the question is the question that we've heard in the past. The jury wants to know, what about if they acquit on 2 of the charges and hang on the 3rd? And the court is refusing to answer that. Apparently, that's what the question is about.
That is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question. It could be answered in an innocuous way that does not affect Ms. Reed's rights.
Okay.
This way it does.
Okay, it was a clear question that the defense first told me to ignore. So
I didn't
is
tell
that.
you to ignore anything, Your Honor.
All right, we are all set. So let's send this in, please.
All right.
All right, let's listen, Michael. I hope you can hang a bit.
Yes, yeah, no problem.
Right. Somehow we've lost did we lose do we have the court feed? Can we get the court feed? There we are. That's the fan of injustice, as I call it, the Sacco and Vanzetti courtroom.
Yeah, the famous fan.
Famous fan. Only fan.
Yeah.
So what happened here is apparently the court wanted to know specifically if they have a verdict on acquitted on 2 of the charges and hang on the 3rd one. Can they do that, or what's the result of that? What does that mean? And she said it's a theoretical question. She's not going to answer it, and it also involved the consequences to Karen Reed and Alan Jackson. I think rightfully put that it has nothing to do with consequences in terms of punishment. They just want to know, could they acquit on 2 and hang on the 3rd? And the answer, it seems to me, would be yes.
Right. Yes. I think she should have given the instruction he was requesting, that she just won't answer it at this time, and then tell him to deliberate further.
Let's see what happens. Although, could that be considered an Allen charge, sort of modified by saying you have to go back and deliberate further? I guess she has to have them come out and say we're hung, right? She has to have them say we're hung, and then she gives the Allen charge.
Right. Yes. It doesn't seem like she would give it based on that letter. I think they would have to say we were hung instead of we might be hung.
Yeah. Okay.
They really haven't been deliberating that long, given the length of the trial. So, but it looks like this jury is going to get some kind of verdict anyway.
Something, right?
Yeah.
And all right, so putting that in, but this is obviously a hard fight. When Alan Jackson said we're going to be in the same position we're in after this trial, after the first trial, if you don't let them, but I guess they want to, they want to make sure that whatever they do doesn't have an impact that they don't intend, I guess. So this was also a very interesting question. It sounds maybe that there's some negotiation that still was going on count 2. And that's why we had the question about the OUI, and that they couldn't compromise. And so then they came back and said, well, what if I think she can tell them you can report a partial verdict, though. I've seen judges do that you can report a partial verdict. I don't know. And then
right. This jury was very helpful to the defense, instead of just saying we have a verdict, they said it was an acquittal. So the defense doesn't have to worry about, fishing for a guilty verdict. So that was, so it's good news for the defense in these questions.
Yeah, per Christina Rexa reported, the courtroom judge is sending back a note to the jury indicating this is a theoretical question that she cannot answer. The jury will not physically come into the courtroom to hear the answer to the question. Is it common in Massachusetts the jurors come into the courtroom to hear the answer to the question, or is it judges send notes back?
It is sometimes done that way, where they'll just send the note back. They don't always bring the jury back for questions.
I would note, and that we do have. Let me see. Oh, we do have your X account. Okay, up there. Thank you. We're putting that up there so everyone can follow you. We have your law office account and your Instagram account, but I'm going to put your X account back up, Michael. So awesome, because he's the man. He knows, as you can tell, he has answered all our questions regarding the OUI and regarding Massachusetts procedure and all. It's, as I said, you never know what a jury is thinking. You just don't know what a jury's thinking. You tried enough cases, right, where they have a question, looks like you're going to have a not guilty, and they come back, or you look like you're going to have a guilty, they come back with like a not guilty, because it's only one person that's asking the question.
Right.
Yeah.
Right. Yeah. I've never had a question where where they've said they have an acquittal. So this would be, certainly if they came back with a guilty after that question, that would be very unusual, I would think. Usually the questions I've had, they don't tip their hand on the possible verdict.
Yeah, we'll see. I mean, here.
But it seems like they might be back in the same position the first jury was in, if we believe the reports that they had not guilty on 2 of the charges and hung a 9-3 for a conviction on the other charge. So maybe that's where this jury is at. It was interesting. They asked about her statements. So it seems they're close to a verdict, but they just asked that So it's possible they're debating how much weight to put to her statements for whatever charge they might be hung on.
Yeah, yeah. Okay, the drama, sometimes the drama is when you're in the courtroom and you have this this silence. Can we bring the fan back up, please? Because I think it's kind of important. I know that the judge is not showing us everything, but you have to remember that people are you know, they probably haven't left. They're milling around, even though the court's not showing them. You know, packing up, milling around. They're not leaving. I doubt anyone's going to be leaving that courtroom. The jury isn't. I understand the jury is not coming back, but yeah. So and specifically, supposedly according to an old law and crime, that if we find her guilty on two charges, hold on a second, that went past. We find her not guilty on two charges. Is it hung on all three or just one? Okay, so that's the same variation of what we heard. They want to know if they report a partial verdict of not guilty and hung, you know, or is something else going to happen? That's what they're wanting to know. That so it sounds like they're in the same situation as the first case, at least with regard to counts 1 and 3. I don't think there was a murder here. I mean, you know, and the fact, you know, the fact that the Commonwealth initially reported in their indictment that there was an intent to murder and then changed it at the end. I mean, everyone knew that was such an overcharge, in my opinion. You know, so, you know, hold on a second, just to serve TV. Hold on. Highway Patrol. I'm passing this by. Let me start so I can get back to it here. CM, now I just had your question. I'm sorry. Highway Patrol, retired. Can you ask the attorney, has he ever had a case where there is a fatality where the troopers did not complete a crash report? So have you ever had a OUI case or DUI case or a case involving a death at an accident or a crash where they haven't completed a crash report? Michael?
No, that you would always see a crash report certainly in a serious case.
Yeah.
There's usually a police report that's going to mimic the crash report, but generally you would see both.
So I hope that answers your question. And for those states that don't have a crash report, tell our viewers what a crash report is. As you have a lot of people here coming from X who don't know.
So crash report, anybody who has an accident and the damage is over $1,000 is supposed to be a crash report. Usually the police will tell people involved in an accident to file a crash report, or they'll fill one out if there's an accident. There'll also be a main police report in most cases where the officer does a full narrative.
And there's none in this case. So that everyone found that unusual, but no one seemed to make anything of it. So I don't know. Let's see. This is all a great question. This was that question. If not guilty, only murder, can they try that again? No, they can't. If there's a not guilty on any count, those counts that have not guilty cannot be retried. The counts that the jury is hung on can be retried over and over again and all. So we've gone from hearing sort of theoretical questions from the jury, according to Bev, one that says, and that's Judge Kenney, one that says, if we find her guilty of the OUI, would she be guilty of the higher charges that involve the death, somebody dying? And the judge answered that appropriately, no, and everyone in the defense was happy. And then that appeared to be, to me, Michael, that there was a negotiation going on to try to give somebody who may think that she's guilty of one of these offenses on number 2 an option to compromise. So, you know, we wait, and they have a lunch inside their room, and then they come out with the question, hey, if we find her not guilty on 2 of the charges, can we report that and hang, basically. That's basically what the question says. And, all. And the judge refuses to answer that. So what is a jury to think of this when they get the fact that I'm not answering a theoretical question? It's a question I can't answer.
I think most jurors will know that they can ask again. and that they'll ask the question differently. They'll sit back there, they'll deliberate for a longer period of time, and then they'll probably submit another question, asking how they should proceed if they're hung.
Well, it sounds like whatever they're going to do it today, except that she has to give that Allen charge, and that may push them into deliberating overnight, which I'm sure they are not going to be happy as we watch The Fan of Injustice, which I love to watch, that Fan of Injustice. It's turning around its air. I'm sure the jury is not going to be happy, because if the next thing is they come out and they either report a verdict and a hung. So let me ask you this. Let's just say they come out and report we're hung, and then they come out and say, and she just dismisses them. We're in the same position, because she won't ask them if they have a verdict on other counts. Why is that in Massachusetts?
I think in this case, if the defense is going to request the verdict, we're definitely going to get the verdict on the other two counts. The last time the defense did not request to see if the jury had a verdict, she said she didn't have a duty to ask, and that if she did, it would have been reversible error, because it would have been seen as potentially her, eliciting a guilty verdict. The last time the defense didn't ask because they didn't know the verdict, so I think they strategically probably didn't ask when they heard it was hung, figuring, well, if you get one not guilty, you're still retrying the case. Why chance a guilty? In this case, they know, or as well as they think they know, that they got two not guilties. So I think if they can, they're going to ask for the verdict on the charges and take their chances on a retrial on the count that's hung. My guess is the prosecution probably drops the case at this point. If there's two not guilties, I can't see them retrying just one of the charges at this point after two hung juries. I think at some point the prosecution needs to recognize that this case was pretty much flawed from the start, and that they need to tell that to the victims and have them move on, essentially.
Yeah, that's what I think. This is different, because now the jury is telegraphing that they have the two not guilties on two of the counts and hung. So the first trial, they didn't telegraph that. So you could end up with what happened in the Weinstein trial this week in New York, where there was last week, there was a hung, and they kept saying hung. And so the defense then asked for the verdict. And it turns out when they came out, they had decided that Harry Weinstein was guilty on one count, acquitted him on another, but was still hung on the third. So he actually got a guilty verdict on the one count, and then they deliberated on the third, and they were still, at that point, they were still hung. So he had both a guilty, a not guilty, and a hung. But so when the defense asked, they got what they thought they were getting, I assume, a not guilty verdict. Instead, the jury came out with a guilty and a not guilty on the two counts. Right. So that's the danger that you have. But here they seem to be pretty smart. They seem to be smart. They seem to kind of know what they're doing.
Right. Yes. Yeah, it does suggest maybe they're more sophisticated, and they're trying to bring this case to closure. It's be impossible. I went to Dedham District Court last week. There's just so many people there, people camping out. The jury would definitely see the massive amount of people there. So they have to know that the community needs them to make a decision on this case.
I think you're right. I think they came into this case. Anyone who came into this case, I think that the likelihood is that they know what's happening out there. I don't buy this stuff that jurors never pay attention. They don't really know. That's just my viewpoint, having tried all these high profile cases. We had one case with the first thing one of the jurors did was send a note to the then Court TV. I mean, he didn't know he knew. I mean, clearly. I don't buy that the jurors don't pay attention. They may not be like going to search the internet, but they may overhear things while they're shopping in their community over the weekend. They have to me, they have to know. They know that, and I think they're trying to bring it to a resolution. That's what it sounds to me. They worked all day yesterday, and they're trying to bring it to a resolution, right?
Right. It seems like that's what they're doing. Yeah.
But if she gives them the Allen charge, she may force them to deliberate again overnight and come back, and then you're not going to have a happy jury at that point. Tomorrow morning, if she does that, you will not have a happy jury. And this will be a very unhappy jury.
Yeah.
If that's the case, right?
Yeah, I think she needs a clear note from them saying that they're deadlocked before she can give them the Allen charge. So if they come back again saying they're hung on that charge, I think she would tell them to keep deliberating on that one charge. And then usually they do an Allen charge. Then if they come back again, well, there's actually a intermediate charge before that. Sometimes they do basically a pre-Allen charge, so to speak. They call it Tui Rodriguez in Massachusetts, and then they would give that charge. So at this point, had it not been for the note, she probably would just give the sort of a modified version, a preview of the charge, wait for them to say hung again, and then give the charge. The defense will probably argue it's a little different because they have a verdict on 2 of the charges. So it suggests that their deliberations are pretty advanced and they really thought through this, that they're not. And I guess the defense will argue we can't have them sit back there too long when they've said they had a verdict now. It jeopardizes maybe compromising the not guilty. So I think the defense is going to push for this to get done as fast as possible, essentially, and ask for that.
Sure. It could compromise the not guilty then if they're thinking they have to go back and they have to wait and get out there, sitting out there and all, because they're feeling that they can't get their questions answered, and they want the jurors want their questions answered. They don't think they're theoretical; they think they're real questions. I mean, they're not lawyers. So it seems to me. So you could tell everybody what the difference between a Tui Rodriguez is and the standard Allen charge, which the dynamite charge, what everyone calls it. Yeah.
It's basically the same thing. It's just our Supreme Court basically adopted the Allen charge. Basically, our charge says that if you're for guilty, listen to the jurors who are for not guilty and determine if maybe you have some reasonable doubt. If you're for not guilty, consider whether the doubts are you have are reasonable. So, and then it basically says no other jury's in as good a position as you to decide this case. And then it tells them listen to everybody, and then it says but they still have to prove it beyond a reasonable doubt. So the gist of the charges is we're going to have to retry this. If you don't decide it, we'll have to get another jury, but listen to each other and keep the standard. So it tries to force them into a verdict, essentially.
That's the whole point of trying to force them into the verdict, and that's what us defense attorneys, and you've been a defense attorney for a long time, try to have juries forced into a verdict. All right.
Right.
So that's so they again, Madeira Beach caregiver. What happened is a jury, they were right out from lunch. They had a note. Which we expected them to do. The jury's asking whether or not if they acquit on 2 charges and hang on the 3rd, okay, what happens? And the judge said, well, that's theoretical, and I can't answer that question, okay, because they didn't say they're asking if they do this, not that they have done that. But we know that if they're asking that question, it really sounds like they have done that. I mean, to me, if I'm Alan Jackson, I want that verdict read and all. And the judge, she sent a note back to them saying that she could not answer that question. All right, so there you go. And then Alan Jackson said, you got to give them more, because or else we could end up in the same situation that we were in on the first case and all, which is caused this. And quite frankly, I blame the verdict form for this to begin with. I think the verdict form, and I know the judge says, well, you have to read it in conjunction with the jury charges. But as a lawyer, I found, Michael, just like the verdict form is horrible, to be honest with you. At least the first one, the amended one may be better, but the first one was horrible. I don't know. What were your thoughts?
Right. Yeah, I did think it was a little confusing. These jurists have never done this before. So for the judge to say this is kind of how we always do it, it doesn't recognize that these are people who may never even have stepped foot in court. Now they have very serious charges with different grids, and for them to see so many guilty options on the form, People have views of the judicial system and respect for it. You don't know what's going to influence or intimidate somebody. So I think they should have simplified it, recognizing that there's no harm in having it in a more simplified form, just because there's no case on it. There's not a lot of cases on the verdict form. So when the judge said, cite me a case, that's one of those things that judges sometimes say, well, there's not cases on it because, if it's a not guilty, it's not appealed. If it's, a guilt, how many verdict forms, cases come down to the verdict form as being your best issue on appeal. So there's a reason there's no law on it. It just doesn't come up that much.
Yeah. Well, hello, Michael Bryant. We have been getting a great lesson from Michael Del Signore, who is the maven dealing with these cases, both on Massachusetts criminal law and the whole operating a motor vehicle under the Influence Act. When you left, but we hadn't gotten to the other question, question 4. But as Michael told us that the operating issues, those two choices under the influence or with the blood alcohol level, it doesn't matter. It's just one operating with two different theories. You don't have
exactly
it's not like
two ways to get to the same result.
It's the same result, and that it would be very unusual to put somebody in jail. I mean, it's all probation, and that Beverly Cannoni was a district court judge, and she probably put everybody on probation who had a first offense. So if she were going to give her 20, the ultimate penalty, that would be very, very difficult. And then he's talking to us about Massachusetts and the whole Tui Rodriguez. The jury then sent in. So then the jury is waiting after lunch with this question, and it's the same one that resulted in the first one. Well, they apparently couldn't get a compromise with whatever that juror was. They were trying to compromise with the jurors by doing the the OUI. But now they said, well, if we have a verdict, if we have a verdict on 1 and 3, and we're hung on another charge, what's the result? What do we do?
Yeah, just like in the first trial, except it kind of tells the defense earlier than they learned last time that they're not worried about those two charges. They're focusing on the glob that is the second charge and all of its tentacles, right?
Right.
So yeah, again, we're back to that same analysis discussion. It's just a joke that what was done the first time could not have been corrected this time, and now they've done this half-ass attempt to correct it, which still isn't quite clear enough for this jury. And then when the judge is asked, well, can they be told basically that they can come to a decision on any of the charges distinctly separate from the whole? And she won't tell them. She won't tell them, well, yeah, you can do that. She won't tell them that. That's outrageous. So just to give you an update, I was wandering back and forth, of course, and I'm listening to what's going on in court. And just before we broke, I'd seen in the chat, somebody had said the jury has another question. And we never really fleshed that out. Obviously, now we know. So there is cautious optimism. I'll put it that way. Kelly Reed, right? She's been in our chat, I believe. That's Karen Reed's sister. She came up to me just to introduce herself, say that she and the family really appreciate what we're doing and the coverage we're providing. And I asked, how's Karen doing? How's the family doing? And she said they're great. They're doing great. She agreed that they're better now than they were earlier this morning when they were total unknowns. Now they have a little more information about what might be happening in that deliberation room. But I think that's what most people feel on the street here, that things tend to be, and again, I'm still, as Diogenes, looking for my one prosecution supporter. I've not seen anybody. So everybody here that I'm hearing from, that they're pro Karen Reed, as objective as we are, they're not. So they're looking at it as it's a victory. If it's acquittal across the board, they'll be upset, but they'll choke down an OUI that does not lead to incarceration.
But Kelly's the cousin. I want to let you know because everyone's
cousin. You're right. I'm sorry.
Yeah. Cousin Liz is the sister, right?
Yes. That was nice that she would make a point of coming up and saying hello. So the family's hanging in there, and I think they're in much better spirits than they were before, even though clearly there's still a lot of unknowns here.
Yeah. So any questions you have of Michael, since he's answered, he's given us time at the spur of the moment, answering everything about Massachusetts procedure and process. And I kind of like it. I'd like Michael to stay on a little bit more.
Let me ask Michael a question that may have come and gone while I've been gone, so I apologize. But I'm looking at the penalties for first offender, second time, third time. It's not even until, as I recall, the fourth time that the maximum penalty changes beyond 2.5 years. I think then it goes up to maybe 5. In your experience, how does that play out in real life?
Yeah, so in Massachusetts, it'd be unusual to even get, most second offenders don't even get jail time. Most second offenders would get a 14-day inpatient program. If you're a second offender and your prior offense is outside of 10 years, you can get what's called a Cahill resolution, where you can get the first offender program. So even a second offender with a OUI over 10 years often doesn't go to jail. Even a third offender, often those charges could be reduced to a second offender. So for an OUI, somebody to go to jail for an OUI, it would be an unusual case, definitely for a first offense. It's not even that common for a second offense. Most judges would give the so-called 14-day program even after trial. So I don't think Judge Kenney would try to impose a penalty for going to trial. I think it would just be too transparent, frankly. If she did anything, then give the first offender program. She hasn't dealt with OUIs while in Superior Court, but she's known to be a very reasonable judge on sentencing, former defense attorney. And when she was in district court, as I had mentioned to Linda before, she would have sentenced countless individuals to the 24D program on OUI. The OUI facts here are pretty slight when you take away, if the jury finds there's no accident, we don't really have her uncooperative. We don't have field tests. It's somewhat of a weak OUI case. If this was just an OUI, I think it would certainly be a not guilty. If they do come back with a guilty on it, I think it's just the jury wants to find her guilty of something based on her statements.
Yep, I would think so. You see Micah's question there, LKB? Michael, what's your experience in Norfolk Superior Court? Any dealing with Kenney? What has made this case different than others you've seen tried?
So it just this case, Judge Kenney, like I said, I had a case with she's been in Norfolk Superior Court. Before that, she would be in Suffolk, so she's kind of rotated around. She's always been known to be a very fair judge, defense background. This case, I just think the attention this case that has come about from this case is really unlike any case we've ever seen in Massachusetts or anywhere else. So it certainly put a spotlight on her. But I think generally speaking, she's known to be, if not a defense-friendly judge, somebody that's right down the middle.
So what happened here? Because some of the rulings she made, Michael, to me, now I'm not practicing in Massachusetts, but I thought they were unfair, some of these rulings. And to me, it sounded like she got an idea that somehow the defense was lying to her and then took it out on the defense, but in open court. And my problem with that was that inured to the detriment of the client and possibly all the people watching, right? They thought she's unfair, and I thought that she should have done it behind the scenes, maybe in a closed hearing, or sealing the transcript or whatever. Any thoughts on that? And while you answer that, at some point, I'm going to just leave you guys for about 2 minutes as you answer this question.
Okay, right. Yeah, the issue with the expert disclosures and the emails, I agree. I was surprised she went after the attorneys like that. Ultimately, she didn't do anything, but I think that was something that she didn't need to do. I think the lawyers on both sides, they're ethical lawyers, and they were doing their best. And if any mistakes, it wasn't to deceive or put any fraud on the court. So I didn't think she needed to go there when she made some of her comment grave, though. I think you're referring to the grave concerns comment.
Right, the grave concerns.
Yeah, I didn't think that was one of the better moments. I think she's had other rulings in the past. Certainly, I don't think that one. I think that one should have probably gone differently.
Yeah. I'm just going to leave you guys for a few minutes. I'll be right back.
Sure. So let me ask you this, Michael, because it was a late ad at the defense request, and that was to put the OUI on the verdict form, despite no specific charge. It is one of the lesser includeds, and obviously none of the lesser includeds are generally a charge. Strategic, what's the thinking there?
I think that was a smart decision. It gives the jury something to punish her on I think the defense is counting on the fact that the judge knows if it's just an OUI, it'd be really difficult to treat her any differently than any other OUI defendant. So I think they were trying to give, with the police officers driving around, the evidence that everybody in the town was driving around drunk. I think they knew that her statements, the evidence of drinking was going to upset some of the jurors, and they wanted to give an outlet for the jury to do something. Like sometimes if someone's charged with, say, OUI, negligent driving, you like to have the negligent driving there to give the jury a little something to punish your client on that's not as serious as the main charge. So given the significance of the charges, I think that was a smart decision to ask for the OUI instruction.
Yeah, and as we're seeing things unfold, at least as we think they are, there's clearly been focus on that charge, and if it's the focus that the defense wanted, it might be playing out exactly as they had hoped. And then if we take your overlay about the real world in terms of punishment for OUI, then it could not end any better, technically with a conviction, however, for Karen Reed.
Correct, yeah. So she would get a misdemeanor conviction out of this for OUI. She would have to do a program, fines and fees. So I think she would be thrilled with just doing the OUI probation again, this behind her. I would not expect the judge to punish her. Somebody can get up to 2.5 years on a first offense OUI. I wouldn't expect her to use the OUI to punish her for what she thought was an incorrect verdict. I think that would just be too transparent.
Yeah, and certainly a lot of folks, because they've seen unusual decisions in this case and in the first trial. I know there are plenty of folks saying, "Well, really? Really? You put that past Judge Kenney? You think she wouldn't do that?" There is definitely that sense. Have you ever seen a first offender, all things aside, incarcerated?
I've seen it, but it doesn't happen much.
Were there extenuating circumstances? What was the situation?
I've heard from one case I've heard was from a judge that was a very difficult, and then other cases where usually if there's some egregious fact, somebody going like 130 miles an hour on the road, somebody causing a serious accident, but it's I've been doing this for over 20 years, and generally speaking, first OUIs, there's no jail time, and even second OUI, people charged with second OUI don't usually get jail; they usually get probation. So, I would. It has been an unusual case, but it would really shock me if she got jail time on a first offense OUI, based on this case.
It sounds like when you've seen it, it's been in connection with, maybe vehicular manslaughter, or at least even if uncharged, there was a death, there was a serious personal injury, something attached to the activity.
Right. Usually it's something egregious about the case. And my understanding is Miss Reed has no record as well. So
right.
It really wouldn't be defensible for her to give jail time just based on the OUI facts. There's not really much to the OUI facts other than her saying she had the drinks. Usually in an OUI, maybe a case where a judge might think they have to punish somebody. They might be difficult to the police. There might be alcohol in the car, people calling 911 saying the person's driving erratically. We don't even have any complaints really about, there are no civilian complaints or things like that. No evidence she was, the video doesn't look like she's stumbling, falling down. The evidence was that one of the witnesses said they thought she was fine, so.
Right. Even a vehicle that she encountered, which was manned and passengered by Commonwealth witnesses, arguably anti-Karen Reed witnesses, had no problem with how she was driving. She missed that turn on Cedar Crest onto Fairview, made a wide turn and came back, and then that other car basically gave her the right of way. There was never any suggestion that she was all over the place. She was. There's just no additional evidence beyond the retrograde blood test. And let me ask you about that, because I'm sure you've seen that over the years. What's your take on how the retrograde evaluation was done in this case?
So the range was vast. I think if this, I think the judge probably should have excluded that from evidence. The range was so wide that it's really hard to say. Usually there should be evidence of a closer range. She basically gave a very wide range. You generally don't see retrograde extrapolation in first OUI cases. When somebody does a breath test, it's presumed to be at the time of driving. If it's within 3 hours, retrograde extrapolation, you really need to know a lot of information to be able to make the calculation. You got to know the first, the last, the timing of the drinks, and things like that. So if the OUI was the focus of the trial, I don't think it would have been allowed into evidence. It was very subjective. The blood test can be affected by other error rates as well.
And that was one of the defense complaints pre-trial, and that was that this was a clinical blood draw at 7:30, maybe followed different procedure, certainly was handled differently, and the court allowed it in. So it's that kind of court decision that makes people wonder, where are the rules here, and what is going to be followed or not followed should there be a conviction on that OUI count.
Right.
So what do you think, as you look at this, if it's impossible really to sanitize this as, hey, this is just your basic OUI case, that it's just impossible. Have you dealt with cases before that have been kind of intermingled with other, perhaps more serious charges? And if so, how did the OUI in those cases work out?
Most of the time, it's just basically been an OUI or OUI serious bodily injury. Sometimes you might have a related charge like a child endangerment, but it'd be usually the OUI is prepared, accompanied by other driving related charges. Sometimes you might have an assault and battery, but that would be an odd case. Typically, it's just OUI, then OUI injury, or like this case, OUI motor vehicle homicide. So they're all usually driving related charges. It's unusual to get other unrelated charges other than the driving charges.
Yeah. So this one are on all fronts. Again, the defense asking for this to be put on the verdict slip. And I guess down deep, they could have thought, well, if the jury truly follows the evidence, they're not going to find her guilty of that either. But I think we can agree that the motivation was to give them an out, to give them a compromise. And if it's going to go that way, so be it, because the penalty is, we can handle that.
Yeah. Yes, exactly.
Okay. So hi, I'm back.
Hey, I heard somebody's giving us a countdown.
I told Michael let's there be 5 minutes that he'd be on, but no, we're just taking advantage of it because he's got information that we don't have and that no one has reported on in terms of how you.
And just full disclosure, Michael, we tell that to everybody, and we get them on here, and we take what we can.
A bunch of questions from our members. Does Attorney Michael D. have any thoughts on the accident reconstruction experts?
I thought the experts the defense hired were fantastic. They were very, very well qualified, credible. They answered the questions the way they needed to. I thought the experts they hired were terrific. It was interesting to see all the cross-examinations of experts throughout the trial, and how at some points the defense attorneys would try to get more, and the experts would fight back. And we had examples where the experts got the better of the lawyers got the better of the experts. So it was really interesting from a legal point of view, all the cross-examination of the experts in the case.
How about the Shannon with one N, Burgess, and the CV? Talk to me about what you were seeing in real time, being a Massachusetts attorney who does this type of work.
Yeah, that was probably a surprise. I believe for the prosecutor that if he can't get his resume right, it just undermines his credibility to the point where now you can't take anything he said seriously. And the prosecution had to go to a lot of lengths to try to rebuild him, saying that, he found things that other experts didn't find. But that just, the credibility, it starts with that credibility. And if they can't get that right, I think a jury's not going to believe what they say.
By the way, I have to tell you that Amy Love Soccer says Sue of Boston 10 reporting defense is stressed. Well, I think they're stressed because the jury is now in there knowing they have 2 not guilty verdicts, which you pointed out,
Right.
and you could possibly compromise those not guilty verdicts by not answering their questions. So let me ask you this. Hey, Paula, why do you think the judge took herself out of the rotation to oversee the case? Michael?
I have no idea. I didn't know.
Sure, Michael D.
I don't understand the judge.
Was she in a rotation to see this case, or was this just assigned to her?
She's the presiding judge, so my understanding is she gets to pick. She gets to take the case if she wants it. So I think she assigned herself to the.
Yeah, and she's not taking herself. She wasn't taking herself out of that case. So Michael Bryant, Michael B. I got Michael B. and I got Michael D. All right, so Michael B. What is you've seen a lot of different high-profile trials. What do you think the defense's next move is? Now they know they have a jury sitting there, hypothetically, with 2 not guilty verdicts. That and the judge says, basically, I'm not going to answer your questions. You just felt like the most important jury in the world, and now you're not feeling so important anymore.
Yeah, I would definitely be making a record that the court should advise this jury that they can come to a unanimous decision on any or all of those charges and make those known to the court. That way we don't have the, if it goes to another hung jury, we don't have the after the fact affidavits from anonymous jury members that go to both the prosecution and the defense saying, hey, we were unanimous on 1 and 3 right out of the box. We were all hung up on number 2. So you can avoid that if the court will make that very simple direction. Will they? I don't know, but I would definitely make a record about it so that on appeal, you can point out just one more thing that she did wrong. And that's clearly reversible error. So that's the move I would make. I'd keep my fingers crossed that they're going to come back with a verdict here, but I'd be ready for that if they don't.
Michael D. Now, we saw a case, ASAP Rocky in California, on this issue. I haven't changed issues, where the judge in his original charge said to the jury, look, you can report a verdict. If you have a verdict on several of the counts and you're hung on any of the other counts, you can report out the verdict that you have come to. Why is Massachusetts not allow that? Or do they allow it? And why do they not allow the jury to be told that? Or are we getting it wrong?
So you're saying those states, they allow the jury to announce the not guilty and then go back and finish deliberating?
Or announce that they're hung. They've come to a verdict on one and they're just hung on another before there's an Allen charge.
Okay. They can report a partial verdict and say they're hung. It's just, I think the judge, the way the judge is doing it is she's just waiting. She's not going to let them they're not going to deliberate. Once they announce the verdict, the case is done. So I don't think she wants them to come back and say, and she wants them to say they're hung on the count 2. They have a verdict, and I think she's going to keep them back there and not. That's going to be, I guess, the defense next request. They're going to ask to report the verdict while they deliberate. Will she allow that? I don't think so. I think she's going to ask them to come to a final determination on the charge they're hung on before it's reported in court and before she discharges them.
Okay, so here's the problem. Apparently, per the reporters in the courtroom, Karen's 4th question actually came in before the other 3 were answered. So while they're working on the answers for the 3, they got the 4th question. Does that create?
Which is the seminal question. I mean, that's.
So, Michael Bryant, let me go to you first, then I'll go to Michael DeSignore. Thoughts on this? This to me seems to be an issue.
Oh yeah. And was she aware of that, and decided not to address it until? Remember, she then declared lunch until 1:30, and she had the parties report back, which we thought was a little odd, because why would they report back if the jury was just going back to deliberating? They'd go to their neutral corners and be ready for the phone call. I think she had to come back because she had that 4th question already in front of her. And now she buys herself an hour to figure out what she's going to do, gets the parties back at 1:30, and then acts, it seems to most people watching, as if, oh, it's a new question. And it wasn't a new question.
And so, Michael, did the answer to the first three then, were they wrong in any way? Because we know now there was a fourth question that we weren't, or at least aware of.
I agree. I think she should have answered them all at the same time because they're part of the same inquiry. To delay it, to have them deliberate without their main question answered, I think was a mistake. I don't know that the defense has raised that issue yet. I didn't hear it, but I think they probably will say that they should have been aware that the questions came in simultaneously rather than three, then one question.
I heard Alan Jackson say something about this question had come in, Your Honor, beforehand. I heard him say something, but it was hard because he's off mic now when he speaks. You know, he's not. They're all off mic, so all we're getting is what the microphone at the lectern can pick up, and it's very, very difficult to hear. Okay, with regard to it, but yeah, so we're all in agreement that question should have been answered. So it sounds like it sounds like to me that this jury has acquitted her of murder and obviously leaving the scene of the accident knowing somebody is dead. All right. It sounds like the jury decided there was no collision. She didn't hit John O'Keefe, but somehow I don't understand why. And Michael D., let me start with you. Why we can't report out on that seminal issue? That's the biggest issue of the case. You know, that's such a big issue. I mean, I don't get it. Unless that's why I think people seem to think that Judge Kenney is railroading the defendant. Your thoughts?
Right. The question, did the question say they reached a verdict or what if we reached a verdict? Maybe
what if? I think it was what if.
I think she's still hanging on that it's hypothetical. And she wants to have the verdicts all announced at the same time. I think she should have advised them clearly if they have a verdict on 2 of the 3 charges, they can do that. And then she can instruct them to keep deliberating on the other charge. But I think that should be clear to the jury that it's permissible for them to have separate verdicts on each charge and announce those to the court.
Yeah, and she seems hesitant to do that. I mean, she's been asked, very directly and specifically to do that, and she just won't. She won't do it. And for those who may think, well, this is a weird request. How come they're thinking everybody should do it? We just had the Harvey Weinstein case where the jury came back with a conviction on one count, an acquittal on the other, and then went back to deliberate on a third count, which they ultimately ended up being hung on. So it's not weird. In this case, the lack of direction is weird and wrong.
Yeah. By the way, when Aiden corrected himself, so we'll correct it. It wasn't Alan Jackson who said, yeah, there were good questions with the 3 questions early on. Apparently it was Karen Reed or something, because Alan Jackson was under a gag, so he couldn't answer that. So Aiden corrected it, so we're correcting that report that we made. We can only tell because we're not in the courtroom. We didn't get into the randomizer because, all right, so let me go to the, we were the ones that had to sue to open that First Amendment zone. In case you haven't been following, Justice Serve TV, Michael Bryant was one of the original plaintiffs because he was the one stopped by the state police on that First Amendment zone. So we had to sue to open that First Amendment zone. We tried to get a press pass, which we've had in 100 Center Street. Not a little the courtroom. We've had down in Florida. We've been to Atlanta. We have a lot of 15,000 followers. And so we apply under the rule, and Michael will tell you what it is, Michael B, that to get a press pass. And we get denied on the basis that Massachusetts doesn't believe that YouTube streaming, which is the largest streaming platform in the world and where everyone gets their news these days, is media for the purposes of a press pass. All right. I was thinking of actually calling you and hiring you, Michael, on this. Okay. We decided, okay, we're not going to get into the randomize. We'll stay outside and we'll do our thing and we'll do our contribution of reporting by breaking up that buffer zone and making it a First Amendment zone. But have you heard that before? I mean, I don't want to put you in the spot because I know you have to practice there, but have you heard that? Is that something that goes on at all?
Denying access to the press? No, I wouldn't think that would be an issue here. I didn't know that they would have denied based on YouTube or media is the media nowadays. As you said, more people get their news from streaming than from reading, the local paper. This is a great method. You have people asking questions. It's more interactive. It's certainly a greater way to learn about the law than just reading the paper.
Yeah. So,
So for those who might be looking for a credential down the road, her name is Jennifer. They do that up in Boston. She's a moron. So don't expect any breaks from her. But, read your own rules, folks. When it says anybody from any medium that reports on matters of public interest, kind of a broad definition. So, and if Jennifer, if they're making you do that, quit your job. Go somewhere where you're respected and you can follow your own rules, because it's an embarrassment.
All right. Thank you. Blessed in Texas. By the way, Linda, eyes are lovely in pink, gray color on all. We normally have Fashion Fridays here, I want to tell you, but we don't think we're going to get to Friday on this case. Michael, this is your thank you, Blessed in Texas. So we do fashion. By the way, if you're interested in fashion, we do have a merch store, Justice Serve TV. I am wearing the leggings today, the yoga leggings. Yeah.
Michael's like, what did I sign on for here? What is going on?
It's the truth. It's the truth. So we do, we have a lot of women who follow us and are interested in fashion. So we try to lighten up a little bit sometimes. And this morning I answered questions about my glasses, which was like fun. I have a different pair on now. And also, so Fashion Friday became Fashion Tuesday. All right.
Nice.
Anyhow, all right. So all of you in the chat, do you have any other questions of Michael Designero? Because I told him it'd be quick, it'd be 5 minutes, and now we've kept him on for like 2 hours. All right.
That is abusive, I have to say.
It really is. But
my pleasure.
Okay, I'm going to follow anyone just before you go. Follow him on Massachusetts DUI attorney. He is the best. As you can see, you had a treat here today with him. Also, his law firm, we'll put that up there. But you really had a treat. And we may call on him again if Karen Reed gets sentenced and all. But Michael, let's not wait another 7 years. I'm so sorry. I told him.
Nice catching up with you, Linda. Nice talk. Nice to meet you, Mike.
Nice to meet you,
Thank
Michael.
you very much.
That's it.
All right. So I think I poured, but what happened is we had so many questions that came, and he was so knowledgeable, as I told you he would be, right? When I mentioned,
it was great. That kind of local knowledge is so important.
Yeah, he's so knowledgeable, and I'm hoping that tomorrow we'll be able to cut that and run that as a standalone, because he deserves the recognition. And you haven't heard that from other networks. You haven't heard somebody in that depth who could tell you about the OUI and what it means and what the penalties are and who the judge is and what the options are and what you would do. And also with regard to the jury charges, because he practices criminal law. And he runs these seminars every year that he pays for to bring lawyers in who who haven't been versed in the process of forensics and criminal law, to train them himself. Okay. Pro bono donation himself to bring them in. And I met him by accepting one of his seminars. And again, he pays for them himself, Michael. $1,000 to train lawyers. Thinking
That's
that
great. This is a profession where we like to give back, right? Where we can, how we can. You're making millions at the Harvard thing, right? When you do the Harvard.
No, we do the Harvard thing for free. Yeah, that's a donation.
Go.
That's our pro bono donation to the Harvard. And they also ask for us to pay for our expenses if we can. And of course, you end up doing. So, Harvard, who has the biggest,
The endowment is like, 50-some billion? Throw you a bone, give you something.
We are lonely lawyers paying, and donating, because you're donating, not only that, you're donating your week of your time. So you're not able to other issues, and they work you. You're working from morning to night. The first year I did it, I was exhausted, because if there's a seminar and it goes from 2 to 4, you're expected then to be cross campus at the other place at 4 to start the next thing, and then you go someplace else 4 to 6, and then you spend time at 6 to 8. Then you're 7 to 9, maybe you're 7 to 9:30. You're dealing with nighttime presentations. Then you got to get ready for the next day. So it's exhausting.
Yep. I get it, and they're lucky to have you guys do that. And of course, Judge Kenney is one of your fellow professors, adjunct professors there. So.
At week 3, okay. But it's interesting to hear Michael say, and some of our people have said that. Look, she said the previous trial that she found the woman not guilty, right? And all, she was very fair, and that Michael said she's known as mostly defense oriented.
It's so interesting to hear that, right? When most people's only exposure to her, and what was it McGee? Was that the name of the other case, which was the heart attack death blamed on the spouse?
Yeah, that's
when it was a bench trial, and she acquitted the defendant. So, other than that little tidbit, which we shared because we had Joanna on, who had been in the courtroom, so we were able to get into it in a little more depth. But most people's only experience with Judge Kenney is this trial, now part 2, and the impression left ain't one of fairness, is not one of defense oriented. It is none of those things that apparently her reputation brings to the mix if you practice here, more regularly. It's weird.
Yeah, no, and that's and Michael said he was surprised the way she ruled on some of those issues. He was surprised by it because that's not what her reputation. That's not how she functioned. So as I said, there was something obviously, and he didn't see it. He thought that there was a nothing burger, right? He said there was a nothing burger. There was no ethical violations. You were dealing with ethical attorneys, so he was shocked by that whole grave concern by it. So that it was to show you that maybe there's some cases. I don't know. There's just some cases.
And it was nice to hear from Michael that our speculation about first time OUI without extenuating circumstances, even a second time, he said, even a multiple, very seldom gets incarceration. They get probation. They go to school,
right?
And that's it. So again, everybody is so cynical about the process in this case and the judge in this case that they take that and they say, well, that's very interesting, but it doesn't assuage the fear that, but in this case with this judge and this defendant, I can't rule out. I don't see her being cuffed and hauled away, but there's a lot that can be done up to and including incarceration that would not surprise me.
And so it's interesting to have it. I mean, we just got a treat, Michael, joining us here on Justice Served TV. By the way, we have a fashion question, which I am going to answer. Okay. For all of you. Okay, Blessed in Texas. I don't know about your waist size. I can tell you that I took a size down on the leggings. I found actually on the black ones. I found the black ones ran big, and that the white ones and the green ones ran more true to size. But I found that the black ones ran big a little bit, and so normally I would take a medium, and I had to take a small. So you're gonna have to use your own judgment because, and I found that the white ones ran just kind of true to size, just so you know. So leggings are leggings, and yoga leggings are funny. Sometimes they stretch and sometimes they don't, but that was my experience with them, Blessed in Texas, just so you know. So anyhow, that was, I sorry to answer that fashion question, Michael, but I feel like
thank you. I'm sorry, I wasn't listening.
Well, we're selling things on the merch store, and we have cups and we have things, and all people want to buy, and if they have a question about it, I want to answer it because it's expensive to buy things wherever you buy things today.
It definitely is.
People are going to do us a favor with their hard-earned money and want to answer the questions. I hope I gave you all the answers that I can give you with regard to that. So now,
was it the truth and was it honest?
It was absolutely the truth, and
you can't do any better than that. I was answering a text, actually a response to a text from mine earlier about a guest that I've now sent a link to, and maybe the guest will show up, maybe not. I don't know, but the wheels are in motion, so we'll see.
Okay.
So it's been pointed out we have now rocketed past 227, which was the poetic, ending to this case that a lot of folks thought might occur. I don't know. Does that mean tomorrow at 227?
Well, it's got to go tomorrow because unless they come back with 3 not guilties right now, right?
They're going to get the charge, the TUI charge, the dynamite charge.
So they either have to come back. Linda, my question is, the question about your merch was hypothetical. But I didn't answer your question, college consider. Okay. Put your hypothetical question in. Okay. Blessed in Texas said, thank you, Linda. All right. Don't fool me. I've got this. but they have, if they come back with the 2 not guilties and then the 5 under number 2, as they indicated, they would go home. But now the danger is that they could obviously also compromise on a higher one, a number 2, just to get out of there, right? Just to get out of there. And that's the danger. That's what the defense is feeling.
And
right?
maybe, maybe if they're in the same position, heaven forbid, we're here tomorrow. Tomorrow is the artificial Friday because Thursday is the holiday. Maybe at that point, whoever is, got their neck bowed finally just says, okay, all right, let's just get out of here. Let's do it.
Right.
Maybe that doesn't happen today, but maybe it does happen tomorrow.
Well, if they come back and say, we're hung on any charge, she's going to give them Allen charge, then they have to have time to deliberate. So that, and then she sends a note in a 4. This jury doesn't really want to come back tomorrow, I don't think, but they may be stuck coming back tomorurw.
Yep.
They're not coming back past Thursday. I can tell you that right now. This ain't. I mean, they're going past Thursday.
Tomorrow is the first Friday of the week. Yes.
Yeah, tomorrow's the first Friday of the week because they have a holiday on Thursday. And I think they're tired too, when they've been in there. And quite frankly, they asked the judge a hypothetical question.
They get nothing. They get nothing.
I'm with the jury. I'm pissed. I'm not pissed at Karen Reed. I'm pissed at the judge. And I'm saying, okay, you want to go home? Not guilty.
Thanks for nothing.
Yeah. Guilty. But the defense is worried that they want to go home what the defense is worried about is instead of compromising on number 5, they're going to compromise on something higher. To get out of there. And that's the danger. That's the danger with the Allen charge. But now that's really the danger because they can't get an answer to a question.
Yeah. And questions that should not exist because they should have been headed off at the pass and handled during the instruction process.
Right. And so that Alan Jackson could have said, this is a not guilty to any of these. You find no collision, not guilty. Okay. Yeah, no collision, no collision, no collision, not guilty. Okay. Wow. I'm sitting here and I'm thinking to myself, now what's the jury doing? Now they've been quiet now for the last 45 minutes. They've been quiet, right?
Yeah,
now
they got their answer or non-answer. Yeah.
Well, would have made a difference if they had, think about this for a second. If they had answered question number 4, which came in before they got their answers to question number 1, 2, and 3.
They must have been thinking, why in the hell is she answering those questions and not the first one we sent out?
Right.
I mean, that would be weird. And it's just, I wish I was surprised, but I'm not.
I'm not surprised either because you create a problem. And the problem is you create a problem that inures to the detriment of Karen Reed. It's not that this is a problem that is to both parties equally. It's to the detriment of Karen Reed.
Absolutely right. Tubi is not happy about it either.
Tubi is not happy about that. And as I said to you, and I know she has a reputation for being fair, but I tell you, when Alan Jackson said, when he was talking about the weight of the videos, of the interviews, and he said the evidence weight, if any, right? And she said, oh yeah, I'll do that. That's the law. And then when Hank Brennan later objected, and you could just see, oh, he's objecting. And then she started turning papers, right? Papers, and didn't say anything. And you thought she was talking about something else. I
did, yeah.
And I said, no, she hasn't answered that first question because she was looking for, she couldn't find any place that helped it. So then she says, yeah, I'm not going to say if any, in all. And I thought it was interesting that Michael DeSignore said, hey, she says, give me a case on the jury verdict form. And he said, well, there's no case because if it's a guilty, of course, I have a case. And if it's a guilty, there's a lot more important issues usually in trial than the jury form. This is a one-off.
And remember, first time around when this request was made, Alan Jackson, he was honest. He said, well, no, there are some other jurisdictions that have addressed this, but nothing in Massachusetts. And of course, it's just, well, if it's something very close to Massachusetts, maybe that's something that we can look at. It'll help your position. Well, I don't think she ever intended to give that clarification anyway. So now, ironically, doesn't help Karen Reed, doesn't help the defense in this case, doesn't even help the Commonwealth, whether they admit it or not. But the fact is, this now may be the case that goes up and makes new law in Massachusetts about how they handle the vagueness of that jury instruction and the request that the defense made, which was denied.
Which was, of course, I mean, I'm getting used to hearing. I mean, you don't even have to. I mean, just put it on Robo here or something like that. Yeah. Okay. So it's I don't know. I don't know. Is the jury then arguing about whether well, wait a second. There could be an alternative. Let's see this. All right. Jury's not guilty on 1 and 3. Let's put that out there.
Okay.
Now, this is hypothetical. And they had sent a question specifically about this operating, right? About number 5.
Okay.
Could they be hung just on that? Could they be hung just on that?
Sure. Meaning that they figured out now that it's not like a menu where they pick one from each side. They've narrowed it down now. They're looking only at OUI, and they have conflict between those in the jury that think it was proven. They believe in the whole retrograde analysis. They're fine with that. But there are others that don't. That's what you're suggesting?
Right. Could that be the possibility?
That's certainly possible. Yeah. Yeah. Talk about the best scenario possible for the defense, really. If that's what they're now fighting about, yeah. That's and if you've got to put somebody in a headlock, that charge is one that I think you're more likely to get their approval on. Because, on its face, people can tell. They don't know what the punishment is per se. But I'll bet you most people on that jury understand OUI. They understand the nature of the crime, that it's it's not a felony. They may even know that. And that, convicting somebody of that, it's an easier cave in than convicting somebody of a far worse crime.
Yeah. Oh, boy. That's all I can say. Oh, boy. I don't know.
Boy.
I don't know what to say. I know today we had a plan. We were going to replay Buchanan and we were going to replay McKay, but I don't think people are interested in that. They want to hear what's going on, what the analysis now. They want to hear every little bit coming from that courtroom, right? We want to hear every little bit coming from that courtroom. We want to hear a little bit coming.
I want to hear more than is coming from the courtroom. Yeah.
Well, I don't
very frustrating.
Want to hear more with regard to a guilty because.
Well, no, I want to hear more details. I want to know what's happening, what's really going on. I want to be the proverbial fly on the wall.
Right. And that's exactly right. The proverbial fly on the wall. That's what we want to be. And that's why I guess, you were around the courtroom. Did they have to clear the whole court out when there's no court, or is she letting reporters and people stay in the courtroom?
That's a good question. I think she's allowing them to kind of come and go. So, like Aiden is right there and he's walking back to, hi guys, are you taking a break? Are you spending more time in there? What's the deal? Yeah. So what's the deal with the fourth question not being asked until after the first 3? What the hell is that all about?
No idea. It's like she likes being on TV.
Aiden Carney.
Hey, Aiden.
Yes, well, that's what I thought was odd. Why is she bringing them back specifically at 1:30 if we're going back to deliberate? And that gives herself an hour to come up with some Mickey Mouse way of addressing it. That's just wrong. That's wrong.
I think the jury's just going to be like, fine then, not guilty. That's what I think they do.
They certainly got that option. Think it's going to happen?
They are no longer debating. It is no longer up for debate.
Hey, Aiden.
He was hit by a car. The jury has determined that has not happened. Right. They're not debating it. They're like, we're done with that. They're just stuck on this small issue of, is there reasonable doubt that she was over the limit when she drove the car? That's the only thing they're talking about.
How smart does the defense look now about throwing that in?
Yeah, that's what you say. But can't you conversely say that we be home by now?
I don't know, because you know what happened last time? They were looking for something and they could never find it.
It's like they seem to agree he wasn't hit by a car. So now they're just stuck up on this issue that doesn't really matter, and about drunk driving, which no one got hurt like 3 years ago. And we're all sitting here waiting to decide this inconsequential issue that doesn't matter and didn't affect anyone.
And once again, the court refused to tell them that they can pair out their guilties, not guilties, and move forward with the one they haven't decided.
Yeah, she wants a mistrial. She loves being on TV. There's no other explanation for it. She is addicted to being on Bev. She loves being talked about. She loves being made fun of. She loves just being the center of controversy. Some people love that stuff. She gets high on being. She never wants the Karen retrial to end. That is what this comes down to. Period.
Well, hopefully she does not get her wish.
Yeah, exactly.
Yeah.
I think that if I was on that jury, I'd be like, fine, screw you then. Not guilty. Let's go home. That's it. We're quitting her.
And they just might.
Yeah, that's what I hope they say.
Bravest, strongest woman out here, Meredith. Always nice to see you and your smiling face, supporting everything going on. Yeah, so hang in there.
Yeah. Tell Aiden to watch the Mike Easter interview because it was great. He's great. We'll try to get him back on.
Okay.
Yes. Okay. Cameras follow him everywhere. I saw a big camera. He can't even go get a.
I know. Well, Tim came over and was actually shooting us doing our thing, and then as he finished doing that, he even went and shot our Starlink on the latest version of the JSTV mobile unit. I have my truck now because I've had the Acadia that I mentioned, which is basically the GMC version of the Traverse. That's my son's car, and I've been taking it on the road. He's back. He's now working in Pittsburgh, so he took his car. And dude, what? So this is my truck, which for those who watch some of my DIY videos, it's a truck. I use it for truck things, but I had no choice until I replaced his vehicle with another car. So the truck is in play, and Tim was shooting that and our little installation here. And then Aiden and Meredith came back from grabbing a snack and they're heading back to court now. So I'm glad he came over to chat.
They can't do anything without the following. I mean,
Oh, yeah. Yeah. Well,
but he gives us good information. He gives us good information. But now we know that he's not in the courtroom. All right.
At the moment, no, he's going back right now. Yeah, he's going back right now.
He's not in the courtroom. So if you're looking for his tweets to see what's happened in the courtroom, it's not gonna matter. So now the jury is back in there, and they're trying to not be hung, I guess, on the one issue, right? On whatever issue that they're hung on, and that's
and you heard Aiden's take on the adding of the OUI, where I think it may end up resolving this case. He's not so sure. He's thinking now they're they're futzing around with that low level, virtually irrelevant charge, and if they're hung on that and the judge does not allow them to articulate their unanimity on the other counts, where are we? We're right back to square one. So I understand that fear. I'm a little more optimistic, but I don't know why. Maybe I'm just naive. But I think with nothing else, the worst case scenario, we get past charges 1 and 3. I really think that the court is totally on notice of that now. Wasn't before until after the fact. And I think that's a huge difference.
Yeah, and the defense too. But the defense is worried that they're going to compromise on that by being back there because, they're back there. Okay. Just what can we say? I mean, but I'm telling you, I don't know. I know that Aiden liked juror number 1, and I would too. I think juror number 1, the 4-person who is obviously dealing with these notes, is very sophisticated and all, is going to get up there at some point and say what I've been saying forever. Look, our job is not to decide what happened. Our job is to decide what the prosecution proved this beyond a reasonable doubt. And the fact that no one can decide this beyond a reasonable doubt right now that we're hung means they didn't. Let's go home. Quit her and go home. So yeah. That's my vote right now.
Okay. Okay. All right. And I think Aiden's vote is similar with a curse word thrown in. Hey, did you hear that sound?
Yes. I meant somebody.
Should I bring on our surprise guest?
Yes.
Okay. Here he is. There he is.
Woo! It's Jersey Day. Jersey Day of Justice. Jersey Day of Justice.
What's up, guys?
How's it going, man? Now we know you have very important appearance on Court TV coming up, so we can't keep you all that long, but we will just because. So you've been watching this thing unfold.
I have not.
You've not.
I have not. I actually work as a real lawyer too.
No.
So do we. But when we work in the middle of the night, we're up all night. We haven't slept in 6 weeks.
I'm not famous like you guys.
Yeah. And then you squeeze in the EMT work. You got to do that, right?
That's tomorrow, Thursday.
Thursday, yep.
Oh, Thursday,
Okay.
Not Mondays anymore. Okay.
You need any CPR? I got the best hands in the business.
You don't use the Lucas machine? You guys have a Lucas machine, right?
I do. The Lucas game changer. I love it, and I'm impressed you know what it is.
Well, I try. Well, that's because it came up in this case when they were talking about injuries to Officer John O'Keefe's body. They had to talk about the Lucas machine, what it was. I was surprised that it's 100 compressions a minute. That sounds like a lot to me. But that's what they said. The doctor said that's what they set it at.
Yeah, we actually set it at when the EMTs first get there. It has two settings, 30 to 2. And then when the paramedics get there and they intubate, then it's just a continuous pumping, and then it gives a breath every 5 to 6 seconds.
What's 30 to 2 mean? What's 30 to 2 mean?
You do 30 compressions and then 2 breaths. But once you get intubated, you don't do that anymore. It's just continuous compressions, and then every 5 to 6 seconds you bag them. So like when we used to do it in the old days, you were doing it on your own, and when you're doing compressions with your partner, at 30 to 2, you get really tired. It's an exhausting process. So the Lucas is actually, if you go to my Twitter, if anybody goes to my Instagram rather, you'll actually see. I was at an event at my rescue squad a couple of weeks ago, and they were using the Lucas on a mannequin, and you'll see it. It's pretty cool.
Yeah. That's where I first saw it, and then I heard him talk about it in this case.
Isn't it also pretty violent in the sense that you're going to get damage when you do these compressions? You're going to get fractured ribs. You're going to get bruises on the liver and bruises on the,
Linda, I just fought a 3-year battle on a shaken baby case where my client, I believed, was falsely accused. And one of the sequelae that they found was that the 5-week-old baby had a fracture in the back of one of its very hairline. In fact, it wasn't even noticed on autopsy. It was only secondarily they found it. And I was trying to explain to the prosecutor, and eventually we got our experts, that when you're doing back blows on a baby that's choking and you're trying to resuscitate it, it is not a genteel process. And many times you'll be doing compressions even on an adult and you'll crack a rib. And that's why the Lucas is great, because it's delivering exact, consistent compressions at the exact rate. Not that you won't crack a rib, but human error is much greater. May I add, in that case, by the way, they eventually conceded that the shaken baby syndrome was inappropriate, and they dismissed it because the baby actually died from a virus infection. Wow.
Well, good for you, because that's an issue I know in a case. My husband testified in Ocean County because people don't want to believe it. And shaken baby syndrome is nonsense. Okay, it's just nonsense. Most states don't even allow it anymore, and all. But then there's some states that do, because some of the doctors won't get off it.
Well, Linda, I just, by the way, I consulted your husband on this case in the very beginning.
I don't even know that. See what I know about my husband's cases?
Yeah, it was during COVID, and he wasn't really, understand people were locked down. But listen, you are right about this, and I think that this is relative to this case too, and Karen Reed. This is why I am so hypersensitive about quote unquote expert testimony, because I've been around long enough to watch that everyone just presumes the expert testimony. It sounds really good. They come in with lots of letters after their name. And in the end, it turns out to be junk science. And you are exactly correct about shaken baby syndrome. In fact, in New Jersey, the appellate division just wrote like a 60-page decision saying under the Daubert standard, or Fry standard, that's the issue here, that it is not scientifically reliable, and it's now in our Supreme Court. It may very well be thrown out because everyone recognizes it's now groupthink. It was not scientifically based evidence. And I see that with all these kinds of these experts getting up, like in this case, opining about things with this level of sophistication that can be very influencing to a jury. And if one side does not get a proper expert to rebut it, innocent people go to jail.
Right? You're absolutely right.
We've talked about the the DNA stuff is fine. I get it. But that cell phone stuff, that and we talked about that with Michael Easter, who we did an exclusive interview with yesterday. And he agreed. He said it's great for certain location information, but not the specificity with which they try to sell you that story. And in this case, it was super confusing.
I got to interrupt here. You got Timothy over here, says he's an EMT. He works in the EO. I don't know how this is coming up on my screen. He hates the Lucas.
Yikes.
It's never positioned properly, never in proper placement. It is
That's not Lucas's fault.
Rescue Squad. It's always in a proper position. But hey, here, Timothy, let me just say this. I don't know if you've ever done a call, if you're just in hospital or if you're at a hospital. But the thing I love about the Lucas, you're right. You got to make sure it's properly placed. But you know what? Continuous compressions are the most important thing and the most important reason CPR is not successful. And when you're moving somebody down in a Reeves stretcher, 3 flights of stairs, and you could still have compressions going on, I think it's pretty damn useful. So I respect your opinion, but I really love that. Look, you guys have everybody watching you. Everyone is watching this show.
We also have you, the Rizzler. What is that story about Riz?
Unspoken Riz. There it is. Yeah.
Unspoken Riz. You didn't know what Riz was. You had to go ask one of the younger people on the rig. Riz,
Yeah, well, that sounds
what?
like some guy said I hadn't spoken Riz. What's that mean?
It's a good thing.
It's a compliment.
Great story. Just great. You know?
So if you haven't been watching this all that closely, what's happening on Court TV? I know they got a verdict in another case they've been covering. So what's the appearance? Give us a preview.
Oh, it's gonna be on Karen Reed,
okay.
and a little smattering of Diddy, and two cases that I just did. If you go again on my Insta or whatever, you'll see just before I jumped on here. What fascinates me about Karen Reed is how where you sit is where you stand. They say how people can look at the same exact set of facts with the same law. The law is the law, right? Both sides here, the same law. And yet can be so vociferously on one side or the other in the interpretation of a particular case. And I find Karen Reed to be wild, in that way. And I have a lot of viewpoints on it. You guys know that, like as a former homicide prosecutor, as a guy who ran a prosecutor's office, I believe very much in doing the best job you could of dotting I's, crossing T's, making sure there's no politics, nefariousness, officers that aren't temperamentally fit to be investigating a case. So I have a lot of problems about the way the case was investigated and some of the characters in the case. But that doesn't necessarily mean that they got to the wrong conclusion. And so I'm just curious. I'm throwing it back at you guys. I know we're just kind of spitballing here. Like, I just don't think the top charge is ever going to stick. I've said that from the beginning, and I believe that terribly. But I think jurors analyze cases differently than we do. I think that we nitpick. We talk about how, Proctor, this, that, and the other, and that's all in play. But at the end, I believe the jury goes in there and they recognize, here's what I think they first do. Can I go there, guys? Or can we go
Sure.
here? Yeah.
We've been on for hours. Knock yourself out.
All right, we're riffing. Okay, good. So, they go in, and in the end, they have this weighty decision. And I think good trial lawyers need to know this. All the good tricks. I've watched lawyers pat themselves on the back at what a great cross they did and how amazing, and then lose the case because they have to go in and they have to balance it. Someone is dead here, okay? And someone's liberty is at stake. They know that, even though it's not really discussed. They know that. And so they're not looking at all of the tricks. The question is whether or not those quote unquote tricks substantively affect their judgment, because they know if it's a not guilty, then they've given Karen Reed a major break, or if it's a guilty, then they haven't. They want to get it right. We want to sit here and armchair quarterback about what I would have done differently. I do it all the time, and it's kind of crappy to do because when you're in the heat and when you're doing things unfold. Everything's not scripted. It's a difficult process. But in the end, I just think that the part of common sense is going to rule here. And when she goes back and she's saying things like, maybe I hit him or did I hit him, it's going to be some level where they're going to say, they're going to have to buy, if they're going to get around that, they're going to have to.
You blew him off his train of thought.
Yes,
with that. You actually
I love you.
He's speechless.
Oh my God, Bob, your website photo is so handsome. But what about now? What about now? What about now? Thank you. I appreciate that. But
sorry.
In the end, tell me if I'm wrong, guys, because you guys follow this case much like as a TV commentator. I'm following, but it's not my life, right? But at the end of the day, in order for Karen to be extricated from this, in my mind, the jury is going to have to believe a big thing here, that this was a huge conspiracy, that this was a setup, that this was done by somebody else, and that all of this nefariousness and collusion all occurred in order to cover up somebody else doing it, as opposed to maybe it was just an accident and she didn't even know that she was even involved in the accident until later. And I think it's a lot. I think that the defense is going to have a lot to overcome, that this whole thing was orchestrated and somebody else did it. I don't know.
That definitely was in the first trial. That was an issue. We know the jury after the fact talked about it. In fact, they suggested the defense didn't prove a conspiracy. Well, they don't have to prove crap. But in this case, they dialed that down And as we now know from the back and forth with the jury and their questions on counts 1 and 3, they've already basically acquitted her. And now they're focusing on number 2, which still would require a collision of some sort unless they go with just straight OUI. So my question then, Bob, is why can't the jury just hold the prosecution to its burden and ignore all that other crap?
Because I think it's very hard when there's a dead person, you know, for them to do that. I mean, ultimately, what they're saying in those verdicts so far is that they don't buy part of obviously the state's argument here. How much of I'm curious what you think. How much of what they're doing right now is the effect of improper investigation, possible collusion, sloppiness, or outright they just don't believe the facts were sufficient or proved beyond a reasonable doubt? I don't know.
Or they don't know what happened, which is my position. I don't know what happened. I have no idea what really happened that night. And if that's the case, that's reasonable doubt. I couldn't convict anybody of anything.
So what do you guys think? I mean, you're following better than I am. What do you think they're hung up with on this one count?
I think there's a split. I think there's a split that they wanted to come to a compromise. A bunch of jurors don't want to find her guilty of 1 through 4 on the verdict sheet. That's why they asked that first question, or the third question, I should say, about if we find her guilty on number 5, would that mean that then she has to be guilty on the above? And so they're trying to compromise, but they want to know what the effect is. And some of them aren't going to compromise on finding her guilty of the offense. And some of them want her found guilty of something, because even though the prosecution may not have proven it, they think that she did something. I think that's what they're hung up on.
Have they asked? Have they said they're hung at all, or?
Well, here's the questions that they sent out. Let me see if I can find the exact wording when Michael talks to you as we put them on.
Yeah, I mean, there were 4 questions, and the order of which is also another controversy. But one of the questions was, can we separate out the different counts? You know, if we've come to a decision on 1 and 3, if we've acquitted on those, can we talk about, you know, the second one? And the court wouldn't respond to that. So that's hypothetical. I can't give you any direction. That was one question. They also asked about the blood alcohol level and what time they should be focusing on, 12:45 or 5 o'clock, which was a bizarre question, but it's obviously tells you where they're focused. Then they asked about the videos that were played. Are those in evidence? Videos of Karen Reed when she talks about driving and having had alcohol. Those are in evidence. They were told those are in evidence. Give them the weight you think they deserve. Not with if any added, just give them the weight you think they deserve. And then the final question was specifically related to the second count and the OUI lesser charge. Specifically, they said it as, for example, what about the OUI charge? They were asking if they find her guilty or not guilty of that one charge, how does it affect the rest of those lesser included? Because the form is such a nightmare mess. It doesn't tell them how to move from point A to point B to point C. So to Linda's point, it sounds to me like you've got people who think she should be convicted of something. OUI is on there. Let's go with that. And those who are saying we're not going to convict her of anything.
And they called her Karen, by the way, in one of the questions, Bob. They didn't call her the defendant or Miss Reed. They called her Karen.
Wow.
Okay?
Yeah,
that's pretty good for the defense. Yeah.
Man, yeah, it's fascinating. You know, that's another thing too. We, as armchair quarterbacks, we're not really in that courtroom. And you know, when you've been there for that long and you've tried a case for that long, there is a level of intimacy. They see the defendant every day. They see you every day. And even as much as a judge will try to say, don't interact with them or whatever, there's a rapport that's being built. And even like look at Diddy, right? I mean, what's going on with the
we don't know what's happening. There was like jury drama with that today again.
There's jury drama with that, and look, I think it's like when they're saying, like Linda, I don't know how you feel about this, but like when a judge is instructing a defendant on how to look in the courtroom, I get nervous by that, because there have been many times I've seen situations where I've prosecuted cases where people were like, well, we thought that he was villainous because he never smiled, or he didn't react when he saw the autopsy photos, or what have you. And so it's very difficult when you're trying to tell a client, like when they say to me, for example, like, how should I appear? And I'm like, do your best to be yourself. You don't want to tell them obviously to have direct contact with a juror, but people have emotions and people have reactions. And sometimes our nonverbal communication is more powerful than the words we're saying. So when does a judge get in to telling a defendant on how to look in front of the jury? It's a very dicey area to me.
Wow, that's what happened. The judge told Diddy how to look. Is that
Well, I'm not. They're just like saying that they didn't like that. Look, apparently there's some looks that are going on. Some people are suggesting. Again, by the way, we can go to a whole different space here. I don't know why it's 2025 and we don't have a courtroom where we can view these things on our own without. I mean, they're talking about public perception. So I have to rely on somebody who's a reporter reporting to me, and then I have to interpret. I can't see it. So I don't know. That's why I hate commenting on those cases. I absolutely hate it because I have to rely on somebody else.
Yeah, you're not there, and that just gets down to the wimpy federal judges. They've got a big ban on the cameras because they're afraid to expose what they do. I don't like it. It should change. There should be access for everybody. Why wouldn't there be? What do you hide?
Guys, I think it's about time that one of your viewers writes another compliment. It's been.
We see. Are there some coming? Or,
there hasn't been one in about 3 or 4 minutes. And
I know it's embarrassing.
Bobby,
welcome to my life, Bob. I go weeks on end. I get nothing. So.
No, they compliment you on all your do-it-yourself projects that you post. What are you talking about?
Yeah, that's right. They say, hey, as an attorney, go do your do-it-yourself stuff.
Somebody recently said to me, like, oh my God, I can't believe you left the law to be a volunteer EMT. I'm like, no, I did not leave the law. Now, how do you do both?
We're exhausted. We're exhausted. We haven't slept in 8 weeks.
Are you doing 2 days now or 1 day, Bob?
I'm back. The rescue squad?
Yeah, the EMT stuff. Yeah.
I'm back to 1 day, 3 days, 3 times a week, and then 2 days on the 4th week.
Wow.
But they're long shifts. They're 12.
Yeah, they're 12 hours, aren't they? Yeah.
Yeah, I had to cut back on the. I was doing a night crew shift, and that's from 7 p.m. to 6 p.m. to 6 a.m. And I couldn't deal with it. I was on Tuesdays. I'd be doing all these media appearances, and I was exhausted.
Yeah, that's brutal because you're changing your clock for that one shift, right?
Yeah,
so you got to adjust going in, you got to adjust coming out. Yeah,
and we cover Linda. You'd be surprised. We also do mutual aid in Newark, and East Orange and Irvington. So these are very active communities.
Right.
So you don't get if you get to get back to the station house and close your eyes for like 15 minutes, the bell's ringing again, and you're going.
I can imagine that you're going out. Yeah, it's kind of like Dedham here. It's been actually quiet for the last half an hour.
It has. There's only maybe they're all back at the station house watching the coverage. This place, Bob, they have no limitation on rescue trucks, paramedic vehicles. For what appear to be very minor incidents. I've seen them go, and it's a parade. And most people watching the trial know that it's 3 or 4 times a day, maybe more, where it's so loud right in front of the courthouse. That's where they go right down High Street here. They have to stop. Everybody in the court, they just get used to it. And they just stop. They stop talking. Just wait.
So guys,
all right, let's go on.
Tell some more stories. I tried a death penalty case as a prosecutor, a murder case. And they were trying to, Linda, knock down the Hudson County jail at the time.
I remember that.
And this jail was built in like 1840 something.
It was really early.
They could not blow the jail up. They did everything. They had guys with dynamite. They had guys with nitroglycerin. And I'm in the middle of this trial, and we were constantly having to take a break because they're trying to blow the jail up. So finally we're told on a Friday, everybody relax. Monday, they got the solution. It's all going to be taken care of. Now, literally, the jail is like out the window. I can literally see the jail. So I got the jury here, and the window's over there, and I'm looking out. And the next thing I know, a crane rolls up, and they got that ball on it with the chain. The ball.
Oh, the wrecking ball.
And I'm like,
yeah.
Are you kidding me? And for 5 months, I asked questions in the cadence of when the ball was going to hit the building. So I'd be like, so let me get this straight. When the fire started, boom, you then ran to such a this went on for 5. I'm not making it up.
I'll bet you could use that in your closing. You could use it to punctuate some very important points. Oh, man, that's old school. It makes sense that they use an old wrecking ball to tear down a very old building. That makes perfect sense.
You had to be there. You had to be there. You had to be at all the Hudson County facilities when we were trying cases, right? At that time, it was unbelievable, right? And at least now they have
The first day I worked there as a young assistant prosecutor, a guy in an orange jumpsuit, which HCJ, Hudson County Jail, ran out of the jail and ran across the street. And I was a young 26 year. I had a flat belly, a full head of hair. I was all gung ho and excited. And I'm like, I go to one of the sheriff's offices. I'm like, a guy, he's escaping from the jail. He's like, don't worry about it. I'm like, no, he literally ran across. And he goes, kid, that's Smitty. He's going to get us coffee. He'll be right back.
Oh my gosh.
And then you had, remember we used to park at the parking lot that really wasn't a parking lot. It was owned by one of the state senators, right? For years, he parked, it was cash. I'm thinking,
Frank
Jesus.
Areno.
Yeah, Frank Areno. That's right. I was going to mention the owner. That's where, don't worry, but I can park there. All I got to do is tip the guy a little extra. It's fine. People say, well, you're going to be like, don't worry about it.
If you were, see, you had to be Hudson County. If you were a Hudson County mentality and you wanted to park for free or whatever in that place, it was old school stuff. Like I would bring the guy a little salami sandwich and say, hey, what's up,
exactly. Right.
Come on, Bobby, come on, I got a spot for you.
That's what I'm saying. People would say, I said, don't worry about it. I got a spot any day I want to go. Don't worry about it. When I clerked in the appellate division for Judge Lynch, he had been the assignment judge of Hudson County at the time before he moved to the chief judge in the appellate division. So that's how I ended up getting my job, in the sense of he and I talked politics all the time. And so here's all these people coming in from Harvard and Yale and all this stuff. And I end up from Rutgers being the clerk to the assignment judge of the appellate division, because he could talk politics with me and he couldn't talk politics from the people in Ivy League schools. Yeah.
Hudson was a very, and by the way, guys, see, this is another interesting thing too, right? It's fascinating that like Hudson has an ethos, and then Essex County has an ethos. And then when I became the head prosecutor in Morris County, that ethos was like 180 degrees different than the Hudson County one. And it really, like we used to say, you had a very blue collar, very old school jury pool in Hudson County. And as a prosecutor, you had to work for that conviction. They held prosecutors to their burden. They weren't gung-ho law and order. They weren't anti-law and order, but when you go to Morris County, is a very affluent, one of the top 5 affluent communities in the United States. I mean, it's almost impossible for them not to believe a police officer. And so it was so much easier to get a conviction. And ironically, your audience may find this odd. When I led that agency, the Morris County prosecutor's office, I actually was concerned and made sure that my assistant prosecutors spent extra special attention to the defenses that were being presented to us, because I knew that we would not lose a case at trial. It was the strangest thing. But in Hudson, when you got convictions, they were earned. Does that make sense, Linda?
Yeah, it makes sense. You had gone, and I had the shooting in the back where my black client was had a white woman in the car, and he was shot in the back and supposedly leaving. And I had to deal with we won't even mention names, your successor, and they would not show us. We ended up settling the case for a lot of money, right? But they would not show the family that's videotape of the shooting until they put it publicly. It was outrageous, Bob. You would never do something like that. You let the family see it first.
It's funny you should say this. I'm literally dealing with a situation right now where I've almost found it unbelievable, but the clients have retained us, same county, and they're saying that a videotape of police officers beating a client who is now a civil rights 1983 action, and there's also a criminal component to it. Nobody has seen the video. And I'm like, how can that possibly be? The video is obviously relevant, but I don't know. Things are weird.
I'm sorry. I was checking on some notes there while you guys were reliving The Sopranos. We're
from Jersey, man. That's how we're good
Some
lawyers.
people were saying something might be happening, something going on. I'm looking for some detail. I see nothing suggesting anything is happening. But I would imagine at 40 minutes left in the day, the court day.
She's going to send a note to them at 4:00 and ask them. So send a note.
Hey, let me ask you guys a question. You may come down to like this thing where, this is what we do as lawyers, right? We're sitting there trying to use a divining rod, understanding what they're thinking about, what are they doing, what happens on the hung? What happens on the hung here? What do you
mean?
guys
Is
think?
there another time, another trial?
Yeah.
In the real
Well-
world or in bizarro world that we live in here in Dedham. In bizarro world, yeah, they will try her again.
Yeah, if they're now, the question is though, they have to report on the acquittal, and apparently this jury doesn't know they can report on the acquittals. That's the same position we were in the first case. And then of course on the verdict slip, if they find a verdict on like number 5, then they can't retry her on the other ones, because the way the judge now finally phrased it is like you move down the sheet, and if you find her not guilty here, then you move to the next. You find her not guilty here, you move to the next. You're not guilty here, you move to the next, so you get the fine. So there's no way if they get the 5 and they find her only guilty of 5 that they can retry her on anything regarding count 2. But they don't know that. I think that there's no way we get a verdict today, because we're still going to have, they're going to, at some point, someone's going to we could get a verdict today, but if we don't, somebody's going to say hung, and she's going to have to give the Allen charge. But I don't think this goes past tomorrow. I mean, this doesn't go past tomorrow. But the question is, does the jury know they can report out the 2 acquittals that they seem to have indicated that they have?
Yeah, I'm listening to you guys. I'm trying to like piece things together. How many cases, guys, have been reversed because of improper jury instructions?
Yep.
A confusing jury verdict sheet that didn't properly advise the jurors how to go about deliberations. And like to your point, Linda, that's a major issue to me, that if the jury doesn't know they can report out verdicts, then there's a huge appellate issue there. I think. At least
I'm sure of it. I'm sure of it. And the fact that she has attempted to correct it, midstream, to me reinforces that it was wrong to start. And after the fact, she tried to fix it, but it didn't fix. So, to your point, the number one reason cases are reversed, jury instructions. So,
but we could end up in the same position, Bob, that we're in the first trial. That they come out, they say she's hung. She sends it back with an Allen charge. They come out, they say they hung, and we never get reported out the not guilty verdicts. That's going to be the same exact position that we were in the first trial. It's ridiculous.
Yeah, but then the defense should be standing up at that point in time and say, now, I mean, could there be a possibility there are guilty verdicts?
I don't think the way they worded it. The way they worded the question is, if we have a verdict of acquittal on counts 1 and 3. Okay, or a verdict on something that this is I'm paraphrasing, of counts 1 and 3. Can we? What do we do with the hung or something like that? It was something, I don't have the exact wording, but they clearly seemed to telegraph that they had a not guilty on 1 and 3. And she said to them, that's a hypothetical. I can't answer that question because it's a hypothetical.
Now, wait a minute, Linda, me and you as defense lawyers now, we would be jumping up in court saying, wait a second, Judge.
They did.
They did.
Okay. Alan Jackson said she was going to use the word consequences, suggesting that it was somehow related to the penalty, but it's not. It's a procedural question. So Alan Jackson got her to back off of using that word, but just said, tell them, I'm going to tell them it's a hypothetical situation. I can't comment.
Theoretical, right? Yeah, theoretical, and I can't. She wouldn't use the theoretical. She just said I can't comment on that.
But useless.
But useless. I mean, in the ASAP Rocky case, you heard, is it Judge Walsh that we had up in there?
Judge Arnold.
Judge Arnold, I'm sorry, Judge Arnold. In the jury instructions in California, they tell the jury, look, if you're hung on something, but you have verdicts on other things, you report out to me about those verdicts. That's standard.
Yep. I think they just did it in Weinstein. Same thing. They just did it in Weinstein.
Yeah, one of your commentators, Meg, is saying in Masters a rule judges can't answer hypotheticals, but that's the point. I don't disagree with that. The point is the judge should ask, or should not ask, should state, if you have a verdict. I'm not going to answer a hypothetical, but if you do, then you need to report that out.
Right. Yep. That's
we've said that from the beginning. We said that was the problem with the first trial. I was always hopeful that they were going to fix it in the second trial, that she would have an instruction that would specifically address that. She didn't. In fact, she denied the request by the defense for a much clearer second count. So she wouldn't do any of those things to help the process. And now after the fact, they tweaked the verdict slip to make it somehow a little easier to figure out. And it is better. It does give the jury some options where it will say, if you find not guilty, then this. If you find guilty, then this. But it's still wrong from the start.
Yeah, and this is what, like, befuddles me as a trial lawyer. I mean no disrespect. It's a complicated case. I really don't. I hate when I'm critical like this, but really, even though the judge wears the robes, and even though the judge is making rule, like the judge is the keeper of the gate of the evidence, but the most essential role that the judge has, the most essential role, is to instruct them on the law and to give a jury charge that is accurate and a jury verdict sheet that is accurate. It's like, how is it possible after 2 trials and all this time this could happen? I don't get it.
Good question. I'm sorry, but that's a hypothetical. I can't really answer that question.
Right. All she needs to do is say, if you have a verdict, you report it out to me. I can answer a hypothetical question, but I'm going to instruct you, if you have a verdict, you have to report it out to me. That's all.
Yeah.
Yep. There's the remedies are very simple. They've always been very simple. She just won't do it.
Yeah, she just won't do it. And here we are. And does that mean, so I'm sure the defense is worried, Bob, if you send them back in there and they haven't answered their question, and the defense believes that they have these 2 not guilties, are you endangering those? Because then you're going to get compromised.
Yeah, I think it's a bad, I think that's going to be an argument the defense is going to make if there's a conviction, that it wasn't handled properly, and the court may have essentially directed a verdict against their client in some way, shape, or form. I don't know. It's a place the judge shouldn't be. I'll just put it that way.
Yeah, it's definitely a problem of her own making. There's no doubt about it. And she got off the hook on appeal from the first trial because the retrial was already in the works. And so the appellate court very simply could just say, well, the remedy is you got a new trial.
Yeah.
And so she's able to say, see, I'm vindicated, when she was really, it was never even addressed.
Yeah, because she got all the court basically said, oh, yeah, it was okay because the remedy would have been a new trial. And here you're getting a new trial anyhow. Okay, so that's where we are. I mean, you know.
Oh, hold it. Breaking news. Bob, so wonderful to see you again. I haven't seen you since Law and Crime Trials. You are the best storyteller. There we go. Right now, we have on the show right now, what, 3/5 of the hosts from Law and Crime? So
That's right. Yeah. That's right.
No, Penny, thanks so much. I mean, yeah, we were like OGs at Law and Crime. I loved doing that.
Yeah, so did
I love being a host. It was a great experience. I felt very fortunate that I came on as a guest, and they asked us to do it. And Linda, do you remember when we would be in that little room when it first started? And the guys,
the air conditioner
out there was no window, no air conditioning. I had this fan, which, by the way,
right, which I have. I bought a second one because of you.
Yeah. It's a little because Linda, I would like pass it on.
And we had to remember to turn it off when you were going to go on. You had to turn it off, otherwise it made too much noise.
Bob would share it with me, the little tiny fan, because I was dying. And you're wearing a suit jacket, right? And dying. And I don't know how the people in the control room were doing it. It was ridiculous.
It was literally brutal. And there was no room. Like, you had to like squeeze your way when you were leaving to get out. It was craziness.
Yeah. And they did great things, no doubt about it. They grew and, took over that whole 6th floor. And had another, the whole production wing did a number of shows, including I Survived Crime, and so then they just decided, nah, we're not going to do this anymore. So that's TV.
COVID happened, and actually in the room I'm in right now that you see, I have a chair to my left here. It had a cushion that was like that thick on it and they put a studio in my house, and so by the time 2.5 years later. The cushion was down. I was like, why is my ass hurt every time I get the? And I'm like, oh my God, I lost all my cushions gone. and then they called us back and we had to go in the studio. And I remember being like angry. You know why? Because I did nothing but wear shorts and sweats for 2.5 years and a suit jacket and a tie. And I couldn't put my suit pants on. The first time I couldn't fit in my suit pants. I couldn't believe I gained like 30 pounds.
Yeah.
And then we had to go in. And do you remember when we went in,
like
there was no one in the studio.
Right. There was no one, just us. And we were in this little tiny room with our back up to the back.
All
right?
the tech people were still at home. They were still at home.
Yeah. So your audience may not realize this. Like you literally went into a room by yourself.
By yourself, right?
And everyone else was gone. And what trial did we have to go back on? Do you remember?
Oh, that's a very good question.
George Floyd.
Was it
No.
George
Went back
Floyd?
on the
No.
George Floyd. Yep.
No.
What?
That's the one I
It was
remember.
the summer of 2020. What was that
No,
trial?
2022. We had to go back.
Oh, I went back before you guys. I was going ahead and going on in. I didn't stay home.
I went back on the George Floyd, I believe. It was
What
the
did
first
you? What do you
trial.
remember, Bob?
I was forced back on Johnny Depp.
Oh, Johnny
No,
Depp.
I was right before you then. I went
Yeah.
back on George Floyd. Yeah.
Yeah, I was back before that. I liked going in. It wasn't a big deal for me. Hop on the train. I liked being in there by myself or otherwise. It was just I felt more like this is real. I don't know. It just as long as they would let me do it, and it, they got over the whole isolation thing after a period of time. But we had to do testing.
Look at this.
Like every day we had to do testing.
My lovely wife.
Yeah, we had to do
Brings
testing. She brings you. Oh, isn't that lovely? My husband came in. He's here today.
Is that
He actually came in.
herbal tea? What do you got there?
He actually asked
Espresso,
him-
baby.
He asked if my
man.
husband wanted to know if I wanted an avocado. He
Yeah.
came in and said, "Have you eaten anything? Are you on an avocado?"
Bob,
and
I
I was
think
like, "Hi,
that's what-
honey. Hi, honey. Bye, honey." I was like, "Bob,
Yeah, passing ships
bye.
passing.
I'm here."
Bob, what you need is espresso. That's what you need.
I know,
Just-
right?
You need to get a little amped up.
Penny, thank you. Penny's from heaven. Penny, you're the best. You're the best. Thank you so much. Thank you.
So we were in this little, and I remember I had my back. It was my back to the wall in the room that they were using. There wasn't any of the studios they were using, and then and like a little teeny like a mini desk. I looked like the guy in the courtroom there. And then I said to somebody, can I have something to put my feet on? Because I was there for the jury for like 5 hours because they weren't changing, right? You go, you go 5, and I had a little box, right? And I was like, oh, I can't, this is not going to work. I can't do this. I can't sit like this.
They were, I didn't know something until later. So when, first of all, I got to give law and crime credit. When COVID hit, I was doing regular.
Yeah, there's apparently a lot of security. I'm going to bail and I will check in with you soon. Hey, Bob, thank you for popping on, man. I appreciate it.
Something's happening, Bob.
You got it, Michael.
Yeah. So let's look and see what we see. Apparently, there's a bunch of security around the courtroom that can only usually mean one thing. The jury has announced they've had a verdict. Let me see what Aidan Carney says, and I will tell you. As we're having a great old time, we're like, oh, okay.
I think that we should ask your audience. We should just do a show with our war stories. From
yeah,
TV.
we should. That's a great idea, and we can even pre-tape it and all. So let's see. I don't see anything on Aidan's page with it. Okay. Let's go to Machado. So some of the people, some of these people have, are like us, are reporting what are being told, but I want to go into the people that are in the courtroom and see who've got a pass and all, who see what's happening here. And of course, as you and I know, Bob, sometimes the court does things without telling anybody, right? Court does thing. Jessica Machado has nothing. Let's go into Christina Rex. Let's see if she has anything being reported on what's happening. Christina Rex, Boston. Good morning. Let's see. I don't see anything there about, but apparently there is something happening with regard to. I'm seeing it on our feed, all of you, and then we can go into Sue at Boston. But the court may know something and is already asked for something like security and not have even told the lawyers. We know that, you and I know that as being in courtrooms. I don't see anything happening, but apparently there is some activity around the courthouse. So I don't see anything. Dizzy said there's no news from inside the courtroom. All right, here's a Vinny Politan saying tons of security being placed all over and around the courthouse. Okay, too much police action. But it could be that, is that what happens every day when the teams leave and all? Let's see. So I don't know. We don't see it. We don't see anybody inside the courtroom actually reporting it out here, Bob. So I will just let you know that we don't see that anything inside the courtroom reporting it out. But that does not mean it's not happening, because we have found in this courtroom that it's very secretive, if you get my drift. You don't really know what's going on. Just like we didn't even know there was a fourth question here that had been delivered before the questions 1, 2, and 3 had been answered. And the judge, when she read the questions initially, she didn't read the whole question. It had to be reported out by somebody else that they heard that the jury actually addressed Karen as Karen in the question. And we learned that after the fact when we finally heard her discussing it to the jury. Okay. Oasis Catazo was on this. Let's see. Yeah, so everybody's been checking. So we don't know. So maybe something will happen. Is something happening? Or maybe that's just getting ready for the jury and everyone to leave at 4 o'clock. Okay. But if you're the jury, do you want to come back tomorrow, Bob, after you've been there since Friday?
I mean, it's impossible to say. I mean, at the end of the day, you know as well as I do, we can't predict this. This could be that they finally came to a verdict, or they're going to come back tomorrow. It's a big case, Linda.
It's a big case, yeah.
And I think that these questions, at least as you're expressing them to me, there's some level of confusion that may be happening, or some resistance in that jury room. So, I mean, to me, it wouldn't shock me if they came back. Yeah, I mean, I would expect more that there'd be a note coming out saying we're deadlocked, or we can't come to a conclusion, or what have you. So I don't know.
I don't know either. I have no idea, because it sounded to me like there was confusion also created, quite frankly, by the verdict sheet that then was trying to be remedied. But it sounded to me like there was absolute confusion, and yet they sound like a smart jury, but they didn't get really any help. Unless they went on the redone verdict sheet, with then after she sent it in this afternoon after lunch, had like, well, on charge 2, you start at the top, and then it had like a roadmap. If you find guilty or not guilty, if you find not guilty, you go to number 3, and if you go to number 3, then you go to number 4 if you find not guilty, and you finish on number 5. And if on number 5, if you find not guilty, you report it out under number 1. Okay, that was literally the charge. If you find got guilty, report it out on the number 1. What is the jury to think about that? What do you mean? You go back to the original offense and you say not guilty? They're not lawyers.
Yeah, it's how did she explain? I mean, usually they go over the jury verdict sheet in the charge. Did that happen? Do you know?
Well, today she did. Today she went over it, but the other day she kind of just like sent it in. And when the lawyers were objecting, when the defense was objecting, she said, "Well, you read the verdict sheet with the charges, and that's how we do it in Massachusetts. And I've been upheld on that in this case. So the verdict sheet is very clear if you read it with the charges." That's literally what she said. But clearly, it's not. I mean, it wasn't even clear to lawyers, nonetheless, obviously the jury. So I don't know. I just think there's no way to leave a jury of lay people who have devoted all the time. And you have you have a serious case here. This is a murder trial.
Linda, let me ask you this question. So we all know there's a possibility for reversal if there's a conviction.
Right.
And I know that others here will critique me for saying what I'm about to say, but I do believe that many times appellate courts look at the overall case and their comfortability with the verdict, if it's a guilty verdict. And then there's always ways to justify it, like you just said. Well, you take the jury verdict sheet in as well as the jury instructions, or it was harmless error, or there was an overwhelming amount of evidence, even though what was introduced was not allowed. But if they want to, they can go to the summation of the prosecutor and say it was over the top, or they could say the jury verdict sheet was confusing. In other words, the appellate division could do pretty much what it wants, in my mind, and justify how they're going to go about it. If they have a rational basis at all. Would you?
I agree with you, by the way, on that. And you see that especially in high-profile cases. They will, things that would be reversed, even on low-profile cases, will not get reversed in high-profile cases because they're just going to look at the whole package.
Right. Yeah, but maybe they'll be in jail or not during the appeal. That's somebody's talking about that. But my question is, have you ever been involved? I have not. In a situation in which, after all this, everybody sits down and says, look, let's come to a reasonable resolution of this matter. I will offer you as a prosecutor no jail time for a plea to the case, put you on probation. Or what. They already know they're losing two counts, or they're reasonably certain that they are. Would you, as a defense attorney, if I came to you as a prosecutor and offered that and said, let's go away, no appeals, that's it, she doesn't do any jail time, or you can face the possibility of a conviction here. Is that a possibility?
I don't think the prosecution, this is too much of a big case and they have put too much into it. And it's a politicized case. I don't think that's a possibility here. So Michael Bryant made it back to the courthouse. He says everything is still at the courthouse, but Twitter or X, as used to call, people are saying there's a verdict. So, if everything is still outside the courthouse, and apparently all the parties have arrived. So that's actually a little bit earlier, because the judge would say she would send a note in at 4. So the fact that all the parties have arrived, maybe that there's a verdict here, Bob. I think there's just too much in this case that they're not going to do that. They're not going to come to you here. I just think they're not. But as a prosecutor, if there's a hung jury, but there's no hung jury here, they're not not saying hung. Obviously, they've got to. If they come out now, they've got a verdict.
And your guys are going. I am not, like I said, I have never done it. I have never seen it. But I have seen cases plea in the middle of a trial.
Right, I've seen that. Right.
So I'm just, is everybody that entrenched? And as if you were Karen Reed's lawyer, or if you were Karen Reed, would you want that safety and comfortability that you're not going to go to jail and just move on with it?
I think we're past that point. Michael Bryant reports that it's unclear right now whether there's a verdict. That there may be. So I guess we're going to have to wait. Aiden Carney has not reported there's a verdict. Michael Bryant's reporting that it's unclear, but it won't happen. It's been too politicized, too hard fought. They've spent a lot of money, the Commonwealth, on this case. This is a police officer also. I think the time for any type of resolution would have been after the first trial, right, where you had the hung jury and a jury possibly saying acquittal on the 2 counts, and that would have been the time for resolution. And I don't think they announced, the state announced, the Commonwealth announced within like 6 hours they were going to retry her.
Let me reverse the question. You, as a great defense lawyer, would you at least try to pitch it?
It depends. It depends on my client, really. It depends on my client. I think once the prosecution says they're going to retry it, you can't pitch it because it shows weakness. But you know how those side of conferences go. The DA calls you and says, "I'm not offering this," right? That's what happened. I'm not offering this. But if I were to get you this offer, would you take it? Do you think you'd bring it to your, and you say, "Look, I'd bring it to my client," right? You have to, right? No matter what.
I've seen judges do that. I've seen judges bring the parties in and say, you got this issue, you got this problem. It looks like, prosecutor, you're losing 2 counts on an NG. It looks like you could be facing a conviction on this. Why don't you get together and come to a resolution? I've seen judges do that.
Yeah, I agree with you. I've seen that too. I've seen that too. We and I both been practicing a long time. We have a lot of clients, and people have seen that. I mean, it's not unheard of, but I think it would be unheard of in this case. Okay, Will the Galera, who's one of the big sources in this case, who's very close to the Karen Reed contingent. He says that no verdict, although they were told to return to the court by 3:45. So that's Will the Galera is saying that. So I don't know if that's true or not. But she may want to send the jury home, send the note in and send them home right away. And then decide what to do. I imagine this jury is not going to be happy they're coming back. Jurors are not happy that they're coming back for day, 1, 2, 3, 4, which is exactly where they were, though, on the first case. The jury apparently has, now that was a while ago, the jury had a question. It's not a question. Sources are telling Will the Galera that it's not a verdict, that they're just told to report back as soon as we see some activity in that courtroom. Okay, as soon as we see some activity in that courtroom, we're going to go there. We have the fan up. The reason why we have the fan up, I call it the fan of injustice, because, Bob, that's the Sacco and Vanzetti courtroom. I didn't like that.
Really?
Yes, that's the court. It's so small. That's the courtroom that Sacco and Vanzetti were tried in. That, again, you had an issue of whether or not somebody would be wrongfully convicted, whether somebody was properly charged. I've come to the conclusion, I forget which one it was. I'd have to go back and look at all my analysis and my notes on this, that one of them was probably not guilty and one probably was guilty. But I know those who believe intently that Sacco and Vanzetti both were not guilty. That doesn't mean they got a fair trial. It's maybe because I'm Italian. I think that they were, initially, because they were Italian, they were like, of course the Italians killed somebody. It's like in New Orleans. Yeah,
yeah.
let's face it. You remember our heritage. Of course, it was like in New Orleans when they thought all the Italians had killed the chief of police, right?
Well, in New Orleans, I was national president of the Sons of Italy, Sons and Daughters of Italy in America, and only recently did they made a proclamation apologizing to the Italian community because of the injustice of the killing of how many people was it? Like nine?
That was a lot. Yeah, at least 9. And they were found not guilty. They were pushed back in jail, and then they were taken out by the mob and hung. But people have to understand, they were
Lynched,
found
yeah.
not guilty. They were lynched. Okay.
And a lot of people, oh boy, you want to start some controversy, Linda? You ready to go?
Ready to go.
Okay. Well, because of that was the reason why, and I believe it was President Benjamin Harris, I could be wrong, instituted Columbus Day as a holiday for the Italian Americans, was kind of like a olive branch because of that those executions.
I didn't know that. That I didn't know. By the way, the witness Mary Splain in the Sacco trial also claimed that her memory got better years later, kind of like the witnesses now. Now, we are told that people are entering the courtroom and are in the courtroom. The fan has not come down into that courtroom yet. We will see it with Bob, and I will see it coming down into that courtroom when it happens. There are a lot of people outside of the courthouse right now, but they're back in the courtroom. The reporters who won the randomizer are back in that courtroom right now, just so you know. They are back in that courtroom.
The divining rod, quoting the great Tony Soprano, indicates that Italians are just Jews with better food.
You've got I always say that we're one of the same, right? In the sense of our relationships with our family.
Yeah, absolutely.
So everybody is in the courtroom but the judge and the jury right now, Bob. So we should be seeing, as soon as the judge comes in, we should be seeing, that fan. And then it will go up, will go up because she's going to bring the jury back in and give them that admonition that they can't talk to people. Unlike some of our cases we've been in, I've told everybody that sometimes the judge will just send them home, and other times the judge will bring them in at the end of the day and bring them in before they start deliberation. And sometimes they won't, with the consent always of the defense. Sometimes the judge will say that, and you say, "Of course I have consent." Of course you do. I don't want to be back. But if you're the defense attorney, you want to see what the jury looks like, right?
Yeah, everybody does. Missy Mayhem's back. She says me and you were back to the old long crime days. Hi, Missy.
Wow. Yeah, we're back. We're back to this is the young crime days, Bob and Linda. Yeah, because Bob and I are on, and then Michael Bryant. As I said, you're right. We had 3 of the 5 hosts, and I think Arthur 3 were the 3 lawyers, right? We were the 3 lawyers that were hosting. All right, so let's see what we have here. Yeah, Missy is like waving to you behind the scenes, Bob. She can't come on. I'm going to come on, but she's waving to you behind the scenes. So we're waiting right now as to what's happening. Michael Bryant has not, he's not in the courtroom. He can only report as to what outside the courthouse. Let's see. Let's see. We have no news. We have no other news. And if Will DeGlara turns out to be wrong and it turns out it is a verdict, that would be very interesting at the end of the day, right? This is where we are, Bob. But this is where we are. We're in the state of, we're like the jury. We can't get our questions answered. All right.
It's this is what happens when we're now armchair quarterbacking rather than literally being in the courtroom itself, dealing with and I got to say there. I don't know if you have the
court
ability.
Officers getting the jury, by the way.
Okay.
Oh, here they go. All right, here they go. I'm hearing noise. We're going to go into the courtroom. Here we are. We have a verdict? Is that what someone's saying? Julia Nielsen's reporting that there's a verdict.
Put us back in session in 80.
All right, jurors, I know you want to go home. So it's been a long day
not a
for
verdict.
everybody. I have to give you those same cautions.
Not a verdict. Not a verdict. Let's tweet that out.
Anyone, do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise for the court, please. There is following.
Bob, she usually comes back out if the jury leaves, as you know, and then we go up and she asks the defense or anything if they have any issues, or the prosecution. So she probably will come back once the jury leaves. There. Okay, here we go. She just handed something to her court reporter, as you saw. If I'm the defense, I'm pretty upset right now because
Jury's exited the courtroom.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you. Court is adjourned.
okay. Now, Michael Bryant will be outside the courthouse, whether or not he'll be streaming or just get the commentary. But it sounds like this is ridiculous. I mean, I don't know how you feel about this, but you know, this jury had, you know, has been in there now since after lunch. 1:30 it was they went back. They worked hard again for 2.5 hours. They've been silent, but you know, she didn't really do anything to help them. They wanted the answers to their questions and they didn't get it. Bob, talk to me, please.
Well, I mean, it depends on what you mean by ridiculous. I mean, it's a lengthy case. There is a lot of evidence to review.
Yeah. Oops, I'm sorry, Bob. Go ahead. Can we lower the sound of what's happening outside, and then Bob can talk?
I think court is over and they're coming up.
Okay.
And you know, I've been on both sides of the equation, and it's frustrating, and you want your verdict to come in and to be over. You just never know what's going on there. I don't even want to speculate as to whether it's one person that could be a problem or they're hung up on something. But it to me, I mean, I hate to use experiential knowledge as a ruler, but I've had juries that have been out for 4 or 5 days, and they're wrestling, and they come back, and then they can't come to a verdict, and then there's an Allen charge, and then they come back again, and so you got to give them a little breathing room here. I know everybody wants a quick resolution, and everybody's very passionate about this on one side or the other, but they have a tremendous amount of evidence to go through. I don't think the judge helped. I don't think that and I think this could be an issue for the defense, you know, down the road. But the jury wants to get it right, and they may not have necessarily gotten a satisfactory substantive response to the questions they ask, which makes their job more difficult. So we just have to be patient and give them their time to do their due diligence.
I will tell you about that when we tried Hernandez, and that was clearly a lot of reasonable doubt, and we were trying actual innocence and reasonable doubt, that the jury did take 4 days to get the verdict. And they had one question on the jury charges, and when we finally got to talk to them afterwards, after they had rendered the verdict of not guilty on the double homicide, after Aaron had been convicted of the single homicide, when they finally got to talk to them, they spent the first day just going through they spent a day going through just the jury charges so they could all read them individually. What were we supposed to do? Just the jury charges. They spent a day. And then another day they all wanted to see the evidence that they had been looked at. And they didn't really deliberate. Here we know that this jury has deliberated, though, at least all day yesterday and some part of the day, because they didn't have any questions.
I just don't think that this is a long period of time to deliberate a case with as much evidence and contradictory and all this expert testimony. I just don't think it is. One thing I found odd, though, that I heard, and I may be wrong, and I don't know if you've ever experienced it, is judges are usually very remiss or will not invade the province of the jury in the manner in which they go about their deliberations. And I heard that the judge said, don't go quickly, take your time. And I found that to be really...
Worse.
Huh?
Let me give you another... Hold that thought. When they went out to deliberate, she told them not to take a straw vote. It would not be the way to go. Okay? Yeah. Go ahead. Now, add that to your cauldron.
Yeah, no, that is something that is communicating a message, is literally interfering in the inside of the sanctity of the jury box itself, where the jurors are. Look, there are times that I've been like, it's really kind of amazing. You take 12 folks, you throw them in a room, and you don't give them any instructions, and you tell them, but the thought to that is that 12 12 citizens, jury of your peers, will know themselves how to go about, based on the case, their deliberations. And so that is the first time in over 30 years of my career that I've ever heard a judge say something like that. And I have to wonder, like, how much may that affect? You know, the judge is very powerful in a certain way with jurors. They look at both lawyers as advocates, and they understand they're advocates for one side or the other, but they look at the judge being more neutral, and the judge has a lot of power that way to influence them. So I just didn't like that. It's kind of nails on a chalkboard when I heard it.
Yeah, and to me too, when she said on Friday to them, I would not advise you take a straw vote. When we had just had Richard Gabriel on, so that's what some jurors do. They go in, the first thing they do is they take a straw vote to see where everybody is generally on their feeling about the case. That's one way they deal with it, especially jurors who want to get to the ultimate issues in the case. Another way is they have to go in and they have to take their time. But this jury was told not to be that kind of result-oriented jury, to go in and go through everything. And you know what happens, then you may end up cementing different views that people didn't really have or believe.
Yes.
Because they want to please the judge.
Or they want to please their fellow jurors.
Or they want to please. That's an interesting point. Talk to me about that dynamic in the jury room.
It's huge. It's huge. I mean, it's just like every social encounter we have, whether we go out to dinner or a bar or in our home and our families. There are people who are more persuasive and influential, and those who are more quiet and easily persuadable. Some who compromise easier than others. I mean, it's a human dynamic, and anything that you throw into it can affect and throw off its access. And so when the judge is, I think the reason why we have a rule in America where the judge does not interfere or instruct with the jury about how they go about doing it. They want their own personality, their own psychology, their own group collective thinking to be what drives an assessment of the facts as it relates to the law. So a judge saying something like that and forcing people to start speaking out, like, look at my wife. My wife's an innocent, gentle, decent human being. How I ever wound up with her is amazing, you know.
Yeah, it's true. And also Holly the beagle, Holly the legal beagle.
Yeah, I mean, her and the legal beagle, her spirit animal. But like Michel does not like confrontation. She will shy away from confrontation. She'll be more likely to agree with somebody to make the peace. There's not, and I admire that quality in her. Actually, it's very different from myself, dog and teeth in a bone,
right.
Kind of guy.
Not giving up,
but
right?
So when somebody in the jury is being told, don't do a straw vote, but now you're forcing people who otherwise may be more like my wife to be more influenced by what other people are saying. That's
a really great point. That's a fabulous point. I'm just going to tell Dizzy and Missy to mark that where Bob just said that as he's having his espresso, because that's an amazing point. Something that hopefully we can get Richard Gabriel and Michel Ward back on to, Dr. Michel Ward back on to speak about, because you're influencing the jury verdict by what you're telling them how to go about finding what their job. And that's their job, is to decide how they find the facts in their job. I never really thought about that. That is such a great point.
If you think about what a trial essentially is with regard to the professionals, everyone is trying to influence a person to their position. Everyone is trying to find that juror who they believe would be receptive to their side of the case. Everyone is trying to articulate and communicate in a way that is going to, on an emotive level, which is probably, in my opinion, more important than an intellectual level, but whatever, on an intellectual level, persuade them. And so, getting in, that's why, the judge is always telling them, don't be persuaded by outside opinions. Don't let anybody talk to you about the case. And then she went and did it.
And then the idea of helping, she's supposed to help them. So I don't see, obviously they're going to come back tomorrow morning. They're going to go home. I don't never buy the fact that jurors never talk to anybody. It may not be directly, it may not be you and I have this conversation, but your spouse is in the kitchen on the phone with somebody talking about a case or something like that, or they're reading the paper, or they're turning on the TV. You can't. The jurors have their phone. They can't not. They're going to go on. They're going to check their Twitter, and what are they going to see?
Yeah.
Siri is going to say she's heard the word Karen Reed 100 times. So the first thing that's going to pop up on their phone is Karen Reed.
I know, I remember when we used to like have to voir dire jurors because somebody walked past a newsstand and there was a headline in the paper about the case. And I'm thinking to myself, like, how do you don't even want to ask the question. Like, if I were a judge, the last question I'd want to ask a jury, have any of you seen anything about this case? It's just if it gets brought to my attention, I'm going to have to deal with it, but I'm certainly not going to ask about it.
And she asks about it twice a day. If you follow my admonition, I followed your admonition, Judge. You don't think this jury is now going to go back? They don't want to come back tomorrow. They want to come back. They didn't want to come back tomorrow. Now they're going to come back tomorrow. You're going to have a verdict. I think they were dressed up today. By the way, Bob. By the way, they were absolutely dressed up. Okay, at like 2 levels. Apparently, the women were really dressed up. The men, most of them, one or so, was dressed the same way. But that told me they thought they were going to have a verdict today. All right. Tomorrow, they're probably going to come in their casual thing because they're going to be ready to duke it out with who's ever holding up this verdict. They want out of there.
Wow, that's a really interesting observation. And I assume it's accurate because you said it, is that really shows you, in my mind, how much they're aware of the public spotlight of this case.
Right. I don't think you cannot be. Apparently, the crowd, we showed a little bit of the crowds out in front. Now, we are responsible for that because you know that Michael Bryant was one of the initial plaintiffs of the first 3 lawsuits to get that buffer zone undone to make it a First Amendment zone. So without that having been done, and without Michael Bryant having that courage to do that, you wouldn't have all those people out there who are able to congregate out there as long as they don't wear, this is the most stupidest thing, free Karen Reed shirts. Is if the jury's not supposed to see them at all, then what are we talking about, right? But you saw out the mobs out there.
I think that Michael Bryant cannot be trusted. It's just once again he's out there creating controversies. Now, I'll get aside. I mean, like, I think that we hope in a better and more pristine world, and I know this is Pollyannic and it's not the way it is, that they understand there's a lot of publicity in the case, but they're not affected by the publicity.
Okay,
and
I think that's right.
The point that I'm making is that if in fact they are dressing up because they anticipated there was going to be a verdict and that they are being affected by the publicity, even if it's just their clothes. It sounds like a subtle thing, but maybe it also influences their decision too. I don't know.
But I think, weren't we always looking for, is a jury dressed up today? That's one of the things in any high profile case you looked up to see, when they're coming in, walking inside, when you used to be able to see them walking into the back door, was the jury dressed up? That was the one thing that kind of told you that they thought, no matter what case, I think for the last 20 years or so. So I've
never heard that.
You never heard that before? Oh,
no.
Yeah. It was the first question. Maybe because I'm into clothes, so I know that they were there, and they were dressed up. Because I think jurors are very aware of the fact that they do media interviews. They've seen other cases on high-profile cases afterwards, or the government will set up a place for them to talk to the press about the decision if they want to.
Right.
Usually, when there's a not guilty, they don't want to. Usually, because they want to go home because they don't want that. Right. Because there is a lot of mobs, but here, I don't know if there's any mobs. I think that there's a lot of support for Karen Reed, but I don't think there's any mobs, but I think her supporters have shown for her, because one of the things that the underlying thing in this case is that the community thinks that there's a lot going wrong in Canton, that it's corrupt and all. And I think Karen Reed's the vehicle for that discontentment. She may not be the discontentment, but she's certainly the vehicle for it.
Well, I mean, first of all, we have one of your guests said something here about attorneys not understanding reasonable doubt. I'm not sure the context of Gracie girl, but look, reasonableness is in the eyes of the beholder. Okay, and reasonableness is, it's not lawyers don't understand the concept. It's words, and it's malleable, And there is no universal truth. Like, for example, in this particular case, as a prosecutor, I'm offended by the way this case was prosecuted or investigated, I should say.
Right.
And we talk about reasonable doubt or reasonableness. I, as a prosecutor, have not prosecuted cases because I have felt that the investigation was profoundly corrupted, maybe by an individual or a set of circumstances, that I wasn't sure that I can inherently rely on the evidence that I was required to present to a jury. And I think that that is what my ethical obligation as a prosecutor was. Now, there were times that I tried cases that were very difficult. The facts were not as strong as I would like. They're very circumstantial, say. But I was very convinced that the person did it. I would rather have a weak factual case with an integratable law enforcement community than have a strong factual case with an unintegratable law enforcement community. I mean, certain things that were not done here in this case, certain aspects of the investigation blow my mind away that you cannot tell me that people are that incompetent.
Well, I'll tell you what, you should have seen, if you get a chance, watch our interview. We did an exclusive interview with Mike Easter. He was the law enforcement expert that Judge Kenney would not let the defense call. A former FBI agent for 20 years, did all the big cases. He was extremely enlightening about how the investigation was basically obscene, okay? And he went through it with us. He talked about it. Give me three narratives. He said it was incomplete, inconsistent, and inaccurate. Okay, and then he went on. But if you get a chance, watch it with him. Mike Easter, he was the one that Judge Bev didn't allow to call, because you would really be offended as a prosecutor after you listen to him.
What happened with those text messages that were deleted? I mean, this is a huge problematic thing from a factual standpoint, and I don't know the answer to this, so I could be wrong. Were people investigated for this? Were people charged with destruction of evidence? Or, we talk about this in my practice all the time. It's like, we got a case right now where the cops did something wrong and it's just excused. But if an ordinary citizen did it, the full weight of the law would have fell upon them.
Well, that's what I said about Higgins, right? He knows that there's an order coming down, and he goes to the Army base where the order would have no jurisdiction, and takes out a SIM card of his phone and gets rid of his SIM card and destroys his phone. This is facts. And Brian Albert destroys his phone, gets a new carrier. I mean, if you and I did that with investigation coming on, the FBI would have us in the hoosegow.
Yeah, it is a double standard for sure. And that's why I think that there are times, and I'd be curious what your audience thinks, you may have to say as a prosecutor sometimes, and I understand that this is a big statement, and I understand there's a fatality that's involved in it, but there's also a defendant in due process, and it's not even Karen Reed. It's about the system itself and the corruptibility of the system itself. And every now and again, you need to spank, law enforcement and people with guns and badges and lots and lots and lots and uber powers that they have to say this sloppiness, or perhaps nefariousness, or perhaps incompetence will not stand, and I will not, as a prosecutor, go into a courtroom and justify it. Now, there are plenty of times in an investigation people make honest mistakes. I'm not talking about that. So I'm just saying.
No, we do as lawyers. We make honest mistakes, right? But I agree with you. I mean, honest mistakes and learning. Even like you said, when you're young, you make honest mistakes. We've had Stephen Plort on. He was an independent accident reconstructionist. We could watch. By the way, Michael Bryant's on as we're talking. We could watch Karen Reed leaving without audio. The courthouse, which we can talk then over. Missy, that would be great if you could run it. But he said that, by the way, he looked at this and said, there's no way there should be a guilty verdict. And he's an independent accident reconstructionist. This is some of the court TV footage I was just taking of people leaving. There's Hank Brennan.
And believe me, it was solemn, very solemn.
Was it solemn, Michael? Brian's back.
And the trooper Hardman came out ahead of time to tell everybody that nobody's making any statements. It was the O'Keefe family. They left. You saw Mr. Brennan as well. And then there is a pause of sorts. I've got all this stuff. I'll put it up on the line. I remember yesterday when I asked Karen Reed, how how she's doing. Are you hanging in there? And she gave me the thumbs up. Today, nothing. Just like nothing. So I think they're concerned. I don't know if they have reason to be. Obviously, nobody knows for sure what's going on. I would think on one level, as I'm sure you guys have been continuing to discuss, the first and third charges seem to be a done deal, you know, and if she's acquitted of those, the second charge sounds like it's a leaning toward the OUI separate count, but nobody knows that either. So I think it's a combination of uncertainty and stress building over time. You know, it just weighs on them, and you could see it.
Well, I think that I don't know anything other than if I were a betting man, the more time is going on, and the more, if there's, you know, the more it could inure to the benefit of the defense. You know, eventually somebody's going to wear out. Wherever they are, somebody's going to wear out. In my mind.
But what if the judge? What if they end up hanging on count 2, but the judge refuses to ask the jury if they reached a verdict on any count, and they have on the first count, and we end up in the same situation where we were at the first time?
There I am bugging her right there. Bugging her.
Yeah, I think the judge needs to get her law clerk and a couple of other people together, like Toot Sweet, to start doing some major research today about how to answer that correctly.
Yeah.
Michael Bryant, narrate. This is a sea of people here.
Oh, it is. Every day, it is worse and worse in terms of the media crush. There used to be a handful of us. I mean, there are like 3 of us. And now there are probably 30 different media types that are both camped at the bottom of the stairs and then peppered along that walkway from the stairs toward the SUVs. And I got to say that the state troopers have done a pretty good job of not breaking bad on some of these folks, because it starts to get a little out of control, a little bit sometimes dangerous. You know, people can get tripped up, fall into one another, and you know, it's like dominoes because everybody's packed in so tight. The crowd itself, very respected. I don't know if you can hear the choppers. There are at least 3 helicopters.
We turned the
overhead.
sound off so we could talk over it.
Well, I'm talking about right now over me.
Oh, over you? No. Okay.
Yeah, there's at least 3 helicopters circling. And by the way, it's now full on raining. It was just starting to sprinkle, and now it's full on raining. So
you know what we learned though? It may be raining, but you, Michael, are not washed up.
Hey, but you know, I have to just put on my merch. Just put on the merch hat, you know.
By the way, Linda, not me. That's not me. This is a Linda with the same beautiful name, though. I think the jurors are dug in. Bob, what are your thoughts?
Okay, it could be. It could be. I mean, that's a very realistic possibility here. I think a really realistic one could be some hung jury that gets back to that issue. Is the judge going to take some verdicts on some of the counts? But that's why I say I kind of agree with what Linda's saying. But if they're usually in those circumstances, it's easier if they're dug in to persuade a not guilty than it is to persuade a guilty, in my mind. But you know, who knows? I've been guessing for over 30 years.
What did you say? It's easier to persuade a not guilty than it is to persuade a guilty?
I think so. I think it's easier to persuade people to a not guilty verdict than it is to persuade them to a guilty verdict, because they understand the consequence of their decision.
Yeah, and I think that human nature, that's appropriate. I hope that's true, because I'd hate to be somebody that just gives in and says, convict her.
Yeah,
you know what I mean? If they really are torn on what was or wasn't proven, to cave in for a guilty is really not the way you want things to go in the system.
But I tell you what, you know, we always learn that to hold on to a hung, you have to really start out with a good 7-5 on your side, at least 5, because you're going to go down to 10-2. But if you start out with a hung with a not guilty of 10-2, you're going to lose that. So just so you, that's our viewpoint when we get from jury consultants.
Well, I never had to really deal with those kind of weird numbers.
Yeah, I know, because you get on guilty as a defense attorney.
They were 12. As a prosecutor, there's always 12 for guilty. Always 12, and crazy. Never reversed.
And never reversed. Yeah, I never was reversed either. Linda, again, exactly, Bob. Exactly. Thank you.
Bob, did you get enough compliments while I was gone? Were they peppered in there? You get enough?
I don't know. It's been kind of light. Kind of light. I love coming on this show. In fact, a major, not that this is not a major network, but a traditional network reached out, and I'm like, no, I'm busy right now.
I love that.
I love it too.
That is
Because
great.
this is, well, you know what? You get a lot more interaction with people and seeing what people think on the show. I mean, we're young, but we've grown pretty fast. We're already almost up to 16,000 subs, Bob.
Here you go,
That's
Bob.
pretty
Bob,
fast.
you're pleasant. You're so pleasant.
Oh, Kitty, I'm
not so sure I've ever heard that in
yeah, I'm not sure Bob and pleasant have been used in the same sentence.
How about
too
this
often.
one? How about this one?
Bob
Linda
is
says
great.
Bob
Yeah.
is great.
There you go.
How about that one, Bob? Like that?
Love it, love it. I'm coming here every day from now on. You guys have to have me on for just for the ego.
It's better than therapy, right? You know, and slightly cheaper.
The Rizzler.
You know, we can laugh. We can laugh because we get to go home. No matter how much we talk about, oh my God, I've been doing that on the air now for 7 hours and 17 minutes. I'm exhausted, and I still
You
have
were
to do my own
complaining
work.
about those 3-hour-long crime proceedings, right?
I know. I complain about that now. The 7 to 8 hours, like I'm exhausted, and then I have to do my own work after this. But you know, we think we're exhausted. Let me tell you, the defense attorneys and the family of John O'Keefe and defense attorneys in Kenney Reed, they're more than exhausted at this point.
I can't imagine. I really can't imagine. And the hammer hasn't dropped yet, you know? So
You know, it's I think that I'll tell you guys, so that's interesting you say. It's like I don't think it's hard to explain to people what it's like to be a trial lawyer. I can only imagine what it's like to be a rock star, right? And what I mean by that is you have so many like adrenaline running through you, and there's so many ups and downs and twists. You're exhausted, even though you may have 4 steps on your watch. You're mentally just completely wiped out. And I don't know if you guys have ever experienced this or heard this. How many of us, after a long trial, get sick?
Oh, I get sick during the trial.
She gets sick during. Yeah, but that's because your body's been fighting everything, and then all of a sudden, boom, your immunity disappears. Oh, yeah, it's almost expected.
You just
Linda points out that this is serious. That Kenney Reed is innocent, factually innocent, and it is serious on it. But yeah, no, you get sick, right? You even if you don't get sick during trial and you get sick after trial, I can't imagine what it's like being there. And this judge has had them there, Bob. It's not just the trial that started April 1st. She's had them there since like January. I can probably count the days in one hand that they weren't there at her courthouse trying to do some hearing, some motion, something that had to be filed. This hearing, this Dalbert, this, that. You know, it was unbelievable. I'd never seen anything like it. You know, and she had this thing that had to start April 1st, right? You know, so Bob, let's do this. Okay, here's somebody wanted me, but I'm going to throw it to you. Can you explain the second charge? I'm so confused. How can she be charged with just an OUI and not manslaughter? How does that work?
Yeah, you guys know the charges better than I do, honestly.
The defense asked for that last charge to be put in, apparently, because it involves no killing, no death at all. It's just a plain driving while drunk, we would say. And I think they wanted it because it gives the jury something for them, if they have a hung jury, to be able to go to and possibly compromise. And that's why. That's why it's in there. The prosecution didn't want it. The defense asked for it.
Now that's interesting because maybe each state is different on this. Like in New Jersey, this is a really like heady thing, but it's important. Irrespective of what the lawyers ask, if the judge should charge a lesser included offense, the judge is required to charge that lesser included offense.
Right.
And a lot of times with that, to the point, I think of this question maybe, is that if you leave murder or aggravated assault, and you have these two, my hands are being seen, like draconianly different sentences, life or up to 10 years maximum. If the judge should charge manslaughter, which is recklessness, and I say as a defense lawyer, no, I don't want that charge because I'm convinced they're not going to come forward with murder, and I want to drive them to the lesser charge. Many times that the New Jersey law is the judge is required to charge the lesser included because on the alternative, I know we're being heady here, the jury may be feeling forced to compel to convict of murder because they don't want to go down to the smaller charge of aggravated assault. So it's interesting that I think that I don't know, Linda, how you feel about
I was explaining that in Jersey, that's a requirement. In some states, it's not. All right. But Jersey is, if there's evidence there, the judge has to do it, whether the parties want it or not.
Yeah,
the judge has to do it, and people don't understand that. But that's in some states. If the parties don't agree to it, and even though it could be a lesser included, they don't have to. That so it really is.
Related question, right?
Yeah.
Why is the OUI not a standalone charge? Well, it kind of sort of is. It was never a charge, like in the indictment, there was never that charge, but the charge was added in the verdict slip by the request of the defense. So it does stand alone. And if obviously the jury's confused about that, that's why one of their questions was, if we find guilty on, for example, that charge, then how does it affect the rest of the manslaughter and lesser includeds? That's what the court tried to clarify. But it is technically a standalone charge.
Yeah. So, Bob, we have, it's going to be interesting. Stephen Plord is with us. He is our independent accident reconstructionist. You really have to meet him. He's really pretty terrific. We call him Crash Daddy Lord, Crash Daddy Plord, or Crash Lord, right? Crash Daddy Plord, or we go call him Crash Lord Plord. I think we settled on Crash Lord Plord. I think we settled on that. We had this decision whether Bob is just Bob beyond. Bob is Riz. Right,
he's the Rizzler.
You're the Rizzler. You're the Rizzler. You have an icon, the Rizzler. Crash Lord for 45 years dealing with this stuff. Very honest opinions. Told us exactly what exactly apparently the jury is feeling about the accident reconstructionist. And I don't know if you had a chance to look at Michael Easter's interview yesterday. We did. He is the FBI. Whoa, somebody likes that.
I think they're about to run into somebody. Sorry.
Expert. So let's bring him on. Let's do all four of us on. There you go. Look at that.
Stephen.
Good to see you guys. How you doing?
I only got a couple of minutes because I got to jet to
He's got to go do the competition.
Okay. Well, I did see Easter's interview yesterday, at least most of it, and very impressed, and
Hey, so Stephen, just to introduce you, Bob Bianchi, one of our former cohorts at Law and Crime, an amazing defense attorney, former prosecutor. He and Linda both starred in The Sopranos. I don't know if you remember them or not from the series. But if he has to disappear, I just want to make sure you guys had met.
Yeah. And before you go, Bob, okay, let me, because I know you have to go. Let me have you answer this question from Floyd. Thank you, Floyd, for that donation. If they come back hung on the defense, if they come back hung tomorrow, can defense ask to poll the jury to see where they are? Bob, I'm going to throw that to you as your final question before you have to leave us.
If they come back hung, can they poll the jury? Every state's going to be different, in my opinion, from a procedural standpoint. But I think the answer to that would be yes. They should have the opportunity to do that, and they should make sure that they're very strong. And I wouldn't be surprised if they come with a major memo to the court that the court should take the verdict or at least instruct the jury that if they have a verdict, that they are to report that verdict out. So, we'll see where that goes.
Can you get a report out on a hung? In other words, are they 7, 5, 10, 2? Are they hung on?
On the
2,
number?
3, 4, 5? Right.
Yeah. Not in our state. It would just be whether or not you can come to a verdict. You're not going to get to know the numbers, at least in New Jersey.
Okay. Will the judge get to know the numbers?
I have seen judges walk into the jury room and find out, even though they're not.
Yeah. So, Bob Bianchi, you have been fabulous. Bob Bianchi points out, by the way, Michael, when you were gone, that the mere fact that the judge told them to take their time, by the way, not a straw vote, take their time, is an influence on the jury, that she has infected the jury with that. She has erroneously telegraphed to the jury something I hadn't thought about. It was a fabulous point. He is a genius.
I do like that. I hadn't thought of that either.
I'm on the air.
All right, I'm going to Riz out of here, guys. Thanks for having me.
Bye, Rizzler.
Take care, man. Thanks.
You got it.
Nice meeting you, Bob.
Hey, Stephen. All right. So we're still waiting. Tomorrow looks like it'll be the day, tomorrow morning.
Are they gone home for the day?
Yeah, they're gone.
They're done.
They're done. They're done for the day.
I was just booking my room for the night. So I waited.
I did see the interview with Easter yesterday, which he's very impressive. Very impressive.
Yeah, wasn't he great?
He said some of the things I said, but he also looked at all the evidence. So there's more stuff that he saw that I didn't, but
Yeah, it was really interesting that he said that he has a whole list of the stuff that they asked to preserve that, you know, they never followed up on it. And I certainly love to see that list. Okay.
Sure.
Because they never told us about that. But yeah, no, he was very, very impressive. So anyhow, they're just, they appear to have a verdict on 1 and 3. That they set it out hypothetically. The judge won't answer what happens if they have a verdict on 1 and 3. She won't instruct them to report the verdict. We're kind of in a mess. All right, it's a mess.
I saw that. I was in a meeting on a big case I was working on, but I had the audio going in the background, so I heard a lot of it.
Yep. Yeah. So that's where we are. So maybe tomorrow we'll get to have you on to talk about the verdict. But today we have nothing. Michael Bryant.
Yeah, it's pouring. I got that for you. It is coming down. I think the weather's going to be better tomorrow. I hope. I hope that for the supporters because they've been troopers out there, and the weather has been cooperating up to now. They scattered as soon as it was learned nothing was happening. They scattered.
Now, apparently, Missy does have a still of you in the scrum. Do we have it that we can put it up? Or is that no? Michael Bryant went out there. There's a still. Where are you, Michael Bryant?
I'm not in that. I think further
down.
There
you are.
Oh yeah, that is me.
There you are.
Yeah,
That's you.
That's me saying. That's me saying. Karen, are you still hanging in there? Nothing. No thumbs up like yesterday. Just nothing. They are very.
I'd be worried too. I'd be worried too.
I think somebody asked Alan Jackson how he was doing, and he said, "How about this weather?" So there was one slightly lighter moment compared to earlier.
That's all he can say, I think.
No, they can't say a darn thing. I asked when the gag order was first initiated. I asked who he was wearing. I could get away with that.
The first day, who you're wearing? It was a funny.
Who are you wearing?
That's funny. That's funny.
That seems like a lifetime ago. And I ran into one of the shooters I think it's for Channel 5. And I said, "Hey, how you doing? I haven't seen you since the jury view," because we were both standing side by side out there on Fairview when the jury went and took a look. And he said, "Yeah, that seems like quite some time ago." Yeah, about 2 months ago, as a matter of fact.
Yeah, it was about 2 months.
Yeah.
Madeira Beach caregiver. Hi, Madeira Beach. Due to my distrust of bias, that's just Kenney. I would have requested to see her written response to the fourth juror's question. How do we know what she actually wrote?
That's a very good question.
That's a really good question, by the way.
Doesn't she have to disclose that at some point in time?
Well, she told them what she was going to tell them. And then I think even at the last minute, it was changed from having them come back in the courtroom and read it to them to just give them this note.
Right. And then supposedly the note eventually goes back gets marked as a court note and goes into an envelope. So,
but I don't, Madeira Beach, I'm with you. I don't trust most of what's happening behind the scenes here.
Yeah. Especially since when they came back and Alan Jackson asked, when they were asking about the videos to see what weight are they in evidence, what weight to give on them. And Alan Jackson said, well, the charge says what weight, if any. And she said, oh, yeah, I'll give that. And then when the Commonwealth said, we object, she said, I'm going to take that out, even though it's the charge.
Right.
Yeah. So there's a lot of distrust going on. So, Stephen, get your suit jacket ready for tomorrow. Dress up like a jury. Okay, because it looks like tomorrow morning we may have a verdict.
We're going to have something. We're going to have movement. That's for sure. It's either going to be either a verdict or it's going to be we're hung. They're going to get the charge and then
down charge, and they're going to want to go home, and she's going to give them. Well, what I think what Mike said earlier. Mike Del Signor said is that there's like a mini Allen charge that she can give actually before the actual Tui Rodriguez. There's a mini one that she can give.
I remember reading about that last time. Yeah.
And so that she may want to give the mini one so she has 2 bites at the apple, because if she gives the Tui, the real dynamite charge, she can't give it a second time. But if she gives the mini one, she apparently can give the real one after.
Right. I'll let you know that I have arrested people riding on bicycles and on a horse because
we were talking about that earlier, operating under the influence.
They're operating in their control of both the horse and the bike. And if you're under the influence, you can be arrested for it. And I've been there with both of them been arrested.
I love the horse. Operating a horse intoxicated. That's great.
What happens? Does the person get hauled away? And what do they do with the horse?
It's a DUI because
where's the horse go?
You know, it just depends. I don't remember what happened this time, but we might have released it to a family member or the ranch where the horse came from. But it was at 2:00 in the morning in El Centro, which is Southern California, where horses are horses. And
of course, a horse, of course. So.
I mean, it'd go to the Humane Society if it didn't wasn't able to be released to a family member or with the ranch where it came from.
Do you all remember the movie? And you can all look it up. The scene is famous. There's a movie called Cat Ballou, and there's a famous actor, Lee Marvin, who's on a horse, and he's supposedly a gunslinger, but he's drunk, and the horse is drunk too. And yeah, you have to look it up. Just Google it, Cat Ballou, Lee Marvin, drunk horse. The horse they put the horse in as drunk. I mean, the horse was obviously an actor,
Right.
and all. But it really is a funny scene. So when you said you arrested somebody for riding the horse, and Michael asked, "What happened to the horse?" Well, the horse. I would expect you to say, "Well, the horse is drunk too. We didn't send him to
No,
rehab."
the horse was put in a cell adjacent to the rider. Yeah.
Oh my goodness gracious!
No, I'm disappointed we don't have a verdict today, but it does sound like something's going to be close.
Yeah, we're making progress, and I think everybody is cautiously optimistic still. But they don't want a hung jury either. The supporters, they don't. Nobody wants a hung jury.
Well, they don't want to. They'd rather have
trial.
Yeah, but they'd rather have that than a guilty verdict.
Oh, sure. Well, unless it's guilty on OUI, and that's all.
Right.
I
If
think
it's OUI, I think it's a big win because from what I saw with the criminalist coming on the stand, 0.14 to 0.28 at the time of the incident, she's admitted driving, and if she's at 0.0, 0.14, 2.8, I mean, that's well over the limit.
Yeah, what do you think, Stephen, about that whole retrograde analysis? Because that's what it comes down to. You got to buy that.
Well, if she had a blood test at 9:00 in the morning, which was 9 hours before, and she was a 0.07, 0.08 or something like that, based upon body weight and metabolism extractions, 0.14 to 0.28, as long as she didn't drink in between that time, that's pretty fair because I'm doing all kinds of stuff and research in that regard. And there's new case law in California that came out that the retrograde analysis is subject to something if it's below a 0.08, so you can't use it. But in this case, it's Massachusetts, and she's a 0.09. It didn't seem like the defense refuted much of that. So
yeah, I think you're right about that. They challenged that it was a clinical blood draw, not a more specific, blood draw to check BAC. So they did challenge that, and then they challenged the lack of information about from 12 something to 7:30 when the draw took place that things could have happened.
Sure,
but you're right. They didn't really argue heavily against what was being presented. But again, the jury's got to buy that, and that's questionable. I think there's some holes.
Right. I think it'd be a win if she got convicted on that, and that's it.
Well, that's why the defense offered it up, I'm sure. Hey, look what Salem thinks. Salem thinks. We're getting off on a tangent here. Remember, you guys remember Mr. Ed? Remember?
Oh yeah.
Wilbur. Remember that?
Yeah.
Wilbur. That was the owner of Mr. Ed. For those who don't.
Yeah, those are my days. I watched Mr. Ed a lot.
Yeah, those were the innocent days, right?
Those are the innocent days, right?
Donna Reed show, Mr. Ed. I mean, yeah, all of those.
Yes.
Yeah. All right. That's kind of where we are for today. We should thank all of everything. Stephen, thanks for coming on. Get a good night's sleep. It could be an early morning for you. Okay.
I'll do that.
All right.
And and I want to thank all of our viewers for staying with us. If you have not seen that Michael Easter interview, which was our exclusive, please go back and take a look at it because it really was incredible. I wish the jurors could have heard him because I think that there would have been no issue. They would have been back immediately if they had heard him. And it's really sad that we can't bring all of the evidence before the court.
Exactly.
Yep. Don't hide anything.
Well,
Stephen,
the show is, even though I'm a little late, still there. But I'll be available tomorrow.
Great.
I have a little work, but nothing pressing where I can't come on if I need to.
All right. Thanks, Stephen, for coming on. I really appreciate it. All three of us rock it. All three of us rock it. Everyone says, yeah. Michael Bryant, tomorrow, 8:50, I guess, again, right? We'll go back.
Why not? Why not?
I hope it's over tomorrow. I have to tell you what, I need to get my roots done. Okay.
Well, you got to set those priorities.
This is what was in court on camera. I'm sorry. Okay. What was in court on camera? I'm sorry. I'm seeing this go past.
I don't
But
know. I've got
you.
the Just Another Smith note up. Whiskey for my men, beer for my horses. Toby Keith lyrics.
Yeah, and we're gonna come back tomorrow, and it's just unbelievable. We'll see what the jury looks like, but I feel they feel, and I think Bob made a great point. They feel that the more they have to keep talking, the more the judge is sending a message to them that she wants a guilty verdict. Okay, and that's really sad. That is really sad.
Yeah. So we'll see if she gives a direction to them in the morning. She'll give them. I'm sure they're going to go an hour or two before they decide. We haven't made any progress. Where else are we going to go?
I think it's gonna be, yeah, you're right.
Or overnight, whoever is the holdout, or 2 or 3 or 4 or whatever it may be, 6 and 6. I mean, we don't know. Give them a night to think about it, and maybe there will be some change in position.
Yeah, we'll see. We'll see, everyone. But our goal, and I'm sure the jury's goal, is to have a day off on Juneteenth Day. Is to have a day off.
Sam Poop, does Mass have the law that allows the judge to add on because of mitigating circumstances? Normally that would be aggravating circumstances, and that wouldn't apply in this situation if we're talking about, if we're talking about virtually all of the sentences that might be imposed for any guilty verdicts. There are guidelines, and they don't have, there's not an additional for aggravating circumstances like robbery, handgun, add on. It's not that scenario.
By the way, if you get a chance too, we're going to try to cut it tomorrow, but you can go back and rewind. Michael Del Signor, who is the maven in Massachusetts for all things OUI. He was fabulous talking about OUI and also talking about hung verdicts and jury charges and all. Go back and watch that. It really was something that probably no other channel has, just like the Michael Easter interview. Why is everyone named Michael?
Everybody's named Michael. Have you noticed that?
I noticed that.
It's a very common name. Very common. Yes. Of course, it means most like God. So it's a lot of pressure. But yeah.
I thought that was my hair the other day. Okay.
Most like God.
Well, somebody said that my hair was so high that it was like Texas closer to God.
Because you were closer to God. Okay, I got you. I'm catching up.
All right. Thank you all for hanging in with us. By the way, if you're here from X or Twitter, please go to the YouTube page, hit a subscribe, a like, share, and then notify. But hit that subscribe. It doesn't cost you anything. We're almost at 16,000. Boy, would we love to hit 20,000 before the end of the day tomorrow. I mean, that would be our goal. I have big goals here, just like I had big here the other day. I have big goals, okay? But please do that. We have a lot of hardworking people giving their time here on this channel for free. They're not getting paid. They're doing this volunteer work because they want to bring you what they think are some good analysis, good interviews with people that aren't interviewed, and some great coverage. Michael Bryant's been there 14 times, and I don't know if we count each day now in extra time, because this may be the longest. You're going to be registered to vote there if you stay any
never
longer.
done the double overnight. That is true.
Yeah. Going to be registered to vote. Let's hope tomorrow morning that the jury says we don't think that the state the Commonwealth has proven its case, and if they have, we'll go from there. But we're going to report it fairly, one way or another.
Yep. So Michael Bryant here. See you tomorrow. In the meantime, trying to do the right thing.
So in the Kenney Baden, 8:50 tomorrow morning.